Good morning. This is the Colorado Energy and Carbon Management Commission. This is day 3 of hearings this week. We are taking up docket 230400117. To begin, we will take a roll call.
Commissioner Ackerman.
Here.
Commissioner Cross.
Present.
Commissioner McGowan.
Here.
Commissioner Messner.
Here.
Commissioner Oath. Commissioner Ray. Commissioner Robbins.
Here.
Mr. Chair, you have 5 of 7 commissioners present.
Great. Well, let's roll it. Let's bring the attorneys for the KPK Financial Assurance Plan into the hearing. And I believe we also need to bring in the next witness on behalf of Frederick, Dr. Allward. All right, council, welcome. Good to see you again. Before we get started with Frederick's final presentation in the case in chief, do we have any procedural matters to discuss? Mr. Jacobs.
Yes, Mr. Chair. I do believe that we're getting tight on time, especially given the number of witnesses requiring some modicum of cross-examination by KPK, plus our rebuttal testimony. We have 2 witnesses we're intending to call in rebuttal, plus closing. I think an additional 40 minutes should suffice, and would respectfully request additional time as encouraged previously by the hearing officer, the hearings manager, and I believe also by you when we started the continued hearing 2 days ago.
Hearings manager Thomas, are you with us? Can you provide the commission with time allocations?
Sure. As of right now, staff has 29 minutes and 30 seconds remaining. KPK has 28 minutes and 17 seconds remaining. Frederick has 25 minutes and 50 seconds remaining, and Dacono has 33 minutes and 2 seconds remaining.
Mr. Boudreau, thoughts about time allocation requests?
Yes, Mr. Chair. I suspect staff may need a little extra time. We're going to call Mr. Duranlo as a rebuttal witness. We anticipate maybe having some cross for KPK's rebuttal witnesses. And then we have a closing that is currently clocking in at around 7.5 or 8 minutes. So I think we have about half an hour left. I suspect we'll need a little bit more than that, but maybe not too much more. My plan was to kind of ask for it if we need it, when we need it.
Mr. Sura?
Yeah, I guess I would join in the chorus here. Town of Frederick is going to finish its case in chief with Dr. Allward today. That will probably take all 25 minutes that we have remaining. Would like to continue to participate in this, and so would request an additional 15 to 20 minutes for rebuttal and for closing.
Mr. Lewis Prescott?
Thank you, Mr. Chair. I'm of the general mind that seems to be the majority here, that a little more time for the parties is probably going to make sense. Dacono's at 33 minutes. I could probably get through my case in chief and closing in that time. Another 10 minutes for cross would be appreciated.
All right, I would like to get through this hearing today. We're set between now and 2 o'clock. Let's grant KPK 30 minutes, staff 20 minutes, Frederick 20 minutes, and Dacono 10 minutes. Elias, if you could add that to the account for each of the parties, and then we'll see where we're at with those allocations at this point. Anything further procedurally, Commissioner Cross?
Thank you, Mr. Chair. I was actually hoping to identify a document or an exhibit that was referenced yesterday, Mr. Sura, during your first witness's testimony. there was an email from Craig Meese that was referenced, and I believe it was listed on your slide deck as Exhibit K2 as an email, but Exhibit K2 is actually a Form 27, and so I was wondering if the right exhibit could be identified for that.
Could I check into that after we get through our case, and I could come back to you with that information or send that to you?
Absolutely. Yeah. I just wanted to make sure as I was looking through everything that I was looking at the right information.
No, I appreciate that, and I'll look into it.
Thank you.
Thank you.
All right, anything further procedurally from any of the lawyers? Mr. Sura, your witness.
Thank you. Call Rich Alward, who is going to share his screen. Rich, I can't hear you. You're muted.
Yep. I just figured that out, so I am working on sharing my screen here. Do we have the first slide there?
Yeah, that looks good.
Is that it?
That
Okay.
looks great. Thank you. Can you please state your name and position?
My name is Richard Alward. I'm the owner and senior ecologist for Arid Lands LLC.
What is your experience in reclamation?
I have a couple decades of experience in reclamation and restoration ecology, particularly on the monitoring and statistical methods for assessing successful reclamation and evaluating techniques to improve reclamation success and scientific research into reclamation approaches.
Could you advance to the next slide?
I certainly can.
And I understand that you served on the Colorado and Gas Conservation Commission. How long did you serve?
So I served on the commission for a total of 9 years, specifically to bring reclamation expertise to a newly constituted commission.
Appreciate your service there. I understand that you prepared Frederick's Exhibit T. Is that true?
That is correct. I did.
Could you please explain how you prepared Exhibit T and explain your findings?
I will do that. I will explain during my testimony, I will explain how I did it, what information sources I used during the process, as well as the significance of the results. Initially, I'd like to provide a few comments to emphasize the need for reclamation and the regulations around financial assurance. So, construction of well pads, tank batteries, and access roads results in the destruction of complex, heterogeneous, and biodiverse ecosystems that existed on the undisturbed locations. ECMC requires reclamation and has set performance standards that operators must meet. ECMC has expert staff to provide guidance. Operators may choose to pay a standard single well financial assurance or provide demonstrated costs. The proponent has provided insufficient documentation of reclamation costs. Based on my analysis of the KPK locations, I conclude that reclamation for the exemplar wells provided by KPK would likely cost over $100,000 each. An average reclamation cost for the KPK locations within Frederick, including tank batteries, access roads, and flow lines, will be over $55,000 per well. Given the catastrophic simplification resulting from construction, reclamation is vitally important. But don't just take my word for it. These next slides are from a workshop conducted by the highly qualified expert staff of the ECMC. The full informative presentation is included in Exhibit R. Reclamation failure is harmful to wildlife, agriculture, people, and our communities. Failure results in erosion, soil loss, siltation of waterways, reduced crop and livestock yields, and proliferation of weeds, among many other negative impacts, including the compacted soils that are an inevitable consequence of every well pad, every tank battery, and every access road. Successful reclamation requires specialists and specialized equipment. For example, to apply seed mixtures and finish the surface to hold the soil, seeds, and seedlings until the perennial plants dominate on non-crop plant sites. If the operator fails at reclamation, then the rest of us, indeed all Coloradans, bear the costs. I want to bring your attention to what I consider some of the key language in the reclamation rules that were developed partly as a result of the 2008 rulemaking that I participated in. I want to point out the imagery that will accompany these next few slides depict KPK locations, access roads, and flow lines in square mile sections within the town of Frederick. I'll quickly highlight critical language from the relevant rules. I know this has been presented prior to this, so I will try not to be repetitive. Rule 1004A explicitly requires all access roads to be removed and reclaimed, and that certain standards must be met in alleviating soil compaction and appropriate revegetation. And Rule 1004C specifies some of the performance standards that must be met for both lands that support crops and for non-crop lands. These standards are substantive and typically require 2 or more years on cropland to ensure the standards are met. And in the case of open space or other wildlife habitat, successfully meeting reclamation standards may require multiple years of reseeding, weed control, and monitoring. When identifying the appropriate financial assurance plans, operators may choose a standard financial assurance rate as provided in Rule 702(4)B, or an operator may propose to calculate an alternative single well financial assurance based on their demonstrated costs for reclamation. The statement of basis and purpose from the financial assurance rulemaking provides guidance to operators for the information needs to adequately demonstrate reclamation costs. The guidance begins with the admonition that all relevant costs need to be included in the proposal, along with information about the initial and total disturbance area for all associated facilities, the nature of the soils to be reclaimed, noting if they are sandy, whether the restoration of high priority wildlife habitat will be necessary, and whether the operator has separated the various soil horizons and stored them properly, and that there's a sufficient topsoil available to create a suitable seed bed and growth medium. Instead of providing the relevant costs and information to demonstrate reclamation costs, this proposal provides incomplete information for fewer than 2% of the wells. And what should be of particular concern is that of the 18 categories of exemplar wells, they have no relevance to the information needs necessary to demonstrate reclamation costs. The categories are not based on total disturbance area, or on soil texture, or on wildlife habitat, or on topsoil availability, nor whether the location is on cropland or non-cropland. Because of the absence of this information, the Commission should find this financial assurance plan proposal to be insufficient. I will provide a couple of examples to look more closely at the reclamation cost information provided for the exemplar wells, beginning with the David Howard B2 well and battery. This well was incorrectly identified in the KPK supplementation as the B5 well. The upper part of the cost demonstration appears to reference well reclamation costs. However, the only information provided about reclamation costs at the well location is within this other services line. They propose 1 unit of other services, which includes cutting and capping the well and reseeding, all for a grand total of $300. This lower part of the cost demonstration appears to reference reclamation costs for the tank battery. This time seed gets its own line, and it is at least presented as a per acre value. There's mention of some heavy equipment that might be dedicated to soil and seedbed preparation, but there's no accounting for costs of topsoil, mulch, weed control, or monitoring for successful reclamation. The only other information relevant to reclamation costs of the B2 location is provided on the map. Crude sketches provide an estimate for the area to be reclaimed, but no other relevant and required information is provided. I located the well and facility on Google Earth and found that KPK underestimated the area actually requiring reclamation. The well pad was underestimated by 50%. Their red cyan polygon, or their red polygon versus my cyan polygon. As was the tank battery. Again, their red versus my orange. Furthermore, the KPK proposal does not include the area of the access roads, yellow lines here, even though Rule 1004 requires their removal and reclamation. The proposal does not include any plan for the fate of the flow line in magenta here. Thus, the total disturbance area that requires reclamation is 3 times what KPK has reported. This proposal also does not reveal that the soils at this location have been classified by the NRCS as sandy plains, and thus the soils potentially have a high sand content. And it also does not indicate what the intended land use is for this location. The second example of an exemplar well is also problematic. The proposal suggests the total disturbance for the well pad working area and its battery total just half an acre combined. As with all exemplar wells, no other information relevant to reclamation is provided. My calculation of the total disturbance is 4.23 acres. Let me walk you through why I am confident that my estimate is more accurate than the one provided by the operator. I identified the well location on Google Earth and found that the 2016 imagery matched that provided by the operator. This well was constructed in 2006, so I was able to find the pre-disturbance conditions of the site using this 2005 aerial. Note the absence of any well pad, access roads, or flow lines. I then advanced to 2006 to be able to observe the full initial area of disturbance during the creation of the well pad in cyan here and access roads. This is important information because the financial assurance statement of basis and purpose directs operators to provide the initial and total disturbance. This is how I arrived at a well pad disturbance of 2.5 acres and 1.5 acres of access roads here in yellow. I've assumed the flow line's immediately adjacent to the access road, but if this is not true, the total disturbance area could increase. This location is on non-cropland, and unfortunately, I do not have any information about the fate of the topsoil removed from these locations. In this manner, I calculated the aerial extent of disturbance for 7 or 39% of the exemplar wells and found that the total disturbance measures provided in the proposal are grossly underestimated. On average, the actual total disturbance is nearly 3 times larger than what is provided in the proposal. So the average area of disturbance was nearly 2.1 acres. I assumed flow line reclamation disturbances would be minimal, which results in an average 1.8 acre disturbance for these exemplar wells. Again, I chose to be very conservative in estimating costs, so I adopted the ECMC staff experience with the Orphan Well program of $32,589 per acre in 2020 costs. We then allow that KPK may have some topsoil stockpile to partially build a good seed bed. But an average of 1.5 acres of topsoil will still need to be imported using staff's experience for costs of $48,000 per acre in 2020. The result is a quite conservative estimate of reclamation cost of $104,000 per well. Recall, this estimate is for the exemplar wells handpicked by KPK for their single well financial assurance plan. This is an appropriate and well-justified amount for determining an appropriate value for single well financial assurance. I would like to shift the focus now to wells and facilities within Frederick, none of which were included among the exemplar wells. I reviewed scout cards for all 108 wells I could find within Frederick. I traced flow lines, I tracked down tank batteries associated with the wells, I obtained soil reports from NRCS, and I calculated the disturbance areas using historical imagery on Google Earth. I scanned through the many years of aerial imagery on Google Earth to attempt to best characterize the initial and total area of disturbance, and then hand digitized the areas of disturbance. I assumed access roads met CDOT standards for rural resource recovery with a disturbance width of 20 feet, and that flow line installation disturbance was never more than 8 feet. On the maps I created, well locations are in cyan, tank batteries in orange, access roads in yellow, flow lines in magenta. Where it was reasonable to assume that a flow line was likely installed immediately beneath or immediately adjacent to an access road, I did not include any additional disturbance for their installation. A custom NRCS soils report can be generated for individual locations, for an entire town, whatever is of interest. I requested one for Frederick and received the 100-page report in a matter of seconds. The link to the NRCS Web Soil Survey are available directly through COGIS on the ECMC website. This access provides information about soil classification, texture, topsoil depth, agricultural uses, and dominant native plant species. One thing I learned is that 56% of the soils in Frederick are loamy sands or sandy loams, soil types that are recognized as potentially more difficult to reclaim. The USDA soil texture triangle is useful to help anticipate how particular types of soils may behave. Over half the soils in Frederick are found in this small portion of the soil triangle. Not all sandy loams are going to be problems, especially those closer to the 50% sand area. But soils that are greater than 70% sand and less than 20% clay may behave more like a sandy soil than a loamy soil. ECMC should assume that all locations within these sandier soil types are problematic unless the operator provides evidence, for example, the results of soil tests, to demonstrate lower sand composition. Some of these sandier soils have extensive topsoils that will need to be replaced. For example, this only loamy sand that I located has up to 10 inches of topsoil. All of the data from all of these well locations were assembled into Table 1 that can be found in Exhibit T. This includes the total area of disturbance, which ranged in size from 1/10 of an acre to nearly 2 acres. So not all the well pads are small. Typical topsoil depths range from a low of 5 inches to a maximum of 12 inches. 60% of the locations were in ecological sites characterized by the NRCS as sandy plains. Total expected reclamation costs were based on the findings that ECMC staff presented on May 5th, 2021, based on their experience with the reclamation of orphan wells described in the presentation included in Exhibit O. Thus, a standard reclamation cost of $32,589 per acre was applied to each of the wells. Staff found the reclamation of sandy locations were a bit more expensive by $3,600 per acre. ECMC staff concluded that insufficient topsoil led to a high risk of reclamation failure, for example, failing to achieve a desirable plant cover of 80%. Thus, their reclamation costs account for the need to construct an adequate growth medium and supplement 6 inches of topsoil where it was missing at a rate of $48,000 per acre. I adopted the same standard in my calculations and limited the supplemental topsoil quantity to 6 inches per acre, even when NRCS soil descriptions indicated topsoils may be as great as 10 to 12 inches. Additionally, I assumed flow lines would not need any additional topsoil, so the area of flow lines was subtracted from the total disturbance area before calculating topsoil requirements. Topsoil costs vary greatly and range from over $8,500 on the smallest locations to over $130,000 for the larger locations. From the 108 wells included in the analysis, the average disturbance area is approximately 2/3 of an acre, and the average reclamation cost is over $45,000. All the same data was collected from the 16 tank batteries associated with these 108 wells and assembled into Table 2, which can also be found in Exhibit T. The average size of the tank batteries is 0.79 acres, and the average cost for reclamation is over $65,000. Let me walk you through a summary for the single well financial assurance for wells in Frederick. I calculated, as I showed earlier, the average per well location reclamation costs are over $45,000, times the 108 wells in Frederick provides total financial assurance necessary of nearly $5 million. I calculated the average tank battery reclamation cost at over $65,000, times the number of tank batteries, which I estimate to be 16. I'm not certain that I've identified all the batteries since there's been considerable change over the last few years and the COGIS data doesn't seem to have kept up. This provides a total financial assurance of $1 million for these batteries. Total reclamation costs for all disturbed lands, wells, batteries, access roads, and flow lines is nearly $6 million. Divided by the 108 wells arrives at a single well financial assurance of over $55,000 just for the reclamation costs, just for the wells within Frederick, and without adjusting for inflation since 2020. So the current reclamation regulations before you exist because the commissions considered them necessary. They are necessary rules because reclamation failure leads to very real and expensive harm. In order to uphold the mission of the ECMC, it is critical that these regulations are enforced. One action you can take to ensure all operators adhere to these regulations is by enforcing an adequate financial assurance to motivate timely and successful reclamation. The financial assurance plan before you is insufficient. It fails to provide the required information for the commission to determine whether the operator has accounted for all the relevant costs that are required for successful reclamation. The information deficit of this proposal is alarming, and I hope it's not typical for what operators submit to ECMC. I have provided a more thorough, transparent analysis of expected costs, and I found that even for the 18 locations chosen for their exemplariness, the reclamation costs are likely to exceed $100,000 per well. I also found that the cost to reclaim the typically smaller locations with Frederick will likely exceed $55,000 per well. Financial assurance levels should be set at an amount that reflects these reasonable and conservatively estimated reclamation costs. I would suggest you use these values for calculating single well financial assurance until and unless KPK provides total reclamation costs that accounts for accurate estimates of total disturbance, including relevant access roads and flow lines. Thank you very much.
Thank you, Rich. Quick question. How many hours did it take you to prepare Exhibit T?
It certainly took me more than 24 hours, and probably closer to 30.
And how long do you believe it might have taken KPK to review all 1,000 wells in this application?
I would expect that they could do it much more quickly than I could. I would expect they could do it much more quickly than me. They already have all these locations within their GIS database. They would know what agreements are available.
Did I get a ruling on my objection?
I didn't hear it. I'm sorry if I talked.
I'm sorry.
I did not hear an objection.
I objected to the question regarding how long it may have taken KPK to prepare its exhibit and its estimate of reclamation expense, and I objected on the grounds that the question calls for speculation.
I tend to agree. Mr. Surrey, do you have anything further on that? Do you want to move on then?
Yeah, Mr. Elward, is there any information that KPK would have that would make it easier for them to prepare this type of exhibit?
I would assume that KPK already has all the data about the locations, the areas of the well locations and access roads and flow lines that they are responsible for within their GIS database, and that they probably employ skilled GIS professionals who could do this work much more rapidly than I could.
Would any of the locations in Frederick or anywhere else for that matter be able to be reclaimed without topsoil?
It would be extremely difficult. Topsoil has organic matter that helps increase absorption and retention of moisture and includes nutrients and improves the growth of plants. It would be extremely difficult to achieve the 80% cover of desirable plant species without an appropriate topsoil. In my experience in Western Colorado, I found old well pads that were not properly reclaimed that had still not achieved a desirable vegetation cover or recovered soil characteristics for 50 years since they had been abandoned.
That's the last question. Thank you.
Thank you, Dr. Allward. At this time, I believe you are, Mr. Jacobs has an opportunity for cross-examination.
Thank you, Mr. Chair. Good morning, Mr. Allward. Appreciate your being able to testify. Long time no see.
Yes.
I'd like to actually go to well, I can work on this slide. Actually, it's still being shared. This picture you've used here, that's not a KPK location, is it?
No, it is not.
And it's probably on the western slope, in fact, isn't it?
It is.
Okay, and that was on the title and I think the third slide of your presentation as well.
It was certainly on the title slide, yes.
Yeah.
Yes, and you're right.
Thank you. You did not prepare a narrative written report per se, did you? I haven't found one in the exhibits.
No, I did not.
Okay, so it's really these slides and your exhibit T for the town of Frederick that you were talking about preparing in about 30 hours time. Is that correct?
That is correct.
Okay. To go to well, actually, you talked about how a complex ecosystem is disturbed by surface use for oil and gas development, and it needs to be reclaimed. I believe that's some of the terminology you use, correct?
Very close, yes.
Thank you. Would it also be true that surface development for residential homes or commercial property would disturb that complex ecosystem?
Certainly.
Okay, and you're aware from the prior testimony of other witnesses for the town of Frederick that they have development plans for areas, including those with existing KPK and other operator wells. You heard that testimony, correct?
I heard the testimony. I'm not sure it's relevant to what ECMC's authority is.
You also, let's see. Calculated acreages for tank batteries, I believe, and those were in orange or cyan, I think you called it, color on your diagrams, your aerial diagrams.
Yes.
And are you aware that tank batteries serve multiple wells typically?
Of course I am, yes.
And so the tank battery acreage would need to be divided by the number of wells that are served by the tank battery in order to calculate a per well reclamation cost. Isn't that correct?
That's exactly what's in Table T or Exhibit T. Oh, you are correct.
Do you have any invoices to support some of the numbers that you've used in your testimony? I think you've talked about topsoil costs ranging, and you mentioned an $8,500 cubic yard figure, I think, or maybe it was a different unit of volume. I didn't see any exhibits on the costs that you've used.
As I said in my testimony, I was using the costs derived by ECMC with their experience with the Orphan Well program.
Okay, thank you. You showed a slide of the Murphy 11.5 well. I think it was slide 13 of your presentation.
Did you want me to move to that slide?
Yeah, if you don't mind, that'd be great. I think that would be clearer for everyone.
Oops. Yes, this one is.
Yeah, that's not in Frederick, is it?
No, it's not. These are part of the exemplar wells
Right.
that I began discussing.
And that's in Arapahoe County, is it not?
I believe you're right. Yes. I think that's what it says underneath near Aurora, Colorado.
Thank you. You did not exclude from any of your calculations the sites that are likely to be developed by land developers in the town of Frederick. You're assuming full reclamation over years to reseed and put topsoil in, are you not?
I do not have access to any of that information, so I had to go with what the rules require for an operator to reclaim.
But you did hear the testimony of the town of Frederick regarding its development plans and concerns about economic development.
And exactly, and open space and other sorts of habitats were part of their plans.
Great, thank you. And you also did not account for any return of to be reclaimed locations, KPK location, locations that might be returned to agricultural use. You assumed full reclamation to pre-oil and gas conditions, correct?
I don't know what the planned use for properties are. I can estimate what it would be from aerial imagery, what their current use is.
Lastly, actually, can we go back to slide? No, I'm sorry. One last question, I guess. You heard the
Yes.
testimony of Deputy Director Cuthbertson at the August hearing, did you not?
I did.
And
I
you
hope you'll refresh my memory.
Well, he had a rather quotable quote. He said that anyone who asserted that locations in Weld County like KPKs that are small and not on large pads costing $100,000 to reclaim couldn't pass the red face test. Now I'm paraphrasing, but I'd be happy to provide a transcription of his quote. We do have a transcript, and I'm happy to share that. I take it you don't agree with that statement of the deputy director.
I don't take any issue with what the deputy director said. I think in my calculations and what's in Exhibit T, I showed that the smaller locations within Frederick would cost about $8,500 to reclaim, whereas the larger locations could be up to $130,000.
Very good. Thank you. I have no further questions for this witness on cross. Reserve recross if necessary.
Mr. Boudreau,
Staff has no questions for Mr. Aldward. Thank you, Mr. Chair.
Mr. Lewis Prescott,
No questions from Dacono. Thank you.
commissioners, questions for this witness? Commissioner Cross?
Thank you, Mr. Chair, and thank you for your testimony today. I wanted to go over it, and now I'm gonna find the slide as well. One of the things that you talked about was I think it was the slide that had the $45,000 for the, yes, so the slide 21 of what you it talked about $45,475.39 expected reclamation costs. And that was based off of the 0.67 acres. And the first thing that I wanted to confirm is that 0.67 acres based off of the size that you were looking at, or the size of the acreage that KPK was initially saying?
I'm sorry, I was looking for that to bring that slide up. You said it was slide 21?
Well, and actually, as I'm looking at it, it has 21, 22, 21. So I think it might be past that. I think this it will be. I think
Is this what you're looking at?
That's the slide. Yes.
Okay, sorry.
So
Okay,
at the beginning of your testimony, you talked about some disputes about the size of the acreage that was listed by KPK. And I was curious here, as you talk about the area measurements, is this 0.67 acres what you believe the size to be, or is this based off of what KPK has?
So this is what I calculated as the average size within the town of Frederick, not among their exemplar wells, which I considered that they had gross underestimates. KPK did not provide any information about well locations within the town of Frederick.
Okay, so for clarification purposes, all the disputes about the actual size, that's actually looking at just the exemplar, and then this is your assessment, the numbers you looked at based off of just the Frederick wells.
Correct. I'm not aware of any dispute since KPK provided nothing.
Perfect. And then in the exhibit T there, you have the expected reclamation costs, and you have it at $32,589 an acre. That's, and I just want to clarify, that's absent any kind of topsoil addition. In a normal situation, that's what the reclamation would be, is $32,589 an acre. That's in the far right columns there.
So I'm not
So
seeing.
under the column at the far right area, it says expected reclamation costs, and it has typical $32,589 an acre. Then you add in the sandy soils and then the replacement.
Right. So the $32,000 per acre is the average that ECMC staff had experienced during the orphan well program. So I'm borrowing their numbers as numbers that are based on actual expenses.
And so after you add in the sandy soils and the replacement topsoil, that 45, that matches, is that where you're getting the 45 in the other one?
Correct.
Okay. And given that that's an acre, part of my confusion is you talked about the 0.67. So is that the 45,000 per acre, or is that the 45,000 per site?
So that's a good question to help. Thank you for letting me clarify this. So that 45,000 is actually for a 2/3 of an acre location.
Okay.
Because the typical costs, the 32,000 were then multiplied by the size of the disturbance.
Okay. Perfect. That is helpful in understanding. I just wanted to
I'm
make
sorry
sure
if I
that
wasn't clear.
No, as I was going through, I was just trying to, because I was looking at some that said per acre, and I just wanted to make sure that I was understanding that correctly. I think that's my only questions for now. Thank you.
Commissioner Messmer.
Thank you, Mr. Chair. Thank you, Commissioner Allward, for being here today. Once a commissioner, always a commissioner. But I did have just a couple of questions around topsoil, and in your experience, can you reclaim a site without topsoil?
We would really have to talk about definitions for reclamation to, because in some cases reclamation just refers to recontouring a landscape and doesn't talk at all about revegetation. If you want to achieve something like what's in the ECMC rules of 80% cover of desirable vegetation or recovery of agricultural production equivalent to the surrounding area, you need topsoil.
Okay. So essentially, if you want things to grow on there, you need topsoil.
If you want desirable plants to grow.
Right. And in your experience on rangeland, and rangeland I'm defining as areas where cattle graze in order to gain weight. Those type of grasses that are associated with rangeland need topsoil in order to be able to grow, do they not?
They do, yes.
Okay. Thank you. Those are the only questions I have.
Other questions from commissioners? Redirect, Mr. Sura.
No need for redirect. Thank you.
Very good. Dr. Allward, thank you for your testimony. Good to see you again.
Certainly great to see all of you again, and thank you for this opportunity.
Mr. Sura, your next witness.
So that is the last witness that we have. I move to accept all exhibits from the town of Frederick from A to T, accepting H, J, and L, which were voluntarily removed.
Chair,
Mr. Jacobs?
just a question for Mr. Sura. Is he asking Mr. Allward, Dr. Allward, excuse me, to be recognized as an expert?
I have not.
Okay. Good, then I have nothing further. Let's see. No objections, thank you.
All right, the referenced exhibits are entered into the record. Mr. Lewis Prescott, I believe you are next.
Thank you, Mr. Chair. I will ask that we elevate Ms. Jen Krieger and Mr. John Oburn.
Mr. Chair, may I proceed with swearing in?
Yeah, as soon as the witnesses are with us.
I see Mr. Oburn. Ms. Krieger, would you turn on your video, please, so we could swear you in? Great, thank you. I'm going to ask each of you to raise your hand, state your name, and say that you swear to tell the truth. I will start with Ms. Krieger. Please go ahead.
My name is Jennifer Krieger, and I swear to tell the truth.
Thank you, Mr. Oburn.
My name is John L. Oburn Jr., and I swear to tell the truth.
Thank you both.
Your witnesses,
you.
Mr.
And-
Lewis Prescott.
Thank you. On behalf of Dacono, we'll start our case in chief. I will share my screen, which will entail our presentation. And I assume you can see the presentation right now.
Yes.
Yes.
Thank you. First calling Ms. Jennifer Krieger. Ms. Krieger, good morning. Thank you for being here. Can you tell us about your background and position with the city of Dacono?
Sure. I am currently serving as the interim city manager for the city of Dacono. I have worked for the city of Dacono for 16 years. My background is in urban planning, and I also serve as the city's LGD.
Thank you. And are you familiar with the map that you see on the screen?
Yes.
And can you tell us what the blue box is trying to encompass?
Sure. That is the city of Dacono, our planning area boundary.
Thank you. And can you tell us about the purple lines that are going up and down?
Sure. The purple lines represent horizontal wells.
And who operates those generally?
In the city of Dacono, they're largely Kerr-McGee. I think there's some Crestone lines.
And do those operators also operate vertical wells in Dacono?
A few. Over the last few years, Kerr-McGee has certainly plugged and abandoned quite a few facilities.
And then we see a bunch of other vertical wells that are identified as either shut in or producing. Who generally is operating those wells in Dacono?
In the city of Dacono, those are largely operated by KP Kaufman.
And have you been listening to Frederick's presentation?
I have.
Where's Frederick relative to Dacono?
Frederick is located just north of the city of Dacono on the other side of State Highway 52.
And hearing the issues and concerns identified by Frederick, does Dacono experience the same or similar issues with KPK wells?
Yes, we do.
And can you tell us why Dacono is participating in this this hearing?
Sure. Our interest is largely health and safety issues, and we want to make sure that there is adequate financial assurance to provide protection to our residents.
And let's turn to KP Kaufman and the city's experiences with KP Kaufman. Can you speak to that generally?
Sure. Our experience has largely been with spills in the city. We've had, experienced a lot of lack of notice. We have incurred costs associated with some issues in the city. And, also at times what we feel has been a lack of cooperation and accountability.
And let's go back to the lack of notice. Can you talk about that lack of notice with regard to spills?
Correct. We've had a couple of situations. In one case, we weren't notified for 2 years about a spill in the city.
And are these spills that KBK knows about but fails to tell the city that they exist or have occurred?
Correct. We again received notice, 2 years after a spill.
And have you had any issues with regard to testing related to KPK wells to determine if a spill was associated with a KPK well?
We did. We had an unusual odor incident in January of this year, whereby a water vault had combustible gas, and a technician was in the vault. His meter went off, or his alarm went off. We also received complaints of an unusual odor from residents, and we had to issue a bottled water notice for the neighborhood as we tried to determine where this odor and where these elevated levels of combustible gas were coming from. The city did hire its own consultant to try and get to the root cause. We were able to obtain samples from around the meter vault. We were able to determine that it was a wet gas that is frequently associated with a produced gas. Knowing that KPK had surrounding facilities, we did ask for their cooperation to assist with some sampling, and they did not want to cooperate with the city. It's concerning to us because we obviously want to get to the root cause. And we want to make sure that we keep our residents safe, and that if there is an issue associated with a nearby facility or flow line, that we're able to address it so that these types of incidents don't continue to occur.
And has Dacono attempted to work with KBK to get some of these issue wells plugged, whether associated with a spill or otherwise, but to just get some of these wells plugged in Dacono?
We did have a conferral in May of this year.
And how did KBK respond in the conferral?
I believe the response was $250,000 to plug and abandon facilities in the city.
Okay, and that was per well?
Per well, yes.
Okay, and did they provide a basis for that amount, or was it simply that amount? That's the cost to plug a well?
I believe it was just the amount.
Okay, and with your experience of KPK wells and facilities in Dacono, have you ever noticed topsoil being stored on site?
Not to my knowledge.
And has Dacono filed any complaints with the EMC in the past year?
The city did file complaints back in May of this year.
Does this summarize the complaints filed in May?
Yes.
And do you know what the status of these complaints are?
Most of them remain open. One has become a notice of an alleged violation. And many of these have had open issues. I think there are a couple of them that are closing in on 1,000 days.
And do these pertain to spills or other issues? What do these complaints pertain to?
Sure, it's a combination of spills, releases, open excavation. There's quite a variety.
Does this encompass all of the spills at KPK facilities in Dacono?
No, it doesn't. We selected a handful that we felt were, potentially impacting the community. But certainly, there are additional outstanding issues in the city.
And have you reviewed any information from the ECMC or otherwise related to open spills in the city recently?
Yes, we have recently. We did notice that several of the sites have had re-inspections or had inspections, I should say, since those complaints were filed. Recapping, there's forms that have been denied, notes about visibly impacted soils, work without an approved work plan, not following BMPs for stormwater runoff. Those types of issues are reoccurring themes, inability to get to root cause.
Have you found any information related to the issue wells in Dacono indicating that a remediation has been closed or completed?
Not to my knowledge.
Okay, and then let's talk about the proximity of KPK wells in Dacono to existing or planned development. Is that an issue that Dacono has seen?
Sure. There are developments that are certainly around KPK facilities.
And let's see, is this one example? Do you recognize this as being within Dacono?
Yes, that is Sharp Farms subdivision.
And do we see two wells within roundabouts in the subdivision there?
Correct. There are two wells in roundabouts. One is on Flying Circle and the other is on 6th Street.
Thank you, Ms. Krieger. And is there anything else you wanted to share with the commission during this part of your examination?
Other than financial assurance is very important to the city of Dacono. Time and time again, we continue to see that this operator is unable to meet its obligations. We are very concerned that without adequate financial assurance, that the burden will be shifted to the city of Dacono. We're obviously starting to see a little bit of that by having to spend, $10,000 at this point to hire a consultant to get to root cause. And, historically, concerns of local government residents, property owners have largely, under the old act, been dismissed because of BMPs and, regulations that are said to be the most stringent in the nation. And either those regulations and BMPs aren't working, or perhaps we have an operator in Dacono that is simply unable to meet its obligations. Thank you.
And just for clarification, you mentioned the $10,000 spent. That was just for one instance, right? That's not the total that Dacono has spent in dealing with KPK wells in the city, just for clarification.
With KPK wells, yes, trying to find a root cause of an unusual odor. There have been other incidents related to methane that we have had to hire consultants to help us deal with impacts of elevated methane in the city of Dacono. We cannot attribute those directly to KPK.
Thank you, Ms. Krieger. No more questions from me at this time, but please stick around for questions from others.
Thank you.
Thank you for the testimony. Mr. Jacobs Cross for this witness.
Yes, thank you, Mr. Chair. I have a few questions. Good morning, Ms. Krieger.
Good morning.
Get the opportunity to receive your testimony and also to ask you a few questions about it. Let's see. The slide you showed with the complaints, many of those were filed by the city of Dacono on the same day, were they not?
Yes, they were.
You talked about, well, and one of them you indicated, I believe, was subject to an NOAV, but the others have not been the subject of enforcement, have they?
I don't know exactly. When you say subject to enforcement, they have been re-inspected and they continue to have outstanding issues and updates to them that have not been resolved.
Correct. And you described them as remaining open, I believe.
Yes, and I apologize if that is not the correct
No, that's fine.
language to use, but from where we're sitting, they haven't
That's
been
fine.
dealt with.
Thank you for your answer. You discussed an odor incident in January involving a water vault, and that vault is not the responsibility of KPK, is it?
No, it's a water master meter vault. However, there was a combustible gas detected in it, causing the technician's alarm to go off.
Sure. And you're aware, are you not, that KPK submitted forensic analysis data indicating that it was not combustible gas that came from any of its facilities, correct?
No, I'm not
Okay.
aware of that. I am aware of the testing that the city had completed by its consultant that did determine, based upon the compounds, that it was a wet gas that is associated with a produced gas.
We can certainly provide rebuttal testimony on that point, but thank you for your answer. Mr. Lewis Prescott, if you could bring your slides back up. I'd like to put slide 5 of Ms. Krieger's back on. Are you aware that 2 of the wells on here have been plugged by KPK?
Which ones?
I'll need to address that in rebuttal testimony, but just want to cover that. I thought maybe you were aware that KPK had plugged some wells in this subdivision. Well, no, I think that's it. I have no further cross-examination questions for this witness. Thank you, Ms. Krieger.
Thank you.
Mr. Boudreau?
No questions from staff for Mr. Krieger. Thank you, Mr. Chair.
Mr. Sura?
No questions. Thank you.
All right, Ms. Krieger, the commissioners now have an opportunity for questions. I can start with one particular one. You indicated that KPK desired $250,000 to plug and abandon one well. Did the city take them up on that and pay that $250,000?
The city? No.
Okay, thanks. Other questions for Ms. Krieger? All right, seeing no further questions, thank you very much for your testimony. Nice to see you. And we will move to Dacono's next witness.
Thank you. Thank you, Mr. Krieger. Dacono calls Mr. John L. Oborn Jr. I will share my screen again. Mr. Oborn, good morning. Thank you for being here. Can we start by talking about your background and your experience with respect to oil and gas?
Mr. Oborn appears to be muted.
Thank you, Mr. Chair.
Thank you.
There we go.
Okay. Can you hear me okay?
Yep.
Okay, thank you. Good morning. I entered the oil and gas business in 1980. Field landman, doing field work all over the Rocky Mountain region. For the first 20 years of my career, spent much time in the field, also conducting due diligence, acquisitions, divestitures, trades for my clients. And that's a lot of documentation and a lot of deals, many of them in the DJ Basin. During that portion of time, I have worked for Garrity Vessels in Canada, Snyder, Noble, Whiting. And then for the last 20 years, I have done more specialized consulting for clients, many of them in the DJ Basin, working on, again, due diligence, sales, acquisitions, trades, valuations of producing, non-producing mineral working interests. Done that for estate tax purposes, assisting banks, trusts, municipalities, even law firms with valuations of offers that they have received to purchase minerals or working interest. Much of this requiring revenue modeling, expense modeling. I continue to do that now. I have many projects ongoing in the DJ Basin at this time. I also have actively been working with operators in Montana and Utah, assisting with their land needs, basically as a contract land manager. And in that capacity, I get to routinely review JIBs, revenue statements, revenue decks, AFEs, help in the preparation of them from the land side. And so I do have the ability to look at a lot of different information that most outside landmen do not. So I do have.
And Mr. Oberg, to try to keep this moving along and brief, because we are limited on time, you did provide your CV. It is attached as Exhibit E, Appendix 2, which
I did
reference. Thank you. And generally, do you have experience dealing with working interest economics, such as revenues and costs associated with vertical wells in the DJ Basin?
Yes.
You have experience with reclamation and plugging costs for vertical wells in the DJ Basin?
Yes.
And you've reviewed AFEs and JIBs related to the same?
Yes.
And are wells that you have experience with similar to KPK's wells in Dacono that you reviewed?
They are vertical wells, mostly Codell, Niobrara, and Jay.
Yeah, and some Sussex Shannon as well?
I have not seen AFEs on Sussex and Shannon. The AFEs and such that I've worked with and the wells that I've worked with have been 2,000 feet deeper in the Codell, Niobrara primarily.
Thank you. And have you been recognized as an expert before in oil and gas matters?
Yes.
Have you been recognized by this commission as an expert before?
No.
Have you been recognized by other commissions as a oil and gas expert?
Utah, yes.
Okay. Did you prepare an expert report in this matter?
Yes.
Can you briefly describe the scope of it?
It was a review of production history on the 59 wells, and from that, I had to extrapolate and estimate revenue and expense projections for determination of proximate value and sale potential of the assets.
And did you talk about costs associated with KPK's issue wells in Dacono, such as reclamation and plugging costs?
Plugging and reclamation, yes.
Okay. And that again is submitted as Exhibit E. At this time, I'll move to qualify Mr. Oberg as an expert entitled to provide opinions related to vertical well economics.
I object to the designation of Mr. Oberg as an expert with respect to reserve valuation and future production. He's not a certified petroleum engineer or geologist. He has not prepared a reserve certification, and that is typically required. The reserves information supplied by KPK to this commission with its Form 3 as part of this proceeding was prepared by the petroleum engineering consulting firm of Netherlands and Sewell. That is the quality of qualification and expert work required for the kind of testimony to be provided by Mr. Oberg. I'm fine with him providing his testimony as a fact witness. He may have opinions, but they're not expert opinions regarding the valuation of reserves and future production from KPK's wells, in our opinion.
response, Mr. Lewis Prescott?
Yeah, I think we laid sufficient foundation related to Mr. Obern's expertise. I'm happy to ask a couple more questions to lay foundation specifically with respect to valuing future revenue and therefore value of the wells, if that would be helpful or necessary here.
Why don't you do that?
Mr. Obern, did you look at the economics of these wells on a few forward-looking basis, i.e. future revenue from them?
Yes.
And how did you analyze that? Well, what information did you use to analyze their future revenue and value?
Looked at the past production on the wells to get an idea of what kind of volumes they're dealing with, and then use an average product price to establish what one would use as a estimated cash flow going forward. And then coupled that with the sorts of expenses that operators are billing to their.
Let's just focus on the revenue.
Okay,
part.
revenue.
That's the only thing
Okay.
that the objection pertained to. So how far was your look back as far as historic production for these wells?
4 years.
And is that acceptable in the industry as far as looking at the value of wells and future revenue from them?
When I'm doing valuations, I'm going generally 3 to 5. In this case, did 4.
Okay, thank you. And did you look at prices by year as well and how that impacted production by year?
Yes.
And did that go into your analysis as to future production or ability to produce more in the future? I.e., if there was high prices, would you expect to see higher production to take advantage of those higher prices?
Yes, that's what I see from my other clients.
And based on your analysis, were you able to confidently confirm what the productivity of these wells are on a going forward basis?
Yes. These wells.
Thank you, Mr. Ober. And I don't want to get into your opinions or your testimony. I just want to talk about your analysis and methodology for this. Commissioner, I believe the methodology complies with industry standard and sufficient to support his expertise in looking at the valuation of these wells and revenue on a forward-looking basis.
Mr. Jacobs?
I renew my objection. He can look at most anything he wants, but he's not qualified to render an expert opinion on it. He's not a certified petroleum reservoir engineer. That is the industry standard, and this commission should understand that. Rule 702 is the basis for this, Colorado Rules of Evidence. It's critical to the analysis of expert testimony that in making a determination, the court may consider the expertise of the proposed expert witness. He is not qualified to render a reserves evaluation or future production expert opinion. He can provide a lay fact opinion, if you will. But I object to his designation as an expert for those reasons. And Colorado case law is squarely in my corner on that.
Mr. Lewis Prescott, any response?
I think we've laid sufficient foundation here, Mr. Chair. Thank you.
Mr. Boudreau, I don't know if you care to weigh in, give you the opportunity.
Thank you, but staff takes no position.
Mr. Sarah?
I haven't not studied his CV. I can't take a position on that either.
All right, let's take a 10-minute break and return at 11:31.
Mr. Chair, if I may, I'd also like to just indicate that we have rebuttal testimony coming from our certified petroleum landman, the nature of Mr. Obern's qualifications, that will also address this point. And you may wish to reserve ruling on this issue of his expert status or not, his designation as an expert or not, until you've heard Avi Mailer's counter testimony as the vice president of land and a certified petroleum landman.
Okay, thanks for that. I still want to take a 10-minute break. We'll return at 11:32. All right, we are back on the record. It is 11:32 on Thursday, October 26th. This is docket 230400117. Pending is a objection as to the certification of Mr. Oberon as an expert on reserves. I'm going to sustain the objection. The commission will still hear Mr. Oberon's testimony. That testimony will be in the record, and the commission will give and determine what weight to give it. I would remind all the lawyers in the room that this is a commission of lay people who are most interested in getting to the heart of the matter based upon the facts. So with that, Mr. Lewis Prescott, if you want to continue with your questioning, we look forward to hearing from Mr. Oberon.
Thank you. And I can assure you we won't get any expert opinions related to reserves. Going back to sharing the screen. Mr. Oberon, did you prepare what we're looking at here? I think it's going to be 4 slides there as part of your expert report in this matter.
Yes,
And does it identify all 59 issue wells operated by KPK in Dacono?
yes.
And can you walk us through quickly, what we're looking at here? I think you can skip the first 4 columns. They're pretty self-explanatory. Talk about columns 5 and 6, please.
Last production.
I'm sorry. Let me just go by title. The 4-year daily average barrels. What are we seeing in that column for these wells?
You're seeing confirmation of low volume, low production. This is just an average going to the ECMC website, reviewing the production on each well, bringing it forward for a 4-year period. And that would be from April 1st of 19 to March 31st of 23.
And that for both oil and gas.
Yep, for both oil and gas.
And what's the average age of these 59 wells in Dacono?
They're about 46 years.
Okay. And then did you also look at known or identified environmental issues for these 59 wells?
Yeah. Took a look at the what was showing up as being filed. And also some of the wells were on the 901A order. So those are those are on the far right. And my apologies, the screen, when this was reduced to the PowerPoint, the last 2 digits for the doc numbers on those have been cut off. So
we can revisit that.
Okay.
And then if we go through the table you prepared, we'll come to your conclusions there. First, you mentioned the 901 order. You're familiar with that order?
Yes, I took a look at it.
And any subsequent orders related to it, did you take a look at those?
The field filings, the field reports, and the Form 19s.
Yeah. And did you look at order 863?
Yes, I looked at 863 as well.
Okay. And then based on your analysis of these wells, did you do some math?
Yes.
And based on the past 4 years, what did you find on average for the 59 wells in Dacono?
They're not producing a lot in the way of per month revenue. Running averages for the production times the average monthly revenue times the purchase price here. It's not a lot.
Okay. So on average, what's the total revenue per well that these wells have generated over the past 4 years?
My estimates put it around, 400, a little over $400.
And then did you look at updates, environmental issues for these wells that you didn't see when you first put that report together?
Yes.
And are they summarized on this slide here?
Yes.
So how many total known spills have been discovered at issue wells since 2020 in Dacono?
Well, there's 11 Form 19s, one's closed. 6 Form 19s reflect further work being done under Form 27 remediation forms. 4 appear open. 4 pending field inspection forms that haven't become Form 19s. And then there's the April 12th, 21 Director's Order pursuant to Rule 901A.
Did you add those up and figure out how many spills we have?
Yeah, there's 16, 17 spills.
Okay, and that's associated with 59 wells.
Yes.
And then let's go back to the math that you worked on here. Did anything jump out to you when you're looking at prices over the past 5 years?
2022 oil and gas pricing was very, very good.
And did you see production from KPK wells increase in 2022 from these wells?
No, it stayed the same as 21, pretty much 21 and 20. It all stayed flatline, very low.
And based on your experience, what conclusion did you draw from that?
Well, either KPK made a business decision not to put money into their wells to enhance production, or they couldn't because they didn't have the money, or the wells are not capable of an increase in production. And I don't know which that would be.
And I'm bringing up a slide here. Those are taken from your report. Does this summarize the math that you did to look at the monthly revenue from these wells?
Yes, it does.
And you have an NRI assumption in there. Do you want to explain what that is?
I use 72.5, which would be 100% less the landowner royalty, less an assumption on overrides. These are old leases. Many of them are burdened by 5 to 7. I'm assuming 7% is a high, 5% is an average, and then you have some taxes in there too. State ad valorem, and what that's going to do is drop your net revenue that you're going to receive down to somewhere between 72.5, or might be a little higher, might be a little lower.
Thank you. And then looking at this slide, we're looking at typical expenses for operators in the DJ Basin. Again, I believe this is taken from your report. Is that correct?
Yes.
And would you agree that these are all typical expenses for operating a well?
These are very general, yes, and they are on the rise.
And can you talk about that, the fact that the cost of operating is increasing?
Yes, labor costs, mechanical machinery costs, insurance costs, anything involving trucking. Of course, your regulatory side is increasing costs on your soil testing, well testing. It's all going up.
And has that been a trend recently, or has that been a trend that you've seen over the course of some years?
We've seen that trend going up over the last 3 years, 2023 especially.
And then you have monthly operating expenses per well. Do these figures on the screen indicate your opinion as to what the typical operating costs are for wells in the DJ Basin?
This is what I'm seeing right now from other operators on some of their Codell, Niobrara, J wells. Our family is in Noble wells, and so we have the opportunity to see on vertical basis what some of the operators are charging.
Again, and to be fair, you didn't have any KPK jibs to look at, did you?
I did not. I would love to see some KPK jibs. 3 years would be wonderful.
And admitting that you're not a reservoir expert, but based on the information available to you, did you reach any conclusions based on what you think the well's profitability is for the 59 wells in Tacona?
Well, depending on the exact situation of the well, the exact NRI, these are going to show a slight profit, or they're going to possibly show a slight loss
And
on a monthly basis.
Do you think they have sufficient profit to cover the plugging and reclamation liabilities?
No.
Do you think there's a market for another operator to acquire KPK's wells?
I of all of my clients and people I work with, no, they would not treat this as a viable acquisition.
And have you looked at other operators in Dacono and what route and operation they've conducted?
Yeah, Dacono has horizontal development throughout the Dacono outline. Kerr-McGee, now Oxy has drilled over 100 horizontal wells from 14 pads. And as part of that, their standard operating procedure is to plug and abandon vertical and directional wells throughout that horizontal drilling completion process.
And is it fair to say that KPK's wells in that case are not necessary to hold leases?
That's correct.
All right, I want to spend a little bit of time with this slide. Again, I'm taking it from your report, Mr. O'Byrne. Can you talk about the costs that you show here related to plugging wells and reclamation?
With the understanding that each well site is going to be slightly different. It's going to be slightly size-wise. My figures, my acreage figures and such are in my report, but assuming that these well pads are quarter acre or a little larger, the P&A costs that I'm getting on other wells, like family wells from Chevron, are about 100K. Last one was 2020 100K for a Codell Niobrara. Wells that I'm involved with assisting on the P&A, reviewing expenses, helping prepare AFEs on for Montana and for Utah. Those are running upwards to 150 for wells that are 8,000 feet and deeper. So to plug the well, I'm using 35 to 50, which I think is reasonable.
And have you investigated that with regard to similar wells, Sussex wells in the DJ Basin?
Really the only Sussex operator is KP Kaufman, and I don't have their data. So what I can tell you is if you're working with a 2020 AFE that says 100,000 on it for a 7,000 foot well, and the KP Kaufman wells are 5,200, the process that's going to be used to plug the well is similar. It's the amount of cement and that additional, what happens in the additional 2,000 feet that's going to affect the cost. So I'm adjusting my cost downward for that reason.
Thank you for that. And are you familiar with vendors that do plugging and abandonment in the DJ? And have you had a chance to speak with them and understand their general plugging costs?
Yes, on a very general basis. And you know, they're confirming my numbers based on their increased costs here in 2023.
Thank you. And going to reclamation, specifically with respect to flow lines, we haven't heard too much testimony about that. Do you know what materials KPK's flow lines are made of in Dacono and elsewhere?
They have steel and they have fiberglass, and that's per the ECMC site.
And per ECMC regulations, generally when a well is closed, do flow lines need to be removed?
Yes, they can be. They should be.
And when they're removed, I want to focus on the difference between a steel flow line and a fiberglass flow line. Can you talk about that?
Well, the process for steel lines is, I mean, you've got two choices with steel. You can trench the whole thing, or you can pothole cut the pipe, pull it. And that's the quickest way that will allow for minimal surface disturbance to get the pipe out of the ground versus the fiberglass. You're going to have to open trench, and depending on the age of the fiberglass, you may have some issues with the quality of the pipe, if you can, you know, get it out whole, or if it's going to wind up in pieces and you're going to be pulling pieces out of a trench. And then the reclamation on that, because you've disturbed, you know, that linear area by 2-3 feet wide, whatever your bucket width is, that's going to have to be cleaned up.
So if we're talking about extensive lengths of fiberglass pipeline or flow line, would your estimation for reclamation related to flow line removal be higher than 10,000?
Objection. I'm concerned this line of questioning is exceeding the witness's claimed scope of expertise or experience. We're talking about reclamation now, not valuation.
Can you lay a foundation, Mr. Lewis Prescott?
Sure, Mr. Oburn, going back to your experience with AFEs and being a consultant to operators who are plugging and reclaiming well sites, do you have experience with reclamation related to flow lines?
Yes. Getting
And
getting bids for the work and loading that into the AFE.
So you've seen bids for flow line reclamation for both steel and fiberglass, is that accurate?
For steel, yes. For fiberglass, I just know that it's unique to this particular basin. It's not something that I'm usually working with steel in other places.
Okay, but are you familiar with fiberglass as a material?
Yes.
Does fiberglass generally break more easily?
Yes.
And are you familiar with spills at KPK sites being related to largely flow lines?
Yes, I have seen that on the Form 19s.
All right. Sure. I believe this witness is able to testify as to reclamation related to flow lines and reclamation related to fiberglass flow lines.
I'll renew my objection, Mr. Chair. He has no experience with fiberglass, and he's only loaded costs from bids into AFEs with respect to this work. He's talking about work in the field, that sort of thing.
And to
Objection.
clarify, we're not trying to get in expert testimony on this. This is based on experience and observation and understanding of different materials.
Yeah, I tend to agree. We will overrule the objection and the witness can answer the question.
And the question, Mr. Oburn, was understanding the different materials and the work necessary to remove flow lines that are steel versus fiberglass. If a fiberglass flow line is relatively longer than a typical flow line, and fiberglass as opposed to steel, would your estimate for removal costs be higher than $10,000?
Yes.
And is that heightened cost related to the need to pothole, excavate, backfill, fill more space with topsoil?
It would be more labor time, more machinery time to remove it versus potholing and pulling steel.
Thank you. No more questions at this time.
All right, thank you very much. This witness is now subject to cross-examination by Mr. Jacobs.
Thank you, Mr. Chair. Mr. Oburn, thank you for your testimony. I've got a few questions for you this morning. Let's see. You did indicate, I believe, that you have not seen any AFEs for Sussex and Shannon vertical wells, correct?
Correct.
You mentioned a number of companies with which you've had some professional interaction as part of your background. None of those companies is vertically integrated like KPK with its own well field or oil field services company, are they?
None of them are.
And you indicated that you've not seen any KPK jibs. That's also correct, I believe.
That is correct.
So you really don't know, you're making assumptions about KPK's lease operating expenses, are you not, in your report?
I am.
And you indicated that, I believe toward the end of your testimony, that you don't have our data. We did not have any discovery afforded the parties in this proceeding, so that also is a correct statement. You don't have KPK data.
I do not. I would love to have it.
No further questions for this witness.
Mr. Boudreau,
Nothing from staff. Thank you, Mr. Chair.
Mr. Searle,
No questions from Frederick. Thank you.
questions from commissioners for this witness? Any redirect, Mr. Lewis Prescott?
No redirect, thank you. And with that in mind, I can move to exhibits if the commission's ready.
I believe so.
Dakota will move for admission of exhibit A. I don't believe that was objected to, but Mr. Jacobs can correct me if I'm wrong. It is simply the aerial photos of issue wells in Dakota, taken from the Weld County Assessor.
Mr. Jacobs?
We do not, I'm just double checking here, excuse me. No, we did not object to A. But with respect to E, Mr. Obern's report, we still object on the basis that it's speculative and it lacks factual support. He's making assumptions about lease operating expenses. He has no data. He's not looked at AFEs for Sussex Shannon production. So it's a guesstimate. And accordingly, I would urge the commission not to admit Mr. Obern's report respectfully into the record. Thank you.
Mr. Lewis Prescott?
Thank you. That was the next exhibit. I do move to admit exhibit E, inclusive of the appendix prepared by Mr. Obern, which we went through today, and his CV, appendix 2. The report is summarized in the hearing before you today. It provides the background of his investigation and analysis. It provides the support for his opinions that were provided, understanding that he's not accepted as an expert in reservoir engineering, which I don't believe is included in the report. I believe that the commission is well suited to determine whether it should be given weight and how much weight, but I don't think there's anything based in Mr. Obern's background or testimony today that would preclude his ability to provide the expert testimony that he did provide today, that he was recognized as an expert in, which is supported by the report.
Mr. Jacobs?
I just want clarification. Mr. Lewis Prescott is seeming to indicate that this commission has recognized Mr. Obern as an expert in some respect, and I do not believe that to be the case. I think the record would reflect that he has not been designated an expert. And now we're simply talking about the admission of his report into evidence of the record of these proceedings. I would renew my objection on the speculative nature of his opinions and analysis, lacking evidentiary support, factual support in the record.
Final thoughts, Commissioner or Mr. Lewis Prescott?
Thank you. The only objection when we move to admit Mr. Obern as an expert qualified to testify as to oil and gas vertical well economics was to his qualifications as a reservoir engineer. We understand that that was sustained and his expert testimony was then given unrelated to reservoir expertise. So I do believe that he was recognized as an expert because there's no objection otherwise to his to the motion to have him recognized as an expert. He has given expert opinions. And again, we're talking about his expert report, which simply supports his testimony today.
All right, well, I'm gonna let in exhibit A and exhibit E, and the commissioners will give it the weight they consider it in that regard. Were you looking for other exhibits, Mr. Lewis Prescott?
I would ask that the commission take judicial notice of exhibits F and G, their commission orders. I don't specifically need them admitted as exhibits, as you do have the ability to take judicial notice thereof, and assume have personal knowledge thereof. So no, at this time, Dacono rests. Thank you.
Okay, thank you very much, and we'll take notice of those two exhibits. Okay, it is noon. We started at 10. We're going until 2. Starting to get worried that we're not going to get through rebuttal at this point. How are commissioners doing? We need to take a short break, or are we good to go and say another 30 minutes or so? All right, I'm seeing affirmative heads, so let's move forward. I believe we now have rebuttal testimony by staff.
Mr. Chair, I'm sorry to interrupt. May I ask for time checks for the 4 parties as we get into this rebuttal?
No, that's a great idea. Mr. Thomas?
Currently, staff has 49 minutes and 30 seconds. KPK has 45 minutes, 13 seconds. Frederick has 19 minutes and 3 seconds. And Dacono has 9 minutes and 7 seconds.
Okay. With that, we recognize AG Boudreau for rebuttal by staff.
Thank you, Mr. Chair. I'd like to recall Mr. Greg Duranlo. Hi, Mr. Duranlo.
Good afternoon. Could I get 1 second to
Yes.
shut down my phone? Thank you. I apologize about that. My computer had an untimely update and reboot, and so I was listening on my phone and my computer.
No problem. So first of all, thank you for returning today. I'd like to clear up a few things that we discussed on Tuesday. Let's start with KPK's slide number 25. So I'm showing you KPK's slide number 25. Can you remind us what we're looking at here?
Yes, so this slide shows 2 photographs of the ACNO number 2 wellhead, one prior to some excavation and one after, and discusses the estimates for remediation of impacted soils there.
Can you tell when the picture on the right was taken?
It was taken October 13th of 2023.
And remind us, please, when were you and your staff asked to calculate KPK's remediation costs?
The commission instructed staff and KPK to develop cost estimates for remediation issues in the August 17th, I believe, hearing.
So at the time you were calculating staff's estimates, did you know how many cubic yards needed to be remediated at this site?
No.
Why not?
This spill was reported in May, and despite the fact that an initial Form 19 and 2 supplemental Forms 19 have been submitted to ECMC, there has been no additional analytical data submitted. And I'd note in the picture on the right, there are, taken in October, there are plastic bags that appear to be associated with soil sampling activities.
Was there any data submitted on a Form 19 or 27 for this site that you did not consider?
No, again, there was no data submitted on the subsequent forms that were submitted by KPK. And I was corrected by my staff that I misspoke on Tuesday, and that I had stated that staff did not use data submitted on forms that were subsequently that were submitted and subsequently rejected or denied. And in fact, if we had data in the file, even if it came through on a denied form, we did include it in our consideration. So again, we did not have data for this site in the file.
So for sites in which you did not have data, how did you make the calculations?
We had to rely on assumptions, and in this case, we utilized the minimum excavation size assumption.
And is this indicative of the type of data gaps that required staff to make assumptions for KPK?
Yes, we frequently had to make assumptions where there were not data in the file for active project sites.
Thank you. Now I'm showing you KPK slide number 26. Can you remind us what this is?
This is the excavation as of November 11th, 2022 at the Greeley National Bank site in the photograph. And then there are texts describing the estimates for additional work needed at that site.
Have soil impacts been fully remediated at this site?
No, nor delineated. There's at least 4 bottom hole samples within the excavated and subsequently backfilled area with hydrocarbon contamination still in place above table 915-1. There's no vertical delineation of those impacts.
Has this excavation been backfilled?
Yes, it has. Following the Commission's February order, ECMC staff granted emergency backfill due to the public safety risks at this location.
And I believe you testified on Tuesday that you have reviewed KPK's Exhibit S. Is that right?
Yes.
How did KPK address remediating these impacts in their cost estimate in Exhibit S?
They really didn't. They provided cost estimates for approximately 2 soil borings. They had $405 in for 2 soil borings, 17 soil samples, and 4 quarters of groundwater monitoring and reporting.
Do you consider KPK's $17,000 assessment of the remaining remediation work sufficient?
No, not at all.
Why not?
As I mentioned, there's hydrocarbon soil impacts still in place, and KPK offered no plans for delineation or remediation of that. There's also groundwater impacts that have been found outside the excavated area, and KPK lacks points of compliance for groundwater. And they did not include collection of source well data.
So what's included in staff's $431,000 estimated cost for this site?
Additional soil sampling and delineation, background sampling, 3 years of air sparge or SVE in situ remediation since the site has been backfilled, chemical oxidation treatments to aid in situ remediation, and also 16 quarters or 4 years of groundwater monitoring and reclamation.
So is it reasonable to assume that regulatory closure can be achieved at this site after only 4 quarters of monitoring data, as KPK suggests?
No, not at all. It would, because there's groundwater impacts, it will take first the time spent to remediate those impacts, and once it's cleaned up, then it's 4 quarters of monitoring.
Is this indicative of the cost differences on a site-by-site basis that you identified in preparing staff's estimated remediation costs?
Yes, I believe it is. They've assumed that in most cases that very little remains to be done, and we either disagree with that based on the data that we have on file, or disagreed because we don't have data on file that we would need to make that assessment.
Thank you. Do you remember Mr. Peterson discussing costs for groundwater sampling?
Yes, I do.
What is your recollection of the testimony on that topic?
For groundwater sampling, he testified that groundwater sampling should cost about $100 per sample, and he contested staff's estimate of $300 per sample.
Can you describe how you arrived at $300 per sample for groundwater sampling?
Sure. So we looked at our contract rates with 4 accredited laboratories, And for organics analysis and the other groundwater parameters, we have costs ranging from $87 to $196 per sample. And the average cost for that analytical suite is $128 and change for organic analysis. And so we also, in our sampling cost, included the cost for a field technician at $90 an hour based on a master service agreement that ECMC has with a consultant. We assumed that on average, 5 wells would be sampled in a given field day at a given site, since that's a fairly typical number of wells on a site. And so based on an 8-hour workday, that comes out to 1.6 hours per sample to include preparation for the field, mobilization to the field, purging the well, collecting field parameters, sampling the well, packing the samples on ice, and shipping the samples to a lab. We included the truck to get the field individual into the field at 75 cents a mile for 14 miles per sample, just because we assumed a 70-mile round trip from the metro area out to the Dacono Frederick area, and then divided that by 5 wells. We included the cost for a disposable baler at $6 per well. We included daily rental of metering equipment used during water well sampling. And so our cost total using that average lab cost of $128 was $326 per well or per sample. It comes down to $284 per well using the lowest current lab price. So $300 per sample is absolutely reasonable. And I'd like to note that we don't dispute the $100 per sample for lab costs. We simply included all other costs necessary to collect the samples.
Thank you. Would you say this is indicative of the cost differences that you identified in preparing staff's overall estimated costs?
As compared to KPK's estimates, yes, this was very consistent.
Thank you. Did you hear Mr. Peterson's testimony regarding excavation unit costs?
Yes, I did.
What is your recollection of that testimony?
I recall that he commented that $400 an hour for an excavator operator is unreasonable.
Did you see on KPK's presentation where they claim that ECMC's transportation charges are equivalent to $118 for a CDL driver?
Yes, I did.
And on the same slide, do you see where it shows that $16 per cubic yard is the equivalent of $2,000 per hour for the equipment operator?
Yes, I did.
What's your assessment of these calculations?
That they failed to take into account the actual cost to do the work. Starting with the transportation costs, it's not just the CDL driver that's included in the reasonable cost guideline rate. It's the driver plus the truck he's driving, plus fuel, plus maintenance of the truck, plus insurance, plus registration, plus overhead that a trucking company would charge. All of that is built into the reasonable cost guideline unit costs. And none of that was factored in by KPK. Yet those are real costs, even when they self-perform the work. And, to Mr. Peterson's assertion that $400 for an excavator operator is unreasonable, it suffers from the same flaw. It fails to account for the $500,000 piece of equipment, the fuel consumed at $10 to $15 an hour or gallons per hour, the maintenance of the equipment, the depreciation of the equipment, the insurance, the overhead, all of that is built into the unit rates that staff used.
And what about the calculations themselves?
Sure. So looking at the sort of top line on this slide, we heard Mr. Peterson testify that it's not reasonable to expect that remedial excavation at upstream oil and gas locations can be performed consistently at 1,000 cubic yards per hour. And yet that was formed the basis of their calculation on this slide. And using that excavation production rate plus the reasonable cost guideline unit cost is not an appropriate way to calculate the hourly rate. And I'll kind of map that out. So at 1,000 cubic yards per day times $16 per cubic yard divided by 8 hours per day, that's where you get 2,000 hours per day. $2,000 per hour. If you use a more reasonable cost, such as the excavation production rate of 200 cubic yards per day, which is what staff actually estimated, you get 200 cubic yards per day times $16 per cubic yard divided by 8 hours per day, and that amounts to $400 per hour as an excavation and loading rate.
I see. So is this indicative of the cost differences that you identified in preparing staff's overall estimated costs?
Yes, again, staff feels that their unit cost estimates were fully loaded with the cost it takes to do the work.
Thank you. I believe there was a discussion on Tuesday about staff denying Form 19s and Form 27s. Does staff deny Form 19s without comments or explanation to the operators?
Not that I've seen.
Does staff deny Form 27s without comments to the operators? Also
not that I've seen.
If staff denies a Form 19 or Form 27, can the operator contact staff via email for clarification on the denial?
Yes, of course.
Does staff have the resources to act as environmental consultants to every operator in the state?
No, and it's not our job to.
Can you give an example of when staff has denied one of KPK's plans for in situ remediation?
Sure, I'd like to talk again about the Grant tank battery.
Okay.
So on October 26th of 2022, staff conditionally approved KPK's Form 27 for the Grant tank battery, quote, to allow for expedient backfill of this excavation to mitigate a significant and ongoing public safety risk. And in this form, and that's end quote, and in this form, KPK proposed a pilot test for air sparge or soil vapor extraction, as well as chemical oxidation injections to remediate the hydrocarbon exceedances remaining on the site. ECMC did not approve the pilot test because the plan was completely inadequate to demonstrate the feasibility of the remedial technologies that were proposed to be tested. And I believe you've got that document up with the notes that ECMC made. So we added a detailed condition of approval on that approved form describing what needed to be included in the pilot test to be approved. The next Form 27 that was submitted by KPK in January of 2023 was denied in March of 2023, in part because the form did not provide the specific technical information specified in the original condition of approval necessary for staff to conduct a review of the pilot test plan.
And were the comments provided on the Form 27 to explain why the form was denied?
Yes, and as you have on the screen there, you can see the level of detail provided in our comments.
Has KPK resubmitted a pilot test plan for the Grant tank battery?
No, there have been no additional forms submitted since that denial for the Grant tank battery. So it's been almost a year since KPK backfilled the excavation, and they still haven't submitted a complete plan to pilot test in situ remediation, let alone a plan to actually conduct the in situ remediation of the remaining hydrocarbon contamination at the site.
Thank you. Did you hear Mr. Peterson testify regarding the significant amount of remediation cost data that ECMC has on file?
Yes, I did.
Did you have any thoughts about that?
Yes, I do. So that data field was added to the Form 27 following the adoption of the financial assurance rules. The data received has not been exhaustively reviewed by staff unless data were not provided in that field or estimates were unreasonably low. Staff accepted that data. I've directed my staff to do this until we began our formal process for annual reviews of financial assurance amounts, which couldn't occur until the operator had an approved financial assurance plan. It also took some time for staff to develop a process for this, and that development process is still ongoing. And a couple of other points. It's challenging, or it would be challenging, to equate those costs to directly to specific work or the project categories that we identified in this exercise or specific tasks, because there are so many variables to the amount of work that could be covered on a given Form 27. It would take a really significant effort to develop a reliable relationship between the cost estimate reported in that data field and the actual scope of work that it represents. We did use some of those estimates, though, for the purposes of establishing our reasonable flat rate estimates for facility decommissioning. And we were able to look at Form 27s that were submitted only for facility decommissioning. And then we were able to look at the facility type that was being decommissioned, and then we could pull some data. And we grabbed a few forms from this operator, from some other operators who have significant decommissioning programs, and we felt like it was reasonable to pull those out for that purpose. And then, lastly on this, just looking at KPK's Exhibit S provides plenty of justification for not using these costs as the basis for our site-specific remediation cost estimates.
Oh, what do you mean by that?
If you can pull up Exhibit S, I can tell you. So it's hard to see. There's a lot of data there. Thank you for zooming in. So KPK, I'll call it good there. So
I'm done zooming. Go ahead.
Yeah, KPK included a column on the form with a column in yellow with the Form 27 estimates, as well as a column in green with the estimates made for this exercise. So it's pretty easy to compare the two. There were 82 sites listed where the cost estimates for this exercise were higher than their Form 27 estimates, and 27 where they were lower. For the projects where the new estimates were higher, the average difference was $23,000, and the total positive difference was $1.9 million. For projects where the new estimates were lower, the average difference was $9,600, and the total negative difference was $260,000.
So would you feel comfortable relying on only Form 27 data to calculate anyone's remediation costs on a site-by-site basis?
No, it's why we have the annual review.
Is KPK's data an example of how unreliable that data can be?
It's a very good example, yes.
Would you expect other operators' data to be similarly unreliable for this purpose?
At this point, yes, we haven't put, as I mentioned, the exhaustive research and review effort into those numbers.
Thank you. Are you aware that KPK sent a list of 18 locations Tuesday evening, listing locations that they allege are being over-excavated or oversampled due to disagreements about background concentrations?
Yes, I am.
Did you and your staff have time to dive into those details before today?
Yes, and I would like to thank my staff for rolling up their sleeves and jumping into that exercise on a very rapid basis.
What did you find?
We found numerous issues with the sites beyond just the background determination question that was at issue there. When we looked through that list of sites, we found 3 sites that had no analytical data to submitted to ECMC at all. So obviously we can't make a background determination with no data. According to the most recent data we have in our files, including data from denied forms, 6 sites have organic compounds remaining in the soil at concentrations in excess of the cleanup standards of Table 915-1. Obviously, Table 915-1 does not have a provision for considering background concentrations for hydrocarbon contamination. They're not present in the background. 6 of the sites have documented residual groundwater contamination, and so it's premature to discuss closure of a site based on background concentrations when the groundwater remains impacted. And one of the sites has an issue with hexavalent chromium, which was historically used in corrosion inhibitors. And while footnotes 1 and 11 to Table 915-1 apply to all metals, hexavalent chromium is not something that is easily cleared through a background analysis because most frequently when it's found, it's representative of an introduced contaminant. So that's a bunch of issues, but there's overlap among some of those issues. Basically, we found that there are 11 sites that are decidedly not ready to consider background determination and closure. Of the 7 remaining sites for which ECMC could consider a background determination analysis and potential closure, 5 had the last form that was submitted denied by staff based on a technical review by staff or failure to address earlier conditions of approval by KPK. An example of one of the denial comments on one of the forms reads as follows. Operator selected that the remediation is complete operator selected the remediation is compliant with Rule 913H1 despite attached analytical indicating that the excavation is not within Table 915-1 or site-specific background.
And does this in any way mean that staff is telling KPK in these forms that they need to remove naturally occurring metals?
No.
Thank you for being here to clear things up. That's all I have on direct rebuttal. I would ask that, well, I think we have to do cross first.
All right.
Chair, I just have one quick question, and it's not a cross-examination question. The form that was quoted by Mr. Duranlo a moment ago, right almost at the very end, could he indicate what location and form that was that he was quoting? There's no way we can understand or look at that without it being brought up or identified. Thank you.
Mr. Boudreau.
Sorry, I don't have it off the top of my head. Can I have 2 minutes?
We can get that fairly quickly.
Yeah.
So we're waiting to get this form. Is that what's going on?
If that's the commission's preference. I think I can get an answer in about 1 minute if you give me a second. My apologies.
Okay.
And I apologize. I would have had it up, but again, I had to deal with the computer shutdown right prior to coming on. So
Fake computers tend to have that tendency.
Mr. Chair,
Yes, sir.
given the hour, might it be appropriate to take a very short lunch break, and then Mr. Boudreau can be getting that form during that time, and we can consider that information prior to cross-examination?
Where are you at, Mr. Boudreau or Mr. Duranlo?
I've got the site.
Yeah.
So the remediation project number is 22006. It is the UPRR 43 Pan Am I-5. I don't unfortunately have the document number, but it would be the most recent Form 27 that was denied on that project.
Thank you for that information. I appreciate it.
And that's all staff has for Mr. Duranlo at the moment.
All right, then let's continue forward, Mr. Jacobs. Cross.
My apologies, I do have the document number. I think it's 403-539-675.
Just looking over my notes for a moment, if you could bear with me. I do have one question. Mr. Duranlo, it's your understanding that the in situ remediation proposal that you referred to for Grant Tank Battery, I believe, was submitted by Marcom on behalf of KPK. Is that correct?
The form is the responsibility of the operator. So if Marcon submitted it, it's to us, it's KPK.
I have no further questions for this witness on cross-examination of his rebuttal testimony. Thank you for your time.
Mr. Sarah, any cross?
No, thank you.
Mr. Lewis Prescott, any cross?
No, thank you.
Commissioners, questions? Commissioner Cross?
Thank you, Mr. Chair. I just want to go into two quick things, Mr. Duranlo. First, for clarification purposes, there's a lot of discussion about the assumptions and the RCGs used. And I just want to confirm those assumptions are only if there's not additional detail provided in a form that has been presented to you, correct?
Certain assumptions were made that applied to work that we knew needed to be done. For example, the assumed additional excavation where confirmation samples had not cleared the sidewalls of the excavation or the base of the excavation. An assumption that we would make, we would step out with one additional groundwater monitoring well where a point of compliance was not established. So those assumptions were made whether there was data or not, in the file. Other assumptions were required due to the paucity of data in the files. And that would be like an example of the ACNO 2 well that I showed earlier, which, we had no data. And so we did have to assume a minimum size to the excavation. So a combination.
So, but especially because there was a lot talked about with the excavation, there wasn't situations where they said we need to excavate this amount and you used a much larger excavation amount as assumption. If the amount was already in the
no, I think there is a dispute on the amount of additional excavation required. I believe that is the case.
Okay. And then the other thing that I wanted to ask about was going back to some of the in situ remediation discussions. One of the things that came up during Mr. Peterson's testimony was they did not assume in situ because ECMC likes to request additional excavation. And I know you talked about this a little bit during rebuttal, but I'd like to really hit on this because I know you talked about there was significant differences where they were not proposing in situ remediation, even if their Form 27s currently had in situ remediation being proposed. And could you just provide a little bit more detail on your thoughts with respect to the in situ?
Yeah, I mean, any site investigation and remediation plan is it's up to the operator to develop a comprehensive plan for addressing contaminants at a site. That plan needs to be, laid out in a manner. I mean, Mr. Peterson laid out a detailed pathway for projects, and I have no objection to that pathway for a project to travel. Emergency response, source removal, evaluation of the site, and further remediation and getting to final closure. In order for staff to approve that plan, we need the data to support it, the details, of the plan, how it's going to be completed in the field, a project schedule that, lets us know that, this is not going to, linger for years and years on end, that they're going to be taking steps to actively remediate the contamination. So it's up to the operator to develop a plan that's supported by the data that they have at their hands that staff can approve. Does that answer your question?
I think it does, yeah. And just kind of going into where the approvals are. And one of the things that stuck out to me in addressing some of the assumptions that you made in Mr. Peterson's testimony was the discussion of you had certain sites that would be using in situ remediation, and he had less, even though their Form 27s had proposed in situ remediation. And he had indicated, well, we didn't use the same that we had on the Form 27s because historically ECMC likes us to excavate. And so I just wanted to try and understand what your thoughts were on because ECMC has historically asked us to remediate or to excavate. We didn't want to use in situ remediation, even if that's what's on the Form 27s.
Yeah, so I mean, I've had conversations with various operators about this exact topic. Like, source removal by excavation is absolutely key. It's just the fastest way to address it. Once you've got a large excavation open for source removal, everyone's got to make a decision as to whether or not it makes the most sense to keep excavating until you get, laboratory confirmation of clean samples, or, hey, a realization that you're not going to get out of the contamination, and a different remedial technology would be more effective, or more cost effective, or more timely, or less disturbance to the landowner's land. And any of those determinations can be made. But again, those arguments have to be made and supported and provided to staff for our review. I mean, our rules require that the investigation and remediation plan be approved prior to execution.
Okay, thank you.
Other questions from commissioners? Redirect, Mr. Boudreau.
Nothing more for Mr. Duranlo, other than to say thank you for reappearing. I would ask that the commission take administrative notice of document number 403-126-424, which is the first document that I put up on the screen. Also the second one, 403-254-814, and then the one that Mr. Jacobs had asked about, 403-539-675.
Okay. Do you have further rebuttal, Mr. Boudreau?
I do not. Thank you, Mr. Chair.
Okay. All right. Commissioners, let me first ask procedurally to lawyers. I think I heard yesterday that Mr. Sura perhaps has a hard stop at 2. Is that accurate, Mr. Sura?
Yeah, I do have a meeting with a client at that time that can't be rescheduled, but I could be back by 3.
Okay. What I'm going to suggest is let's take, say, 15 minutes and everybody go grab a quick bite if you've got it with you. And then we'll come back and we're going to try to plot on as best we can. We want to try to get this over with if we can today. Yes, Mr. Jacobs.
I'm fine with that, but I do want to, at some point, either now or at the end of the lunch break, address an email quote by Mr. Sura and the submission of that to the hearings manager.
Okay, we'll take that up at when we get back from this short break.
Very good.
Let's return at 12:55. All right, we are back live at 12:55. We just concluded the rebuttal testimony of the staff. Mr. Jacobs, I know you wanted to raise a concern procedurally. What is your concern?
Yeah, Mr. Sura provided a document.
Hold on just a second, Mr. Jacobs. I don't see that Mr. Sura is with us yet. Oh,
Yeah, sorry.
okay.
Very good.
All right. Now raise your objection.
Well, he's provided an document 2357752. It contains a quote from our former KPK director of EHS compliance, Mr. Craig Meese. And he makes certain assertions in submitting that to parties and hearing officer Thomas by email at 11:38 this morning. But we disagree. Form 27, number 403-412-431 at Exhibit K2 is for Facility 4 North, filed by CDH Consulting on behalf of KPK on June 5th, well after Mr. Meese's departure. The email is not part of that form or project and nonetheless was not submitted. The email with the quote that was made of Mr. Meese was not submitted by the town of Frederick as an exhibit, and we would like the quote and the reference to the email stricken from the record.
Okay. I have, as one commissioner, I've not looked at the document, so I can only take it, your word. Mr. Sura, what is your response?
If we reference the wrong Form 27 or spill number, I apologize, but the question was about the Guadagnoli spill location, and we stand by that. This was something that Commissioner Cross requested, and it is pertinent to the Guadagnoli location, and I think that it demonstrates the kind of responses that have unfortunately become typical of this operator, at least in the spills that they're addressing in the town of Frederick.
All right, but was this form disclosed previously?
Guadagnoli was specifically referenced as a concern and a spill within the town of Frederick. We've discussed it both in testimony and in Exhibit K. And again, if I reference the wrong Form 27, I can go back and correct that number. But the reality is that, yeah, we've been talking about Guadagnoli for now 4 months.
But if I may, there's no Form 27 for Guadagnoli in the record, period.
All right.
And I think that's irrelevant, frankly. To the point we're making, this is an employee from KP Kaufman that was responding to queries from the town of Frederick and said, look, we're not going to get around to it.
All right. I'm going to not allow this into the record. We need to move on with regard to rebuttal. Let's continue forward. At this point, rebuttal testimony is by KPK.
Yes, Mr. Chair, happy to proceed, but we need to elevate Mr. Killian as a panelist so he can drive our exhibits remotely. Thank you. And then we'll need to swear in our first rebuttal witness, which is Mr. Avi Mailer. And he'll need to be elevated as well. Mr. Mailer,
All right.
can you read? Mr. Mailer, can you hear me?
Yes.
AG Davenport.
Thank you, Chair. Mr. Mailer, would you raise your hand, state your name, and say that you swear to tell the truth, please?
I, Avi Mailer, swear to tell the truth.
Thank you.
Your witness, Mr. Jacobs.
Thank you. Please state your full name and current employment position for the record.
My name is Avi Mailer, and I'm currently the Vice President of Land for KP Kaufman Company.
And briefly, what is your educational background?
I earned a finance degree from Yeshiva University and an MBA from the University of Colorado in Denver.
How long have you been employed by KP Kaufman Company?
Approximately 17 years.
And what positions have you held at KPK in that time prior to assuming your current VP of Land position?
Started out as a land intern, then landman, land manager, and now the VP of Land.
What's the nature of your job responsibilities in your position as VP of Land?
I manage and coordinate all land activities, including but not limited to the negotiations for securing certain land documents, the maintenance of land and lease records, and the oversight of KPK's relationships with landowners.
And do your responsibilities involve negotiating and securing KPK surface use agreements and surface owner waiver and consent agreements from relevant landowners?
Yes.
And do your duties also involve transactions with land developers from time to time that seek to have KPK plug and abandon its wells located within a proposed land development project boundary?
Yes, they do.
And are you aware of the assertions of the city of Dacono and town of Frederick that KPK is demanding too much money to plug and abandon its wells in their jurisdictions?
Yes, I'm aware of that assertion.
Have land developers in Frederick and Dacono continued to pay the price that KPK has sought to plug and abandon its wells and abandon primary reserves and other lease rights along with P&Aing the well in recent years?
KPK has executed and is currently in active negotiations with multiple developers in the area. Ultimately, the agreed upon purchase price incorporates multiple factors. The agreements that we have recently signed and have been signing for many years have been to plug and abandon the wells. Incorporating in these agreements are locations in the town of Frederick for school districts in the town of Frederick. The wells or the scenarios where houses were built around existing well bores were done under surface use agreements, which were entered into in the early 2000s, between 2000 and 2005. KP Kaufman hasn't entered into one of those type of surface use agreements in recent years.
Thank you. And has the price, the base price that KPK requests for plugging and abandoning a well in a project like you've described increased materially in recent years?
No, the standard starting price per well required by KPK has not really increased in many years.
Thank you. Do you recall hearing the testimony of Mr. John Lee for the town of Frederick?
Yes.
And Mr. Lee used a diagram for one of his developments, I believe, that had green and orange dots on it for wells in that subdivision.
Yes, I do recall.
Killian has brought that slide up. Do you recognize this slide?
Yes, I do.
Do you have any concerns about the accuracy of Mr. Lee's testimony regarding these dots, the green and orange dots on this diagram?
Just a slight correction that the orange dot, which highlighted P&A wells, it was indicated that all the green wells, the producing wells, were KP Kaufman's, and the orange ones were generally other operators. In fact, just a correction point is that the well in the left corner there, the Champlin 86, Amoco B6, a little bit to the right, a little with the orange one, was in fact plugged by KP Kaufman Company in the mid-90s, and then moving over to the other side on the right, one of the Woolly Unit number 2 well was plugged by KP Kaufman Company in 2008.
Thank you for that correction. Have you reviewed turning to the testimony of Mr. O'Byrne, have you reviewed the report of Mr. O'Byrne prepared by for the city of Dacono?
Yes, I have.
And are you familiar with Mr. O'Byrne's education and training generally?
Yes, he's a certified professional landman, which I share that same certification and designation.
Does that training enable him to expertly value and assess reserves and future production potential for specific oil and gas leases and wells?
As discussed earlier, no, it does not. Generally, those type of reserve analysis are for petroleum and reservoir engineers who model their analysis and use certain engineering metrics to come up with a reserve analysis value.
Thank you. Is it your understanding that Mr. O'Byrne asserts KPK's vertical wells can be plugged because other operators are completing and producing from horizontal wells that may hold KPK leases, otherwise that lost with P&A?
Yes, I believe he claimed that the trend in the basin has been to plug vertical wells in favor of drilling horizontal wells. However, while horizontal wells in these situations do hold these leases, KPK's vertical wells are producing out of a different formation, and KPK has no ownership in these horizontal wells being drilled, unlike the other operators which he listed.
Mr. O'Byrne account for the risk of having a third party's wells holding KPK's leases with third party production?
No, he does not.
Does he consider the benefit of well workovers, acidizing wells, refracking wells to enhance future production from KPK's wells in Dacono?
No, he does not, and those methods have been available and were utilized and are still available for KPK to realize increased production from these primary reserves.
And this would include wells in the city of Dacono?
Yes.
Setting aside Mr. O'Byrne's lack of engineering qualification to render a petroleum reserves evaluation, he uses a number of assumptions in his report, City of Dacono Exhibit E, correct?
Yes, he does.
Do you have concerns with those assumptions that he's making?
Yes, with specifically with respect to the net revenue interest, or the NRI, very few of KPK's wells in this area are burdened by any overriding royalty interest and thus operate at the original 12.5% royalty rate. And additionally, he overstates the applicable ad valorem and state severance tax for these issue wells. They are in 15% as he stated, but much less.
Thank you. What about his assumptions regarding lease operating expenses for the issue wells? Do you have any concerns with those assumptions?
Yes, as also discussed this morning, he does not know the expenses as he admitted to, and thus his assumptions are just that. And secondly, given KPK's vertically integrated company structure, the LOEs in which KPK can operate their wells is at a much lower rate.
That's lease operating expenses, LOEs?
Yes, lease operating expenses.
Thank you. Mr. O'Byrne also uses a 4-year look back at historical production trends as part of his valuation methodology, claiming it to be commercially reasonable. Do you have a concern with that approach?
Yes, I do. Specifically in this situation, those 4 years included the 2020 and 2021 global pandemic, also the imposition of the ECMC's 901A director's order to shut in many of the wells, these wells being included in that, as well as the diversification of all of KPK's available resources to remediation with no production enhancement expenditures under the former compliance plan agreement. So these were unique circumstances in these past 4 years and not reasonable representation, in my opinion.
Thank you. Mr. O'Byrne also asserts that KPK's issue wells are not marketable in part because KPK has not sold any wells in the last 5 years. Do you agree with that assertion?
No, I do not, because KPK has not sold wells in the last 5 years. And in fact, during those last 5 to 10 years, KP Kaufman has actually purchased 130 Sussex wells or so to increase KPK's position of this asset base in the basin. Also, KPK is currently marketing the Spindle Field and other Colorado assets with Petrie Partners, as was mentioned in the August hearing.
What about his reliance on the lack of new vertical wells being drilled and produced from the Sussex, Shannon, Codell, Niobrara, and J Sand formations?
KPK believes that it's much more cost-effective and less impactful to extract these reserves from the existing vertical well bores.
Thank you. Mr. Mailer, I'm bringing up KPK rebuttal exhibit UU in screen share, or Mr. Killian is. Do you see that?
Yes, I do.
Do you recognize this exhibit?
I do.
And what is it?
This is an exhibit that highlights a number of Sussex horizontal wells that were drilled in this basin.
Who prepared this exhibit?
It was prepared by myself with the help of Lily Clark, one of our engineers, and Jeffrey Kaufman, our president.
Whose horizontal wells are shown on this exhibit?
There's one KPK pilot well, and then there's also, looks like 5 Oxy or Kerr-McGee wells that are on this map.
And those are shown with the flagged labels and then the purple lines. Are those the laterals of the horizontal well?
Yes.
Thank you. And what is your understanding of the relative success and production from these wells?
Well, as you can see from the initial production rate of these wells, they highlight the value of the wells, and they've actually maintained very favorable decline rates and continue to produce even today.
Thank you. In light of Mr. O'Byrne's assertions regarding the lack of value of Sussex vertical wells owned by KPK, what is the significance of these horizontal wells having been drilled and completed into the Sussex formation?
It shows that there's still significant value to this formation in the basin.
Thank you. Did you watch the town of Frederick's presentations and arguments at the August hearing, Mr. Mailer?
Yes, I did.
You recall the PowerPoint slide deck that corresponded with the town of Frederick's presentation?
Yes, I do.
And we're going to actually move to some slides in that presentation.
Okay.
Mr. Killian would pull up the first such slide. You recognize this slide, Mr. Mailer?
I do recognize it.
What does it show?
It shows a handful of KP Kaufman wells with lease roads and flow lines and tank batteries.
Do you see the lease roads indicated in yellow?
Yes.
Are any of those common access roads with other operators?
Yes, a handful of those were and are shared access roads with other operators. Furthermore, the tank battery box there in orange is highlighted as being KP Kaufman's battery, which it is not. There is no battery on this site for KP Kaufman Company. And in fact, the only battery on that site belongs to Oxy. Furthermore, this land is platted and for future surface development for building additional housing.
And those errors, common access road, battery not being KPKs, would affect the acreage calculations made by Dr. Alward, would they not?
Yes, they would.
Okay, next slide, please. What does this next slide show, and do you recognize it?
Yes, I do. This too has a number of KP Kaufman wells with boxes around them indicating this. Some of these wells are co-located wells with other operator, thus the access roads that are on them belong to not exclusively to KP Kaufman Company, as well as some of the tank batteries, which are highlighted here, are also co-located batteries.
So those would not be an exclusive reclamation obligation of KPKs?
That's correct.
And that also would result in an overestimate of acreage requiring reclamation by KPK?
Yes.
Next slide. What does this next slide show?
This slide also shows a number of KP Kaufman wells with access roads and flow lines, as with some of the other slides shown here. Some of these access roads were shared access roads, and also in the bottom left corner, that piece of ground is platted and for future surface development and housing development, and also is under an existing surface use agreement for that parcel of land.
Very good. And next slide, Mr. Killian. Do you recognize this slide as well, Mr. Mailer?
Yes, I do.
And does it have some of the same, raise some of the same concerns you've been addressing?
Yes, they do. In particular, I'll just point out a couple, and starting from the top. The yellow roads that they show there are shared access roads with Crestone Peak has their field yard out there, along with Rocky Mountain Midstream Company. And also they identify, coming from south to north to that David Howard B number 2L, that is not KP Kaufman's access road. And also the existing access road that KP Kaufman might use for that is a shared one with the ditch rider in that area. Moving along down towards the battery area, the red box, which KP Kaufman estimated as the area for the battery, is actually where KP Kaufman's battery is. There is another portion of it which is used by an A1 septic company, and therefore the access road going in there is again a shared access road.
Thank you. So that also would result in an overestimation by Dr. Allward.
Yes.
Next slide. Thank you, Mr. Killian. Mr. Mailer, do you recognize this?
I do.
What can you tell us about this slide and your concerns about reclamation acreage?
Starting with the image on the left, the wells here, particularly the Gilson 4 and the Gilson 2, are co-located areas with a different operator. Thus, the access roads service both operators. And the wells on the left side of it, the Gilson 1 and the Gilson 5, is also an area which is going to be developed in the future for a future school site.
And do you have any, I guess you spoke to the roads, therefore are shared access roads because of the co-location?
Yes.
Thank you.
And then moving to the image on the right, similarly, the Gilson battery there is a co-located battery with a different operator, and thus the access road and the size of the battery is also overly stated.
And did you prepare acreage calculations for KPK's estimates that account for these co-locations and reduced acreages?
Yes.
Next slide. Do you recognize this slide?
Yes, it's a blown up version of the previous slide, and you can see the other wells more clearly delineated and the other equipment clearly delineated in these slides.
Thank you. I'd like to ask you then just generally about roads that KPK uses to access its facilities. Are lease roads for KPK typically full of gravel and road base that needs to be removed as part of reclamation?
Generally not. These roads, are generally just dirt roads, sometimes 2-track roads that run through agricultural land, not heavily filled with road base, and thus the reclamation for these roads wouldn't be that significant.
Any other concerns that you have with respect to the prior testimony, Mr. Malin?
Just in general, a lot of these locations, as we've mentioned multiple times, have been they are platted for future development. Developers have assumed the reclamation responsibilities. When it comes to agricultural land, most of the time, the reports we get back is the farmers or the tenant farmers request that we just compact the roads, and they'll go ahead and plant it as they see fit to make it consistent with the crop and the seed that they use for the rest of the field.
Do they typically require KPK or request KPK to bring in topsoil or significant soil amendments?
Just a certain layer of topsoil, but nothing of significance.
Any other concerns before we stop? Very good. That concludes my rebuttal examination of Mr. Mailer.
Mr. Boudreau, any cross?
Nothing from staff from Mr. Mailer. Thank you, Mr. Chair.
Mr. Sura?
Yes, briefly, thank you. Isn't it true that a number of the wells that you have in the, say, the Dacono and Frederick area, you only own the well bore, you don't have the underlying surface minerals?
No, that's incorrect. AP Kaufman owns from the surface to the base of the Sussex Shannon Formation, all rights, all depths up to that formation.
But you can't deepen those wells. Is that correct?
That's correct, but we can perform refracts or acidizing operations on our existing formations.
And you talked quite a bit about access roads and pointed out a number of access roads that were either shared or were not going to be the responsibility of KP Kaufman to reclaim. But there are access roads that only access your facilities, isn't that correct?
Yes, there definitely are some.
And there are definitely some that have gravel.
You know, there might be some that have gravel, but the vast majority of them don't.
And you can testify today that the vast majority of wells are not serviced in Frederick are not serviced by gravel roads.
I definitely can say that I've probably been to all of the Frederick wells that are there. I don't recall on a well by well basis, but the majority of the access roads that I go on are generally dirt roads.
Okay, no further questions.
Mr. Lewis Prescott?
Briefly, thank you. Good afternoon, Mr. Mailer. How are you?
Good afternoon.
How long have you been with KPK? I heard you've had a lot of positions there. How many years have you been with the company?
About 17 years.
Okay, fair to say you're a pretty loyal employee.
I would hope so.
I want to talk about those horizontal wells drilled to the Sussex Formation. I think you identified 5 or 6 in that map that you showed. Is that all the Sussex horizontal wells that have been drilled?
To my knowledge, yes.
And I interpreted your testimony to be that these are pretty productive, pretty good wells. Was that your testimony?
It was.
Okay, and how many of those did KPK drill?
KPK drilled one of those.
Okay, and that was the NRC 9915H, right?
Yes.
All right, let's do a share screen here and take a look at the ECMC mapping system. Is this well here, right, in section 9?
Yep.
All right, and here's the well. KPK operates it. And here's the production data from it. Let's go back to when it was drilled. It IP'd at about, let's see, best month, 1,100 barrels. Is that right?
Yep.
4,600 MCFs. Is that right?
Yeah, those are the numbers.
Yeah, we're talking about the best month of this horizontal well. And today, we're looking at down to 16 barrels in a month. Is that right?
That's what it says, yes.
And then a lot of months, 14 MCFs in a month and no MCFs for some months. Is that right?
Yep.
How much did this well cost to drill, Mr. Mailer?
I don't recall offhand. I will say that if you look at the lateral, this was a pilot test well. The lateral is much shorter than a regular horizontal well. It's about 1/4 of a mile as opposed to a full mile. This was drilled back in, I want to say 2010 or 2011 as a pilot program, which KP Kaufman was looking to develop the field horizontally in the Sussex Formation. And this was the first well tested with that.
And remind us how many wells you've drilled since that first in the pilot program.
We haven't drilled any subsequent to that.
And Mr. Mailer, last question. For financial assurance, you agree that we can't assume reclamation will be waived by a surface owner, right?
That is correct.
Thank you. Nothing more.
Commissioner Messner?
Thank you, Mr. Chair. Mr. Mailer, thank you for being here. I do have a few questions for you because I'm a little confused by some of your testimony. Is it your belief that in the rules it allows for, a calculation or a determination of reclamation costs or reclamation expectations in submitting, required documentation associated with demonstrated costs that future use can be considered in determining cost, whether that's a subdivision or whether there's some other use that's being contemplated by the landowner?
I don't think that it plays into it.
So really, this consideration of future use is, not really relevant to what we're talking about here. Is that correct?
It was just to point out that a lot of these locations are going to be developed and are in the, right about to be developed.
But in determining demonstrated costs, they're just not relevant, correct?
Sure.
Okay. As far as determining materials associated with access roads, you understand that stormwater management is a critical part of maintaining an access road associated to sites.
Yes.
And on these sites, should someone go out and visit them, 2-track dirt road without any kind of surface material associated with them, do you believe that that's proper stormwater management associated with an access road to an oil and gas facility?
I think it would depend on a case-by-case basis.
Okay. I think standard stormwater management practices may differ with your determination in that. As you look at these shared roads that you indicate, do you think that because it's a shared road that it exempts KPK from determining any kind of cost associated with that access road?
No, I don't think it exempts KP Kaufman of any costs related to it, but it doesn't imply that it's all on KP Kaufman Company.
Can you show me in evidence that's been provided by KPK and demonstrated costs where you've done the calculation on these shared access roads and how you've calculated that linear foot associated with whatever percentage you determine your shared access is when you're determining what the demonstrated costs were associated with that access road and the different even exemplary sites that you've provided?
My involvement in this was to provide the areas that were associated with specifically KP Kaufman in terms of coming up with the reclamation costs. I wasn't involved in that.
Did you consider any percentage of shared roads in the acreage that you provided, whoever was determining this?
Yes, I believe we did.
And what percentage did you allocate?
I think ultimately the determination was the area that was actually KP Kaufman's. So therefore we would.
So if it was a shared road, you didn't actually calculate it.
We probably associated half of that cost to KP Kaufman Company. But again, if we were
reclaiming. Did you probably, or did you? I mean, I'm asking a specific question here.
If I may, Mr. Commissioner, I believe that our next rebuttal witness, Mr. Peterson, who prepared Exhibit S, with Mr. Mailer's assistance, can answer your question more completely.
Well, I'm assuming that this witness is the one that determined the acreage as he's indicated in his testimony, and so I'm asking this witness.
That's fine.
I provide, sorry.
Go ahead and answer the question.
Yes.
I provided the area and they incorporated into it.
And how did you determine the area associated with the shared roads, or was that not a consideration?
Well, it also depends upon, the assumption is that if we are plugging our wells or abandoning our wells, we can't reclaim the road if another company is still using it.
but you're still responsible for some portion of that road, correct, in your calculations?
I believe we used a sort of an average of half of the area to. I'm sorry, the half of the cost to reclaim that road, given that it's a shared access road.
And there's documentation that I'll be able to look up in the evidence associated with that statement.
I assume so.
Thank you.
Commissioner Cross?
Thank you, Mr. Chair, and thank you, Mr. Mailer, for your testimony today. Commissioner Messner asked a couple of my questions, so I want to focus on a couple of the other parts of your testimony. Towards the end, you were talking about some of the landowner, and I think you said most landowners request that you just decompact the soil and move on from there. What percentage?
I don't know. I don't have a percentage, but in terms of my experience with tenant farmers, or that's been the request of them.
And how many of those tenant farmers, how many of these locations have you gone through reclamation on?
Recently, a handful. I don't remember the exact number of wells that we've plugged in the last number of years, but some of them were with tenant farmers that I mentioned, and also some were lands that were being developed, and thus the reclamation was assumed by the developer.
And can you point to any of the variance requests for any of those where it wasn't assumed by the developer, but can you point to any variance requests where they said, let's not go through the full reclamation, let's only decompact the soil?
You're saying not the developers, or are you saying in any case?
So you mentioned developers there, so let's set the developers aside that may have assumed any reclamation on it. But you talked about most landowners, most tenant farmers, when you're looking at this, they don't want full reclamation. They just want you to decompact the soil and they'll go on planting as they want. And so, and I'll kind of give you an idea of where I'm going here. For what do you have? 1,200 wells KPK has approximately?
Give or take, yeah.
And for the reclamation aspect of this, not talking about remediation, just with the reclamation aspect of this, you're wanting us to look at 18 exemplar wells. And what I'm trying to understand is, I would like to know if those 18 exemplar wells are actually exemplifying what the overall 1,200 wells are like. And so when you're telling me that most landowners are saying, no, don't reclaim this, just decompact the soil, I'd like to see some kind of evidence showing that. I mean, not just, oh, well, this was taken into account. Do you have variance requests showing that? Do you have numbers of how many have said that, how many percentages? Because if you're looking at 18 out of 1,200, that's a pretty small amount. And so I can see, as we went through this presentation of your rebuttal here, where you're saying, Dr. Allward said there was more acreage than what KPK put forward. And so you responded to that. But I'm kind of curious how this applies to the other 1,182 wells, approximately. And so Commissioner Messner brought up part of it. Are all roads shared? Probably not. Are there similar concerns about acreage? I don't know. And so what I'm trying to understand is, what about the rest of these? So how many, what percentage of landowners are telling you don't decompact? And really the way I can see this is, do you have variance requests? Do you have data? Do you have anything that you can point to other than saying, most of the time, this is what they're telling me?
I don't have any hard data because it wouldn't become relevant until we actually went and proposed to plug the well. Then you would consult with them and see how they would want reclamation done.
So if you're saying doesn't become relevant until you actually go to plug the well, when we're looking at these demonstrated costs, a lot of the costs that you've been trying to tell us is, listen, in this area, it's small, it doesn't really take that much It doesn't take that much work with the excavators because you're just decompacting it. You're not having to go through a lot of this. We don't need all this topsoil because, as you said, and again, you said most landowners just say just a layer of topsoil, nothing of significance. And so this is what I'm trying to understand, because we have some parties saying you have to pull in at least 6 inches of topsoil, and you're just telling us most of the time what we hear is you just need just a small layer of topsoil, or just decompact it, we'll take care of it. But I need to try and see some kind of evidence that says this 18 exemplar wells and what you're putting forward as data for these 18 exemplar wells is really going to exemplify what's happening in 1,200 wells across the northeast part of our state.
Understood. I can go off some prior wells that we have plugged, and in those situations, I can think of one offhand. It was a similar request that they wanted us to work with their tenant farmer, pay for their seed, decompact the road, and then allow for him to plant it and him to do what he wanted.
And when was that well plugged?
In the last 2 or 3 years, 2 years, I think.
And so was there a variance that was submitted with respect to asking for not full reclamation?
It was incorporated into an agreement, and then it was presented when we went to file the forms with the COGC at the time, and it was part of that variance.
Okay. And so you said there's one example within the last 2-3 years. Can you provide other examples to try and give us an idea? As you said, most. And so I'm just trying to understand, when you say most, is most 50%? Is most 95%? Can you point us to something? I'm just trying to understand.
I can't give you an exact number at this point.
Okay. But as Commissioner Messner went to, until something actually comes forward, whether it be with a variance, whether it actually comes forward with a developer taking it on, until that school is built that you talked about in your rebuttal, until that happens, it's still presumed that you have to do full reclamation under the ECMC rules. Is that correct?
Yes.
And so
yes.
any kind of demonstrated cost is going to have to go to that full reclamation under the ECMC rules, not an anticipation of a variance.
That would be fair.
Okay. The other thing that I wanted to try and ask about, since you've been talking about the plugging and abandonment of the wells, and I think this is a vital part of it, and we haven't really gone into detail throughout this hearing on it, but the asset retirement plan for KPK. Have you worked on the asset retirement plan for KPK?
Not particularly.
Have you worked on it at all?
No, I'm not a planned asset retirement plan. No, I have not.
Who would be an appropriate person to testify about the asset retirement plan for KPK?
I would probably say Jeffrey Kaufman, the president of the company.
Okay. So even though you didn't work on it, are you aware of what the asset retirement plan is with respect to plugging and abandoning wells?
Like with all companies, you want to analyze if there's future reserves and value to the wells, and then schedule a time to plug them if you don't think that they're profitable anymore.
And have you seen what the asset retirement plan is in terms of when wells are going to be plugged? At what point in time you decide to move on from continuing to produce to plugging? Have you seen any of that information?
Right. We still think there are additional value to each of the wells. Obviously, there's exceptions to the case. But so in terms of a official plugging program, we don't have wells slated for that. But we are constantly evaluating each well, and like mentioned beforehand, we are actively marketing this Spindle Field and other Colorado assets. So in terms of plugging them, our focus either is to continue to produce them or to divest of them.
Okay, so just so I heard that correctly, you don't have any current plans to plug any wells. The current plan is to either try and sell the wells off or continue to produce.
Correct. I mean, we might have other, we might, and, there might be some discussions within the engineering group of they've identified a well that they think needs to be plugged. And I know we're plugging, or we recently just plugged a well, but in terms of a full-blown plugging program in the immediate future, we don't have that right now.
You are aware that the financial assurance rules require KP Coppin to submit an asset retirement plan, though, correct?
Yes.
And you're just not aware of any, at least for the immediate future, aware of any kind of plan to retire any of the assets for KPK.
I'm not aware.
Okay. And you said Mr. Kaufman is probably the best person to ask about that.
Yes.
Okay. Thank you. That's all the questions I have for right now.
Further questions for this witness, Commissioner Ackerman?
Thank you, Mr. Chair, and thank you, Mr. Mailer, for being here today. I wanted to make sure that I understand that last point by Commissioner Cross before I go on my questions. So to your knowledge, is there a cohesive KPK asset retirement plan document in existence?
I don't know of one, meaning, like I said, Mr. Kaufman would probably be the best one to answer that question.
Thank you. And you've been with the company 17 years?
Yes.
And remind me, I'm sorry, your title?
VP of Land.
Okay. Thank you. We've talked, I wanted to kind of talk a little bit about this reclamation assumed by other types of developers. This has come up from time to time a little bit today and in previous hearings, in which I understand that in response for monetary compensation, KPK relinquishes its rights and walks away from a site, assigning that responsibility to plug, abandon, reclaim, retire, remediate to other companies. Has this happened as far as you know?
Where a developer has assumed those responsibilities?
Yes, with regard to KPK assets.
Yes.
Gotcha. And is this a strategy historically and or currently used by KPK, assuming that some of those sites, if they hang on to them long enough, will be reclaimed and remediated in those developable sites by other types of developers?
Not especially, obviously, as we've seen from other testimonies, the extension from Denver to Greeley is expanding, and there's a lot of development there. It's not that KB Coffin happens to be that these wells that were drilled in an oil field, and now the development is coming in onto that field. So it's not that we are holding on that it's going to be developed, but when we are approached by developers, then we discuss these possibilities.
Thank you. So if I'm understanding correctly, there aren't any additional sites from this point forward that KPK assumes will be cleaned up in this manner?
Well, we are, like I mentioned, we are under discussions and negotiations with certain sites, but in terms of the other ones, that is correct. We are not assuming that it's going to be handled by someone else.
Thanks. Can you tell us approximately how many of these occurrences there have been with regard to KPK sites?
Where the developer assumed reclamation responsibilities?
Yes.
Couldn't give you an exact number, but I couldn't give you an exact number. No.
Yeah, I understand. I'm just trying to get an idea of if this is a one-off or a handful or, 25% of urban assets.
I mean, I would say in the last number of years, we've plugged probably north of 50 wells, this type of arrangement.
Gotcha. So in the last couple of years, you say? So it is a significant portion of your cleanup business, whether it's pursued or not at this point. Would you agree with that?
I mean, it's just the reality that we've plugged wells for development, and that assumption by the developers has been exercised.
Thanks, Mr. Mailer, for helping me understand how that's working on the ground. Would you agree that regardless of whether or not this may or may not occur in the future, the ultimate cleanup, plug abandonment, reclamation, remediation work should be adequately planned for by KPK?
Yes.
Thank you. Nothing further, Mr. Chair. Thanks.
Further questions for this witness? All right, redirect, Mr. Jacobs. Mr. Sura, you've got your hand raised.
Yes, I do. I just have a quick follow-up on Commissioner Messner's. It'll take 2 minutes.
All right, we'll allow that, and then we'll let Mr. Jacobs with redirect.
Thank you. If I might share my screen. Mr. Mailer, can you see that? Or should I? It's the Raleigh J. Vincent. It's Exhibit D, page 37.
Yeah, I see.
Do you see where it says seed and it's done by acre?
Yes.
Are we to assume this is the only area where we see seed mentioned? Is that correct?
Appear that way.
Yeah, and so you would assume that this acreage is going to include everything that you need to reseed?
Seen that, yeah.
Okay, so then if you had an access road that needed to be reseeded, it would be in here, correct?
If I may,
I would rather not be interrupted if I could. I'm almost done. You'll have a
Go
chance.
ahead, Mr. Sura, unless there's an objection.
So that was 0.86 for seed, and we have 0.78 plus 0.08, which is 0.84. So 0.86, that is. So you have not accounted in this case for reclaiming this access road, have you?
In terms of the actual breakdown of costs, I think Mr. Jacobs said that Mr. Peterson was much more involved in terms of calculating those.
Okay, well, no further questions. Thank you.
All right, redirect, Mr. Jacobs.
that Exhibit D, Mr. Mailer, that you were looking at, Mr. Sura projected on screen share. You did not prepare that, did you?
No.
And you had no involvement in its preparation?
In the cost, no.
Okay. That's all I have on redirect.
Okay, this witness may be excused. Do you want to call your next witness, Mr. Jacobs? And I note for the record that Mr. Sura is going to be available for the afternoon, so we're not going to have a hard stop at 2.
Oh, very good. Yeah, well, give us a moment, maybe take a couple minutes to get our witness into the witness room, and we'll get going here shortly.
Who should I elevate?
Witness is John Peterson. He's already been sworn in.
Okay, we're working on getting him. Mr. Peterson, if you want to visualize yourself and unmute yourself, we'll be able to get going.
Yeah, I'm ready.
Afternoon, Mr. Peterson. Welcome back. You've been listening to the testimony of staff witnesses and the witnesses of the relevant local government parties during this hearing, haven't you?
Yes, I have.
And you've also listened to the questions of those witnesses by commissioners and party counsel.
Yes, I have.
I'd like to ask you some questions regarding some of the assertions made by those witnesses in their testimony and in response to questioning. First, I'd like to ask you about prior testimony of Deputy Director Cuthbertson concerning reclamation expenses in Weld County, where KPK's Spindlefield wells are located. Do you recall the Deputy Director indicating that based on Orphan Well Program data, he concluded that reclamation costs for location for small wells like KPK's commonly ran from $8,000 to $10,000 and was therefore reasonable?
Yes, I recall that.
You agree with that testimony?
Yes.
Are there reasons for that?
I think our locations don't require significant more reclamation, even when you're applying the SBAP factors. I believe that our reclamation costs and the needs that we need to perform are similar to the reclamation requirements of the other operators that have already submitted reclamation costs and approved costs for reclamation in those same areas of Weld County.
In your memo prepared last August addressing those SBAP factors and finalized after KPK's financial assurance plan supplementation was submitted, did address those factors. Is that correct?
Yeah, I think concern was that wanted more detail and backup on the reclamation costs, which is what we did. We began preparing that for supplementation, and as I testified, the memo did not get reflected in our supplemental submission of costs. Nevertheless, in the memo, the factors don't really move the needle. The small footprint, the lack of slope, the frequent lack of high priority habitat, the absence of salt kill, absence of lots of sites with sandy soil. So I don't believe that those factors are significantly impacting the final reclamation cost calculated.
Thank you. You recall the testimony of the relevant local government witnesses concerning the alleged inadequacy of KPK's estimated reclamation costs for wells in their jurisdictions and also outside their jurisdictions, based in part on the assertion that KPK's selection of 18 exemplar wells for the preparation of P&As and the estimation of reclamation expense was inadequate?
Yes, I do.
Did you and your colleagues attempt to address that concern of the city of Dacono and town of Frederick since the August portion of this hearing?
Yes, we did. We selected another 16 wells in Frederick and Dacono and did a site-by-site evaluation of the likely reclamation expenses associated with those locations to determine our prior reclamation estimates were inadequate or not.
And is that estimate based on 16 wells in Frederick and Dacono captured in KPK's rebuttal exhibit VB?
Yes.
Who assisted you in the preparation of exhibit VB?
So we got assistance from Quandary Consultants to help develop the cost model and a few of the input values. And then Lily Clark, myself, Jeffrey, also integral in that evaluation. They have all the site-specific knowledge about the assets, the size, where the shared facilities are, lease roads, tank batteries, other nearby operations, and so forth. So that's what we use to redevelop the costs.
Thank you. And you mentioned Jeffrey. That's Jeffrey Kaufman, the president and COO.
That's correct.
Thank you. I'm having KPK exhibit VB brought up on screen share. We'll need to zoom into that.
And I'm going to raise an objection at this time.
Go ahead.
Just as the commission struck additional reclamation testimony submitted for this round of the hearing related to reclamation from Frederick. This is entirely new reclamation information prepared by KBK that was not part of their initial reclamation presentation. So based on the commission's order related to what this presentation will pertain to, I mean, it's clear that this was just created for purposes of supplementing their original reclamation presentation. It doesn't seem that it's proper. Again, what's good for the goose is good for the gander. Frederick can't do it. I don't think KBK can.
Frederick would like to join in that.
Mr. Jacobs.
This is proper rebuttal. We were constrained at the time that the commission continued this hearing to, in our supplemental pre-hearing statements, only address remediation, but we had not provided rebuttal testimony on all of the issues raised in our case in chief. This is entirely proper rebuttal to the concerns raised by Frederick and Dacono.
And if I may.
Yes, Mr. Lewis Prescott.
For the original case management order, our presentations were made available weeks before the hearing in August. KBK knew exactly what the presentations were going to be with respect to Wells and Frederick and Dacono, what the testimony would be related to reclamation based on multiple rounds of briefing. The rebuttal related thereto should have been presented as part of the reclamation presentation. It's now being presented based on the time provided only for remediation evidence. So I maintain my motion that this should be stricken and not admitted into evidence, and no testimony should be taken based on this exhibit or related thereto.
AG Boudreau, did you want to weigh in on this issue?
Staff's going to take no position.
Okay. Mr. Jacobs, what part of this line is rebuttal?
We're rebutting the concerns of Frederick and Dacono that we've evaluated insufficient number of wells. We did the same reclamation analysis for 16 wells, I believe 10 in Frederick and 6 in Dacono, to specifically address the concerns that we have somehow been inadequate in evaluating the exemplar wells. You'll recall that the deputy director was fine with our approach of 18 exemplar wells for purposes of downhole P&A estimation. We wanted to address and rebut the concerns that somehow, and you've heard throughout their testimony, these are hand-picked exemplar wells. There are only 18 of them. This doubles the number of wells, and it specifically addresses a significant number of wells in the jurisdictions of the government parties. So it is entirely proper rebuttal, and I would like this witness to be able to explain how they went about preparing it.
Is it true, though, is it not, that the issue of inadequacy has been kind of a seminal part of the cases from others throughout? It's not like this just arose in the last day or so.
No, not in the last day, but again, our opportunity to rebut having been, we hadn't started rebuttal when the hearing was discontinued. We had done our direct, and we have had since August to prepare this and to look at these sites, and we did so. And we provide this as a rebuttal exhibit.
Mr. Lewis Prescott?
What I heard Mr. Jacobs just state is that they are simply supplementing their case in chief on reclamation, which is open and shut already.
All right. I'm gonna let this in. Again, we are lay commissioners. We're trying to get to the heart of this. Let's move on, Mr. Jacobs.
Thank you. Mr. Peterson. Can you please identify the locations evaluated in Exhibit BV down the leftmost column as Mr. Killian scrolls down the second page of that exhibit?
The Morgan A2, the Gilson 5, the Gilson 4, Lanson Farms 15, Pace Connolly 5, State 9, State 6, Upper Pan Am AE6, the Grant 1, the Champlain Amco B5, Dacono Investments, Lepla State 4, and Hutchins number 1, the Blanche Hopkins 2, Foreman Unit 4, the Upper Pan Am I-21.
Thank you. Now let's have you please call out the column heading scanning across the top of the second page. If you
Sure.
would.
The first 6 are identification parameters. The API number, battery number, battery name, its location, which municipality it sits in, and the number of wells that feed that battery. We also have various comments about the conditions of the site. The well acreage is how we what the assumptions were going into estimating the well acreage. What the scope of work was associated with the wellhead estimate for reclamation. And the next column is the downhole P&A cost specifically. The next area is the acres of the well head itself. The truckloads for the hauling of road base out, road base trucking costs, road base removal, site prep, miscellaneous site prep costs, wellhead costs. Then we get into the tank batteries themselves, the acreage and the information surrounding that specific tank battery, the costs and basis associated with those, amount of the size of those batteries, the truck loads of road base requiring removal, same as for the wellheads, site prep, same as before. We got the topsoil in there, and total tank battery costs. So we look at that total tank battery cost, and I think this is an important part to bring up when you're looking at the presentations, both from us and from the other parties about reclamation costs. There's a lot of it's easy to confuse and commingle or double dip wellhead reclamation with tank battery costs. And I was just looking at the numbers. KPK has about 300 tank batteries and about 1,200 wells. So about 75% of our wellheads don't have are not co-located with tanks. And so the size acreage that you would use for those 75% of the wells is going to be smaller than the ones that you would assume for tanks. So what we did in our estimate was we grouped all the tanks together, divided them out by the per locations of wells that are feeding them, and then we did the wells and the lease roads independently, and then summed them together.
Thank you. And beyond the issue of the tank battery allocation of acreage to wells, can you describe how the information on this exhibit BV page 2 was utilized in evaluating or preparing the spreadsheet developed for you by Quandary Consultants?
Can you repeat that question? I'm sorry, I was distracted.
Sure, no problem. We just reviewed the column headings. You described some detail on the tank battery allocation, but I'd just like you to describe the information on the page and how it was utilized in the evaluation using this spreadsheet prepared by Quandary.
Yeah, hold on just a second. If you look at there's some other slides I think that we brought up.
Here's the first page. Yeah. Describe that.
Yeah, so these are some of the unit rates that go into that model. It has the per acre costs of reclamation, all the seeding, decompaction, stormwater, topsoil, and then as well as equipment costs on the unit rates. So that's how those numbers were derived. And then we went through and calculated the areas again and did the multiplication out, obviously separating out the tanks from the wells themselves so that we could get a number that a per acre number out of that calculation.
Very good. So could you please summarize your conclusions regarding reclamation expenses anticipated for wells in Frederick and Dacono based on your preparation of Exhibit BV?
Yeah, as we were going through trying to understand the claim about it being adequate, the biggest conclusion was that a lot of the original estimates that we put in for our reclamation areas and the tank batteries and the wells was smaller than what we originally estimated. We used an online mapping tool and aerial imagery from Google Earth to define what the land reclamation needs were. And then we had a detailed map outline of those areas for each of the 16 sites. And then secondly, we learned that the original estimates didn't factor in much of the shared facilities where the operators use the same roads that we do in order to service the locations. So we had to reduce the footprint of the anticipated reclamation area with the understanding that those operators would continue to use those facilities if we're not operating. We also observed that nearly all of the wells and batteries from the list located in the municipality are still surrounded by agricultural use, which significantly impacts the reclamation costs, I think, downward. We compiled all that data, created a heuristic value for reclamation per acre of land. It was $22,033 per acre.
Thank you. And how do those calculations for wells for reclamation of wells in Frederick and Dacono compare to the RLG party's assertions regarding reclamation expense anticipated for wells in their jurisdictions?
They're significantly less, and I think I can explain the reason for that if Cole could bring up some of the maps that I had referred to. So this is facility 4. You can see the reclamation area is that we are responsible for is in blue. The rest of that site is DCP, and there are gates along that northern fence line, 2 different gates, and so they use the turnarounds in those areas. So the area of reclamation for this site is smaller than what you might intend just looking at the aerial photographs. There's a couple of others like this. I'll show you if you could scroll down. This is just how we're calculating the lease roads separate from the other components. This is the tank battery being calculated separate from the wellhead itself. Keep going down. This is the wellhead calculation so that we sum those together. Keep going down. Here's a example, and there's quite a few of these in our field where there aren't any lease roads remaining to the wellhead. And so those areas would be overestimated if you were adding a random number of lease roads to those. The other thing is that that battery on the left, that's an Oxy battery. I have to pull my notes specifically to these maps because I don't want to cite the wrong operators as we go through. You can go to the next one. This and Avi talked about this one. Cresto Peak and us joining that, so the estimated reclamation area for that site would be lower than what the city or others would have estimated just by looking at the photos. The next one, you can see this is a place, that little square just north of our panhandle there. That's a Crestone Peak well, and so our assumptions about flow line reclamation, lease road reclamation in the wellhead stop at that point, and that road that's on the west side of that whole picture there is the ditch road that the ditch riders use, as well as Crestone Peak and KPK. And so those types of areas wouldn't necessarily be reclaimed as part of the oil and gas operations because there's multiple uses by the surrounding landowners, the other businesses that are operating in the area, as well as other operators that are producing oil and gas. You can keep going down. The Gilson 4. So if you were just thinking about the Gilson 4, you might encircle this whole area. But what's hard to see on this map in the lower, I guess the southeast corner of that is a crescent or a Crestone Peak well, and so that site is accessed with the same roads that we are, and they would be responsible for claiming the area around their well. Go to the next one. It's an example of our wellhead location. That area to the west is a landowner maintenance facility of some sort, so we wouldn't include that. Next one down is the Upper I-21. You can see no lease road there either. So that's why those portions weren't included except for right at the entrance. If you scroll, or you can't see it, I guess it's on the next map. Scroll down. You can see the little area for the lease road that we assumed for that one. The I battery. So scroll down one more. This is the I battery. So there's our tank battery location. The well itself is a spot that's lower or further south, but that other that lease road that's north of us and west of us, and the circles, all that equipment is oxy. That big facilities oxys, the wellheads oxys, and so they have to have access to their facilities. So those weren't included in the reclamation costs. Scroll down. This is another site. That area on the west side is not part of our disturbance. You can keep going. Lanson Farms, it's not nothing significant. Same thing. Wellheads and lease roads. Same for the Pace Connolly wellheads and lease roads. The Pace Connolly tank battery. If you keep going down a little further, keep going. Right here. So there's a little road to the east of us. That's not our road. That's landowners. That's a paved road, actually. Our battery is this outlined in blue. The roads to the west of that are for business access for those other businesses that run in that area. The grant one, nothing specifically to note other than it's a two track that has to be reclaimed, not a gravel road. Go down this one. I know Avi talked about the facility 7. There's another business that's using that area, so we assumed we were reclaiming the parts that would be our business, and not that whole thing. Obviously, there's another wellhead that's right there below that tank. We had calculated that area too into our acreages. The Blanche Hopkins doesn't have anything. Go to state 6. Keep going down. This is another location where there's an access road for the entire property. It's not a lease road for just our wellhead. So we excluded those types of the features in our acreage. Keep going down. The 8 and 6 is nothing of note for that one. Neither with the Champion, pretty straightforward with those. The Dacono investments, this one, that road there is a ditch rider road. It's not a KPK road, and so we didn't assume we were reclaiming that. Lepla's got pretty standard stuff. The Robert Hutchins #1, there's an oxy battery that we share with our location, so they would be responsible for that. Scroll down a couple more. No, one more, sorry, go up. And maybe this will be a better spot to save on the discussion about Mr. Allworth's testimony. So maybe I can leave those for that.
Good. What reclamation parameters do the calculations in Exhibit BB depart most significantly from the RLG party's witness testimony and argument?
The topsoil that's needed for an agricultural field is significantly different than the topsoil that you need for recreational parks, growing grasses and so forth, or even just to match the topsoil of the pre-existing pre-oil and gas type conditions. I know, and many of you already know, the topsoil in Colorado is not the greatest, and so pricing a topsoil that's grade A peat moss or with some really expensive topsoil price is not really a like for like comparison. But the seeding requirements, obviously we wouldn't reseed in an agricultural field because the farmer is going to plant their own crops there. The reclamation monitoring time frame, since most of these are agriculture areas, the reclamation time is like a couple of months, 6 months at the most, because of when the growing seasons are. So those farmers are back in there planting over those former oil and gas locations right away. Vegetation's growing up there within a few weeks, maybe a month. So the monitoring for 2 years is a little excessive in the ECMC's estimate. The recontouring and the gradient, obviously these sites are already flat, so most sites don't have any topography. The other thing was the amount of the gravel that's required for removal. Unlike a lot of the other operators up there, we don't have a lot of really thick gravel road bases, both for the locations and the lease roads. These were put in the 70s. And so additional gravel has only been brought in on areas where it's hard to pass if there was wet conditions or mud that we needed to try and control with stormwater. But in most cases, the gravel that's there is minimal, if any. And so we didn't assume, several feet of gravel road base at each location that requires removal. We assumed a lower amount, 6 inches to a foot of gravel at the most.
Thank you, Mr. Peterson. You heard a question of Mr. Mailer by, I believe it was Commissioner Messner, concerning whether or not in the lease road acreage calculations, a portion of shared lease roads was assumed to be KPK responsibility, or if that was somehow apportioned between co-located operators. Could you address that briefly?
Yeah, Mr. Mailer was incorrect in saying we did assume the percentage. We didn't assume that. We didn't calculate the co-located acreage and split it in half. Obviously, if that's something that needs to be done, we can do that. But I would note that the other operators that are co-located with us and have abandoned ahead of us didn't pay us any money or cover the costs of reclamation for the shared piece that now we are getting held to the whole amount. So it's just another nuance as far as the calculation.
Thank you. Any other concerns with reclamation costs in your rebuttal that you'd like to address?
There's a slide that Dr. Allward brought up. I think it's page 14 on this bottom of the slide. I just wanted to point out a few things on that's important for the commissioners to understand.
And Mr. Killian, bring that up, please. It would be in Dr. Allward's presentation.
Yeah, this is, I just wanted to bring up that comment again that I talked about, where if you commingle wellheads and batteries together, you run the risk of double dipping or extrapolating a large acreage requiring reclamation over a lot of sites that don't have it. An example here is the Facility 7 consolidation. So obviously he had a different calculation where he was improperly including land that wasn't our responsibility. But if you look at our number, the 1.09 acres is for that Facility 7. There are 107 wells that come into Facility 7. So the per location cost for that facility, you have to take the 1.09 acres and divide it by 107. So the per location acreage that you would apply for that is 0.021 or something like that. And I'm just pulling up the quick calculations that I did on those. Like the Briggs, that one, the 0.67 we feel is a better number than the 0.83, but there's only one well there, so that's a good number to pull across and try to average. The Elaine, there's 2 wells, so that 0.44 number we believe is a more accurate number. So the real per acre or per location size would be 0.22. I talked about Facility 7, the Vincent number one, and I can show these on those other maps that we almost got to before. The Murphy 11-5 well and battery. There's the acreage that he's got to 4.26 includes areas that have already been reclaimed as part of interim reclamation after the well was drilled, and so I think it's an overestimation to try and apply that 4.26 into your average, because it's not how much acreage requires reclamation, but it's also not representative of most of the sites that need to be reclaimed, because that was a newer drilled well when most of our wells are drilled in the 70s and the 80s. But I just ran through the numbers really quick, and the average per acre, when you account for these per wells, the average acreage per location, when you account for the wells that come into this, is 0.64 average acre per location, not 2. And so to extrapolate 2 across 1,200 wells or per locations is grossly overestimating, because of that fact that 75% of our wellheads are not with a tank battery. And that's pretty unique to the field, because back in the 80s, Amoco, in an effort to get rid of a lot of the truck traffic at all of these locations, consolidated. And so the lines and the wells and the tank batteries all were built in with underground flow lines, so that there would be less trucking, and that further reduced the impact. And you can see this on old area photographs. You can see areas from back in the 70s that used to have a tank battery that now don't. They've already been reclaimed because of this consolidation. And so if you're just taking that number and trying to apply that bigger number across all of those sites, you're unfairly discounting all the reclamation that's been done prior to KPK's ownership, and it's just misleading in the total assessment. Obviously, we disagree about the unit rate per acre, I guess, of reclamation costs. The ECMC is at 45,000. We're at 22,000. I think that 22,000 line is pretty good. 22,000 an acre, and I was looking at some of the submittals by the ECMC. On the pre-hearing testimony, Whitking Fullerton had I added up all their unit rates to get it per acre, and I think it was like $18,619 per acre. So we're above that number, but they're pretty close. It's a reasonable order of difference between operators in the same area with similar type assets.
Thank you for that explanation. I have no further questions of this witness in rebuttal.
All right, this witness is open for cross. Mr. Goudreau?
Nothing from staff this time, Mr. Chair.
Mr. Lewis Prescott?
Thank you, Mr. Chair, and hello again, Mr. Peterson.
Mm-hmm.
Going back to that exhibit VV, when was that created?
The table that we just talked about.
Yeah, the basis of your entire.
I'm not very familiar with all the exhibit labels, but if it's the table that I went through, that was done several weeks ago as part of our pre-hearing testimony submittal.
A few weeks ago,
I believe. I mean, we were working on it. I'm not sure if it was that submitted, John? I can't remember, but we worked on that since the August testimony, because the concern about the inadequacy of our numbers.
Okay, and you just applied a flat plug-in cost for all, I forget how many, 16 wells there. You just said it was 35,827 to plug each of those wells. Is that right?
I think that was the amount of plugging that was brought up in the original hearing, or in the August hearing, as the P&A amount. So that's outside of my scope. So that number is carried forward from the previous testimony or the hearing in August.
Right. And I just want to make sure I understand, because you called these 16 new exemplar wells. The other exemplar wells were identified based on the type of well that they were, and therefore the cost to plug. You didn't do that for these. You just identified wells in Dacono and Frederick, right? And then wanted to talk about the reclamation costs instead. Is that right?
Well, short of going through every single well in Frederick and Dacono, we tried to come up with a sample set specifically to Frederick and Dacono that were outside of the exemplar wells, to help people see the costing approach for the wells inside Dacono and Frederick.
And when you wanted to help show the reclamation costs of these wells, again, you didn't include any costs related to removal or reclamation of flow lines, did you?
There's the flow lines, I don't believe are in those estimates. No.
Okay. And we did hear testimony that KPK is unique and has a bunch of central facilities, and they have flow lines going to each of the wells instead of having those facilities on site, right?
Yes.
All right, so if I may, let's take another look at the ECMC GIS map here. Can you see that?
Yeah.
And we're looking at Dacono, are we not? Here's Highway 52, here's Highway 25. So here's Dacono right here, correct?
Uh-huh.
And all those black lines, those are KPK flow lines, right?
That's correct.
And for example, here we have one KB Kaufman fiberglass. Here we have one KB Kaufman HDPE. What's that material?
Plastic.
Plastic, okay. And let me ask you this, since you started in May, how many flow lines has KPK removed?
We haven't removed any. We've done quite a bit of replacement, but I don't know the full number.
KPK can't speak to the cost, or you can't speak to the cost to remove fiberglass or plastic flow lines, can you?
That's no, that's would be our construction group.
Okay, and do you know the process for removing fiberglass or plastic flow lines?
Yeah, there's in my experience, I've removed them with underground storage tanks, and I've seen them removed here in our field in the 5 months that I've been there, as well as in other locations. There's multiple ways that it can be done.
Okay, well, let's look at this one, for example. You can't just pull that one out of the ground, can you? It goes in a bunch of different directions, right?
Well, you don't pull it all in one segment. You can't pull that much flow line in one pull. You have to break it up into smaller segments because the tensile strength of the fiberglass is not strong enough to pull a half mile through the ground.
Right, and that's the point I think I'm trying to make here is, you know, it's pretty labor intensive to get these flow lines out of the ground, isn't it?
I wouldn't say it's labor intensive. It goes pretty quick especially when you're pulling. Obviously, it's slower when you have to scrape the top, and usually that's like a 3 to 4 foot wide area that you scrape off the topsoil, pull the fill material out, pull the lines out, screen to make sure there was no release, and then replace that back in. That's more intensive than pulling, but both are used, and in lots of cases, in places where sensitive habitats will ask to leave those in place. In fact, we just had Form 27 for decommissioning at the Grant 2 approved last week that included some sections of flow line to be left in place. So
your position that all these flow lines will be left in place because they're sensitive habitat?
I don't think that's what I said.
Okay, and I want to go back to I won't pull it up here because I don't have access to it, but you showed a bunch of depictions of these wells, aerial photos of these wells, and a lot of them don't have access roads to them, right?
No, I showed you some didn't have access roads. The ones that I showed you.
It was your testimony that there's no access road to reclaim, that it's simply the little space that is the wellhead. There's your testimony, right?
Well, for those sites, if there's no road to reclaim, I wouldn't spend money reclaiming a road that isn't there.
Well, let me ask you this. How does KPK operate those wells? How does KPK get to those wells to make sure they're operating properly?
So in lots of cases, they go on foot from the location that they can get nearest, because the tenant farmer may have planted grass. We have a specific example now where the tenant farmer had planted over our access road, and we needed to get in there with a rig, and we talked to the landowner about it, and he still had crops that hadn't been harvested, and so he hurried up and got those harvested, knowing that he encroached on our lease road, and then we were able to get a road in there to do the rig work. So it's a collaborative environment with those landowners when they decide they want to farm over our lease roads, and we can still operate and maintain the well safely and productively.
And thank you for that example, and thank you for also kind of making the point we're getting to here, being that we've heard testimony that KPK may intend to come in and work over these wells and bring more production. You can't do that without a road, right? So there will be a road to do a workover, or when you have to plug and abandon these, you can't do that on foot, can you?
No, you can't do that on foot. No, but there are some techniques and technologies out there to bring rigs in that don't require building a whole road, bringing in gravel and building a road. So you can use railroad ties, you can use other, you can use other platform type pieces of equipment. I know I've seen anywhere from plywood to steel plates being laid down to get rigs back in there. So you're not necessarily creating a road to constructing a road that needs to be reclaimed.
So so we're clear, your testimony is that if there's not a road there, there's never going to need to be any reclamation related to any future operations to get to that pad and to complete a workover or a plugging, that what you circled is simply the extent of any reclamation necessary.
Objection mischaracterizes the witness's prior testimony.
I'm asking if that's the testimony or not.
No,
Yeah.
I didn't talk about workover, future workovers on rigs or anything like that. So,
Well, is there additional reclamation necessary when you need to get a rig there, whether it's to work over or to plug?
it depends on which technology you use, but there are definitely places where you wouldn't want to spend money building a road to then spend money pulling that road back out. So you would find really cost-effective measures that would not equate to the same as taking out a road that's pre-existing.
I believe we've talked about how what we're talking about is what vendors would do to take care of the plugging and reclamation here, not what KPK would do, correct?
That's correct.
Okay, and correct me if I'm wrong, I understood your testimony to be that native vegetation regrows in a few weeks, and that's as long as reclamation takes. Is that your testimony?
No, that's not what I said.
What did you say?
I said that agricultural crops takes a few weeks to regrow, month to start rooting and actually sprouting, and that time frame between reclamation and planting and seeding and starting to irrigate that thing is in the period of months, not years.
Okay, so just so I understand this, it's your belief that we get to full crop yield from a compacted oil site that's been used for 50 years. We get back to that with minimal topsoil in a few months. Is that my understanding?
Our estimate that I ran through includes decompaction and topsoil.
My understanding was that it doesn't require that much topsoil.
There's a topsoil number in that table, correct?
Your exhibit.
Yeah, there is. So
Okay.
I went through the categories on the top. I know I mentioned the word topsoil. I know I mentioned the word decompaction.
Right, and we talked about how you don't need much topsoil for the sites that you're referencing here. So let's get back to your understanding is it takes a few months to complete a reclamation. Is that your testimony?
I'm saying in areas where there's agricultural land and they're farming it, the max period before the crops are growing is 6 months, not 2 years as estimated in the other reclamation estimates.
Thank you, Mr. Peterson. Nothing else.
Mr. Sura?
Yes, thank you. I'm just going to pull up your exhibit VV, and maybe you can help me understand what I'm looking at, because it seems as though your testimony in this exhibit would indicate that there are some costs that are going to be per location, because every location is going to need stormwater management and stormwater inspections. And then there are going to be an acreage cost as well. Is that correct?
That's correct.
Okay, so let's just understand how much per acre you're assessing here, because okay, 8,000, 1,200, 4,000, and then we've got, assuming that there's going to be some topsoil required at minimum of 16,000. Is that correct?
Yeah, but if you look at the table, could you bring back up my cost table?
This one?
Yeah, if you go down to the bottom right,
Mm-hmm.
all the way down at the bottom.
Okay.
Scroll down, keep going all the way down to the bottom. Oh,
yeah.
Keep going. All right, so this doesn't have those recalculations, so that the submittal from the pre-hearing testimony, it takes that total amount of acreage and the total amount of dollars for wellheads and tank batteries and divides that to get to the $22,000 an acre. So the per site costs get built into those on each site, and it would be assigned with the unit of a site rather than per acre. So and that depends on all the site conditions that you're assuming in there, whether you're putting on 6 inches of topsoil, 12 inches of topsoil, or 18 inches of topsoil. So the model is trying to allow for variable perimeter input parameters at different sites, some of which are fixed per site, some of which are based off of the land area.
And so it appears as though this totaling these up is going to come to $30,000 rather than $20,000. Plus some per site assessment, and stormwater BMPs, it's $1,500 per site. Is that correct?
Yes.
And then you've got $1,800 per site per month.
Yes. Those are stormwater inspections, somebody to go out, look at the vegetation, make sure that it's being reclaimed.
Okay. And it's $1,800 per month for over a year?
The year is in there, is what the assumption was.
Okay, so it's $1,800 per site per month.
Yeah.
And then over a year, is it $21,000?
Yes.
Okay.
Or, that's what the assumption is on that parameter. Yeah.
Okay. So every site is going to have a base cost of $21,000 for reclamation.
That's not necessarily true.
Well, that's what this says. So I guess I appreciate the fact that you went back and you recognized that your previous filing was insufficient and didn't go into enough detail. But the detail you provided here, if applied to your exemplary wells that you submitted at the beginning, I think would come to a far different result. Isn't that true?
I think
the question mischaracterizes prior testimony. The reason for doing this was to address your concerns of inadequacy, not our concerns that our numbers were inadequate. We believe the 18 exemplar wells was an adequate approach. The deputy director believed it was an adequate approach. Well,
okay.
his position.
Mr. Jacobs, I think you're just arguing. I think he can go down this line of questioning. He's using the VV exhibit that you just did, and he wants to make some points. So be quiet and let's listen to Mr. Surik's questions.
I appreciate that. Thank you. Because when we go to your earlier exemplar well exhibits, it doesn't have topsoil listed, and it certainly doesn't have topsoil listed at $16,000 an acre, does it?
Yeah.
Or did I completely miss that?
Yeah, we can go to, if Cole can pull up that table with the, or I guess you can go to the table, scroll down to.
I'm talking about your exemplar wells that you put forward 3 months ago.
Yeah, I think those were $7,800 a well. It's all I think what we're arguing here is the real factors that affect these is the site acreage, right? And trying to compare acreage numbers to location numbers can get confusing, and trying to commingle wells with tank batteries can also be misleading. So what I testified here today is that $22,000 an acre is a reasonable estimate given the number that we just went through, or the exercise that we just went through. It's also more than what other operators in the vicinity have estimated for their approved financial assurance. It happens to be half of what the ECMCs are, but I also pointed out why I thought those numbers were elevated. So the numbers that you provided, I clearly showed that those are miscalculated because they didn't divide by the number of well locations, and the areas that were assumed were including properties that weren't ours.
Oh, okay. So just for the record, we did our best, recognizing the fact that we don't have the information you have. Still, you are now putting forward that, at least from what you have here on this screen, $20,000 to $30,000 per acre is going to be a reclamation cost. In addition, you're going to have $21,600 for stormwater, as well as $1,800 or $1,500 per site.
Yeah, those depend
that's on top of what you've already proposed. So what I'm seeing is that there's going to be a per site assessment as well as an acreage assessment. I think that that's fair.
Okay.
That what you're proposing is fair, but your numbers don't add up.
Okay.
Right? I mean, if you've got $21,600 for stormwater that you cite here, that's per site.
Yeah, but the not every site needs that component. So
so there are sites that just don't need stormwater or weed inspections or anything like that.
Correct. After we have returned it to the landowner, they don't require that.
Oh, okay. So this is assuming that there's a landowner agreement in place where they're okay with you not doing that work.
No, I'm assuming that we're returning it to the pre-oil and gas use, which was agricultural crop growing.
Okay, so this is all assuming agricultural. Could you break it out between agricultural and rangeland and those that are in the middle of city parks?
I think the table does that. It talks about the land use that's there. It's in that table.
And that's how you come down with the assessment, where sometimes you don't need any topsoil and sometimes you do.
Correct.
Again, this level of analysis just shows that the exemplar that you put forward 3 months ago, is totally lacking in any of this kind of detail.
Is there a question in there?
The question is that I guess had you considered putting this rigor through your 18 exemplar wells and see if there's a different result?
I haven't. No.
One second. What criteria were used to ID these wells in towns? Were these hand selected?
They were given to me by Jeffrey and Lily, and I'm not sure the criteria they were using, other than they were in city limits, but I don't know how they culled them or sorted them or selected them.
Okay. Well, I appreciate your time. Thank you.
Oh.
Sorry, I'm muted. Commissioner questions, Commissioner Cross.
Thank you, Mr. Chair. And I'm going to get back to the line of questioning that Mr. Sura was just talking about in a minute, but I want to clarify a couple things that were brought up during some of those earlier questions in your testimony. First, in response to Mr. Lewis Prescott, you said that the flow lines aren't part of the estimate, even though there may be reclamation costs for the flow line. Is that accurate?
The flow lines aren't included in that table that was submitted.
Okay. No. Just wanted to make sure of that. And number two, you testified that in some of these shared circumstances, whether it's a shared battery, a shared road, whatever the case may be, if one of the other operators abandoned beforehand, they didn't pay their share. Did I accurately describe your testimony?
Can you repeat that question? I'm sorry.
I believe you testified that in some of the situations where there was shared property, whether it was a shared access road, a shared battery site, whatever the case may be, that whoever you shared it with, there were instances where they abandoned their site before you, but they didn't pay their fair share.
Well, I'm just saying that they didn't pay for the share of the lease road that was left in place.
Okay, so you're saying because it's shared, you shouldn't have to include that in your estimates either?
No, it was just our assumption that we made that they were going to continue to operate and that ours would be abandoned before them. If that's not the appropriate assumption, then we can recalculate.
I'm just wondering, wouldn't they have the same assumption then that maybe you'll continue to operate and then we're
Yeah,
left with
maybe.
the road
Yeah.
that's not paid for?
Yeah.
Okay.
So I guess the last man gets stuck with the lease road, the joint lease roads.
And perhaps Mr. Killian can help me with some of the question going back to what Mr. Sura was talking about there. First off, if you could pull up Exhibit VB, the first page of that, where you have the assumptions in here. So, and just as a forewarning of where I'm going with this, Mr. Killian, if you could also get Exhibit C ready, your Exhibit C, that is your demonstrated costs. So I'm curious as to one, as we're looking at Exhibit VB here, Mr. Peterson, where some of these numbers came from. For example, under the equipment, you have the blade, the loader, the belly dump, the tandem, the decompaction, the topsoil, the dryland pasture, the excavator. Where did those numbers come from?
Those are our estimates based off of market prices.
So these are not Kaufman Well Services. This is third party.
Yeah, those are the assumptions we made for those types of pieces of equipment.
Okay, and now if we can go back to Exhibit C, your demonstrated costs, if we could perhaps go down to, I don't know, we'll pick a well. How about we go to page 5? See if Mr. Killian can help out here. So in the bottom parts here, it talks about the roustabout services for the well, and that's going into well reclamation, and also the roustabout services for the battery, and it goes into that. And I want to try and do this without as much back and forth as possible, but and I'll definitely provide you opportunity to go back and compare here. Where did those numbers come from?
The numbers that are in on this table.
Yes.
Yeah, those were developed by all of us on the team that were putting in this, running these calculations.
So when you're looking at the exemplary wells here, Exhibit C, and you're saying, here's our demonstrated costs, and I believe it was used with a lot of the costs of Helena Resources. We're going to look at things like a dump truck being $75 an hour for reclamation purposes. But now, as we go to today, and as we're looking at Exhibit VB, we have a belly dump here that's $95 an hour.
Yeah.
Why did you not use the same numbers?
Well, belly dump is larger than the dump truck.
Okay, where's the $75 dump truck that's in Exhibit VB?
That would be can you show me the table? I'll show you which line item it is. It's the 10-ton truck rate.
That's listed at 68. So now your prices are going down further?
That was the number that we used, 10 tons for the 68. Yeah, that was the number that was put in there.
So, and I'll give you part of where I'm going with this. Before, when you're saying these 18 exemplary wells, this is what we're saying it's going to cost. You're giving us sites. This is the right amount, $75 for a dump truck. But now you're coming up saying, actually, it's not $75 per hour for a dump truck. It's actually 68, and we could use a belly dump, which is going to be 95. And I guess we can go into more of these as well. It has a blade for 85, a loader for 100, decompaction, disc drilling for 100. Can you point out where those are in your demonstrated costs?
For
going back to Exhibit C.
They would be in those breakouts for each of those tasks.
So I'm seeing a backhoe, which I'm not seeing on the other one. I'm seeing a vacuum truck, which doesn't match up.
You're kind of
doesn't match up.
You're kind of comparing two different things. You're comparing
if I could, I don't know that I am comparing two different things, because these are sites that we're looking at reclamation costs that you said, this is how we determined our demonstrated cost for reclamation. We looked at these 18 exemplar wells, and on those 18 exemplar wells, we broke it down. It's going to cost 15 hours for a roustabout foreman with a truck at $71 an hour. It's going to cost a dump truck at $75 an hour, 2 hours. It's going to cost a winch truck to disassemble the pumping unit, $150 an hour, 1 hour. It's going to have other services such as cut, cap, well, and reseed for $300. And then you have the backhoe, you have the vacuum truck, the disposal, similar things listed out by hour, by the different types of equipment. You're telling us that in determining your demonstrated cost for reclamation using the 18 exemplary wells, this is what you have to look at. These specific prices, these amount of hours for this type of equipment. Now you're saying we're going back, we're going to look at some more in rebuttal, we're going to look at some more well sites, some more batteries, some more locations, facilities, and we're going to talk about reclamation again. But now you have a completely different list of equipment. You have different prices for the equipment. And so I'm trying to figure out which of these are we supposed to be looking at? Are we supposed to be looking at what you provided initially in Exhibit C, or are we supposed to be looking at the cost and the equipment you're looking at in this new Exhibit VV?
Yeah, I can answer that for you. So the initial submittal, if you recall, was the cost for plugging and abandonment and reclamation together. And the reclamation costs were derived from the same values as Helena Resources. The second,
we're no longer using Helena?
What's that?
We're no longer using Helena Resources?
Well, we went back and recalculated just the reclamation costs independently because you guys said that you didn't like the use of Helena Resources numbers. So we recalculated them independently of the assumed number in the original submittal.
So we're now using this cost per well, not what you previously talked about in August.
Well, you're looking at the cost per well for all the plugging and abandonment stuff in conjunction with the cost per well for reclamation. That was one of the criticisms of the original testimony, was that the reclamation wasn't parsed out enough detail to segregate the commingled activities between the plugging and abandonment activities and the reclamation activities.
I'm not sure I agree with that assessment, more than anything because part of what, even if you look at, as Mr. Jacobs has pointed out several times, even the deputy director, and you pointed out as well, the deputy director agreed back in August with your supplementation as to what it should cost. And one thing I want to point out there is that in their letter, in the deputy director's letter saying, yes, we're going to take these demonstrated costs for plugging and abandonment and reclamation. The plugging and abandonment cost was also $31,000. Now you're saying it's $35,000. So that's another question I want to get into. But before it was saying, okay, we're looking at $7,000 per site, and I'm not sure where the new numbers are coming from. And ultimately, what I really want to understand is what numbers are we looking at in determining for your approximately 1,200 wells in Colorado? What numbers are we supposed to look at for a demonstrated cost? Is it what you initially submitted that we've been relying upon for the reclamation costs that were discussed back in August, and the last few days we've been talking more about the remediation? Or are we now using this new costs that are coming up with different equipment, different costs per that is being brought up in Exhibit VV?
The well plugging and abandonment costs are still valid, and I think I testified today that we think a more accurate number for the reclamation piece is $22,000 an acre, which is in line with the $7,800 to, or I mean, $8,000 to $10,000 that Mr. Cuthbertson testified to, as well as our $7,800 per location. So they're not out of the range of each other. So that.
Okay, and I'll go back to the first part of what you said there. You said the plugging and abandonment numbers are still good. So now I'm curious again, are we using the 31,000 that was based off of what you initially submitted in August that was that the deputy director okayed, or are we using the $35,000 and change that's in your Exhibit VV?
I'm not the person to be asking about the plug-in and abandonment costs. Those were done by Lily, and she testified on that, and I can't remember the number that she quoted.
But you also just said you still stand by the plug-in and abandonment costs.
I think that's correct. I think those were in dispute.
So you don't have an opinion on whether it's the 35,000 that's in Exhibit VV or?
I couldn't tell you which one it was, but it's in the record.
Okay. And so we're essentially supposed to ignore Exhibit C now. And moving forward, it's now going to be $22,000 an acre.
No, I think I demonstrated that the secondary calculations that I ran through are in line with the original calculations, the original estimates
For the reclamation aspect.
for the whole financial assurance, right? We got the two pieces, the plugging and abandonment, and then the 22,000 an acre. On, if you look at our original estimates, like $7,800 a site for reclamation pieces, and $22,000 an acre is in line with that number.
So ultimately, it doesn't matter what background you use for which equipment is being put forward in your potential AFEs. It doesn't matter what hourly rates being used for that equipment, because ultimately it all comes out the same, even though there's different equipment listed each time, different costs each time. Regardless, it still comes out to 22,000 an acre, or approximately 7,800 a location.
I'm not disputing that those two numbers are different. What I'm saying is that the impact on the final number is not significant. Then it's not a big driver on the because the numbers aren't very far apart. So,
but part of what I'm trying to understand here is you have a burden to demonstrate to us the cost if we're not going to use the assumed $100,000 for reclamation for single well financial assurance.
Yeah.
So if you have the burden to show us this is our demonstrated cost for reclamation, I'm just having a little bit of a hard time with you saying, yeah, I know the numbers are a little bit different, but ultimately that little bit of difference doesn't really change anything. It's all about the same.
Yeah, we were asked to we were trying to rebut the inadequacy of the numbers, and so we ran another exercise and we came out with a similar answer.
Okay. And then the other thing I'd like to go, if we could go back to, Mr. Killian, please, if we could go back to Exhibit VV. Oh, and I do want to, and sorry, just before we do go to that, Mr. Peterson, Mr. Sura also brought up the stormwater BMPs and the stormwater reclamation inspections and the per site cost that could come up with that.
Okay.
Can you tell me where in the previous estimates on reclamation using those 18 exemplar wells, can you point out to one of them where it has anything addressing stormwater BMPs and how that should be included in the cost?
It was baked into that first table. That's why we were trying to help demonstrate the reclamation costs, because it was not clear in our presentation in August, those two components. So that's what we were trying to do.
So is this going to go into potentially the other services such as cut, cap, well, and reseed? Is it going into that? The other services, stormwater control, just $400 for an acre now?
Yeah, I think that's what I'm trying to say, is that the previous table had reclamation costs baked in various tasks and not clearly defined, which is what we tried to do in our exercise after you requested that we provide more detail about the reclamation components. So that's what we tried to do.
Okay, and then similarly with that, did any of your exemplar wells include topsoil? The initial exemplar wells, not the redo.
They were using the Helena Resources numbers, which would include all the necessary tasks, including topsoil, to reclaim a site, just like Helena did.
But you can't point out where the topsoil is encompassed within those Helena.
It wasn't broken down into that level. No, that's why we did the secondary exercise, so that we could show the topsoil numbers separate from the baked in numbers.
And can you let us know again approximately how many wells Helena Resources has?
I'm sorry, I didn't catch the last half of your question.
Approximately how many wells Helena Resources has?
I don't know.
So, and now, Mr. Killian, if we could please go back to Exhibit VV. And if we can go to the second page, where it starts breaking down some of these individual sites. I'd like to talk about a few of them. If, for example, we talk about the Gilson 5, and it says comments in talks with school district. What does that mean?
I'm not sure. I didn't write that specific comment.
So is this presumably going to have an effect on the reclamation cost, or is
it, if it did, it was put into those numbers and assumptions that are filled in the cells to the right.
So you didn't put in the numbers and the assumptions on the field. Right?
It was a group effort, right? And so that note, I can't recall specifically what that note was referring to. I didn't put that note in there, but I think it is it's safe to say that the numbers that are in the columns to the right are representative of the comments that are in the columns to the left.
And so would that comment presumably mean that you're not going to do a full reclamation because the school is going to do that? This is what I'm trying to understand.
Right. It depends. So the assumptions for that given entry have to take into account those land use parameters, all the site conditions, right? That's why they're listed there. And so the numbers on the right, the input parameters, the quantities, the amounts, all get adjusted based off those descriptions.
So as we go down to the Lansom Farms 15 and the Pace Connolly 5, cropland, we would only decompact. So your reclamation numbers there, don't assume that you're going to do full reclamation.
I think that the reclamation costs in here assume compliance with the rules.
But you would only decompact, you wouldn't do a full reclamation per ECMC rules.
It says remove road base, decompact the lease road and the wellhead.
What about reseeding? What about any potential topsoil? What about?
Yeah, so if you look at the columns along the top, so if keep going to the right, so you have the road base removal, the site prep, the seeding, topsoil, all of those cells are calculating off of the input parameters for that those decompaction, seeding, all of those components that are associated in the input parameter list.
So for this one, the very first one is going to have the site prep and seeding. And then the next 1, 2, 3, 4, 5, 6, 7 don't have any kind of seeding for them.
Yeah.
And a couple more do, and then a bunch more with no seeding or site prep.
Correct.
But don't the ECMC rules require seeding for it?
Well, if we want to seed before the farmer pulls it out and puts his own seed there, we can put costs for that. It seems wasteful.
But has a variance been granted for this?
No, but you would assume that they would. You wouldn't assure.
So, but this is what I'm trying to understand. You're coming up with assumptions that are supposed to account for all of your wells.
Yeah, that's the whole.
A large part of these assumptions don't even take into account that you may have to seed. It's just assuming a variance is going to be granted. Again, this goes back to what I was trying to ask Mr. Mailer about. How many of these wells are we expecting to have a farmer that's going to say, oh yeah, we're going to do it? So far, we've looked at 18 that it didn't have all these assumptions in there. And now we're looking at a new set of 16 where they are having these assumptions in there and that you're not going to reseed. So even under these new assumptions for these new 16, you're not going through all the ECMC regulations for reclamation. You're assuming that a variance is going to be granted. And so for the other, if we take out the 34, we're still looking at approximately 1,170 other wells that KPK has. How are we supposed to know how many of those wells are going to have the seeding or not have the seeding? Or are we assuming variances granted for half of those, for 2/3 of the? How are we supposed to understand your demonstrated costs if we don't know how these assumptions are being built into 1,200 wells as opposed to just a subset of wells that you're looking at here?
Yeah, I think the assumptions that we made for these are in there, but what you're saying is the we have to make assumptions. Everyone in here is making assumptions. We're trying to calculate a number for something in the future that's representative, a unit rate number that's representative on a per well location. And so you have to make some assumptions that are conservative, some assumptions that are not, to offset those differences. And so if your financial assurance to get you the certainty that you're looking for, it sounds like to me you want a site-by-site evaluation of all 1,200 wells, all 1,200 batteries, and then assume the assumptions that you want to assume for each of those things, or the full assumption of full reclamation on sites that's not going to happen on. And so, it's just two different levels of assumptions, and how you decide what's a fair number for a unit rate on a per well basis.
And I'll start off saying, in no way am I suggesting that you have to point out, here's what the reclamation is going to cost for all 1,200 wells that KPK has. What I want to understand is, if you have a portfolio of approximately 1,200 wells, and you're saying that out of these 16, 2/3 of them are not going to be reseeded, are we supposed to assume that 2/3 of the wells are not going to be reseeded out of the 1,200? Because a lot of these are not, of these 60, or a lot of the 1,200 wells aren't necessarily in Dacono or Frederick. Or are we going based off of your Exhibit C, which you're now saying we shouldn't be looking at, that does have seeding numbers? Or this is what I'm trying to understand. I'm not saying I want you to do a site-by-site for all 1,200 wells. I'm just saying, how are we as a commission supposed to interpret the assumptions that are different here versus the assumptions that were given in August for the 18 exemplar wells? And how do we take some of these things that assume things like apparently assuming a variance where you wouldn't have to reseed? How are we supposed to take that into account for 1,200 wells at March?
Yeah, I think
Before you answer, if I may, I just want to clarify with leave of the chairman. The Form 3 is quite clear that we have 1,086 wells subject to single well financial assurance. Somehow we got to talking about 1,200 wells, and I just want to clarify, it's less than 1,100 wells. If you want to generalize at 1,100, fine, but it is not 1,200 wells. Thank you.
Okay, well then I take that back. I believe one of the first things that came up in testimony in my notes was that KPK has approximately 1,200 wells overall. It may be that 1,186 are applicable to financial assurance under our ECMC rules. So we'll use 1,086.
Yeah.
That doesn't change my ultimate goal here in trying to understand, how are we supposed to take assumptions that differ from August to now and take into assumptions such as, well, we're going to assume there's going to be a variance, because this also goes back to what Commissioner Messner and I asked Mr. Mailer about as well. Well, presumably there's talks about building a development here. Well, the development's not in yet. A variance isn't done yet. So how are we supposed to understand what weight we put on this, and how do we take that and apply it to 1,086 wells across Colorado?
Yeah, I hear what you're saying, or you're asking me to put myself in your shoes. And if I were in your shoes, I would look at the sample set and see if that's representative, and the testimony that based off of the things that we've said, is that representative to be applied to all of the wells for financial assurance? And those parameters and the assumptions that all the different parties made, are those reasonable to apply to all 1,000 wells, or is it something different than that? And I guess that's the decision you have to make. You have to look at our sample set. Is that representative enough of the variance that, or the variations we have for our facilities, and the testimony that we provided that was trying to demonstrate those assumptions for you? So that's the way I would do it. I would look at the numbers and say, is this a reasonable number to apply to all the wells? Is this a reasonable number to apply to most of the wells? And the testimony being different, I think that's a mischaracterization. I think what we did was do an analysis that shows that the reclamation costs that we included in the first submittal are not much different than the ones in the second. I don't know if you expected us to come up with the exact same number. It's highly likely when you're doing two different independent analyses. So,
and I guess I'll just say, I'm not expecting you to come up with the exact same number. I just want to know which number I'm supposed to be using.
Yeah, I think that's been presented in our testimony, the P&A number that was presented in August, and the $22,000 an acre that's been presented here today.
Thank you.
Further questions from commissioners for this witness? Commissioner Messner?
Thank you, Mr. Chair. Just a couple of questions. So I think I think I'm just trying to understand. So because you didn't do a site-by-site analysis, you chose to use exemplary wells. Those exemplary wells, at least in the initial submittal, were developed to utilize different types of downhole characteristics as well as potentially surface characteristics in different cross sections of what it may be like in other areas that have KPK wells. Now you're bringing in 16 wells with a more in-depth analysis than was done with the initial 18 exemplary wells. And you're asking us now to use these 16 wells that are concentrated in the towns of Frederick and Dacono as the exemplary set of wells?
I don't think so. I think that we were trying to demonstrate that the exemplary set of wells reclamation costs is not much different than when we just did the focus on the cities or the Frederick and Dacono's wells for purposes of clarifying with them and rebutting their testimony, as well as clarifying them the analysis specific to their locations.
So did you hear the testimony earlier from the town of Frederick and the witness? I'm sorry, I have to look up the witness's name because I'm drawing a blank right now. Sorry, Mr. Allward, who indicated in his analysis that that the exemplary wells that were initially provided were twice as much from a reclamation standpoint than the wells that were analyzed inside the towns of Frederick or Dacono.
Are you asking if I heard that testimony?
Yeah.
Yes, I did.
And you acknowledge that at least in his analysis, he saw reclamation costs double, at least double of what even he estimated the reclamation costs would be of the wells inside of the city of Frederick or Dacono.
Well, I understand Mr. Allward's position and what he was in charge with and calculating his numbers. I also demonstrated specifically on the 6 sites that he brought up how he doubled the estimates of the amount of area that requires reclamation. So that's why you could arrive at a double number, but
But he applied the same standards, whether inside the town of Frederick or Dacono or outside the town of Dacono. So that analysis isn't particularly valid. But nonetheless, I just wanted you to acknowledge that you did hear that, and that there was, clear testimony as far as the standards that one person with experience in reclamation applied twice as much reclamation costs associated with the wells, the exemplary wells that were outside the city of Frederick and Dacono, than applying the same numbers to the stuff inside the Frederick and Dacono. And so moving on from that, I continue to hear that testimony around how Deputy Director Cuthbertson, determined that the initial reclamation costs associated with your exemplary well proposals were appropriate. I think we also heard Deputy Director indicate that the evidence that the way that he determined whether they were appropriate or not was a phone call with Dave Andrews from the Orphan Well Program. Is that correct? You recollect that testimony?
I listened to his testimony. The specifics that you're mentioning, I can't specifically recall, but I'll take your word for it.
Do you recollect that Mr. Duran, though, indicated that his reclamation specialists were never contacted to review any kind of numbers that were provided by KPK in their demonstrated costs?
I do recall that, yes.
Okay. And at the same time, the orphan well program numbers were the numbers that were utilized by Dr. Allward in his analysis in determining a lot of data associated with his numbers. Do you acknowledge that?
Yes.
Okay. And that your analysis or your testimony indicates that the reclamation numbers associated with same ECMC staff are grossly inaccurate. Is that correct?
I don't know that I made a statement on that. What I did say was that the assumptions that go into the reclamation costs, particularly the size of area to be reclaimed, is a significant factor in the ultimate unit rate. And so
I guess my question ultimately is, on one hand over here, and I just want to make sure I understand it. On one hand over here, you want to utilize ECMC staff to help support some of your arguments, particularly Deputy Director Cuthbertson. And on the other hand over here, you don't want to utilize ECMC staff's number expertise because it doesn't fall into your argument. And so I'm struggling with that a little bit because you don't get it both ways.
Yeah, I would characterize my opinion on this is that I would like to have the same rates afforded to KPK as other operators who have approved testimony that have been deemed reasonable, and that our rates are similar to theirs with the same operation. So that's what I would hope for, is equal representation, I guess.
Okay. And the final question, to your knowledge, is Deputy Direct, and I'm assuming that you don't know this, but I'm going to ask the question anyway for my record, but is Deputy Director Cuthbertson an expert in reclamation?
I don't know.
Okay, thank you.
Further questions of this witness? Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Mr. Peterson. And I think the adage, where you sit is where you stand, kind of applies for lots of the testimony today. But I do wonder if there's some recognition on your part. I don't disagree that it would be nice if we had like a rate that we could apply to everybody and said, this is an average rate that applies to everyone. But in this instance, I think what you hear some of the folks who are testifying saying is, regardless of the rate, there is more work that has to be done at some of these KPK sites. And those are the examples that you've been seeing from folks testifying. And I'm wondering if you have thought about that, that if the idea of a rate was taken out of the picture, I'm not sure that your comment that KPK's portfolio is just like other well operators in the area is necessarily true, based on some of the testimony from not only the ECMC staff, but the two cities that have some of your wells in their jurisdictions.
Can you rephrase that question? Are you trying?
So I'm wondering if, in your efforts to come up with reclamation and remediation costs, you took into account not just what you thought was a prevailing rate, but the amount of time and effort it would take to bring your sites back to a place where we could close them out.
Are you referring to remediation costs or reclamation?
Remediation.
I believe that the approaches that we assumed in our remediation costs are within reasonable standard practice for environmental engineering of these types of problems. I also believe they are consistent with what other operators are doing. And I would say that contamination from one tank battery that's KPK by another tank battery that's another operator, yeah, they're going to vary depending on the size and extent of the release, but the magnitude and approaches are similar. You can use similar approaches to clean them up. But it becomes site specific based on the magnitude and extent. I would say that KPK's magnitude and extent of impacts at known release sites is no different than the magnitude and extent of impacts from other operators.
Okay, thank you. So I know we've been focusing a lot on reclamation and a little bit on remediation. I am still wondering, and maybe, I think Mr. Jacobs, you said if we want to talk about the asset management plan, which is also required as part of an option 4, I've only seen a redacted document, and I don't know who to talk to about KPK's thoughts about what the asset retirement management plan looks like. And I don't think your previous your previous person who testified really kind of understood what we were getting at as far as that component of an option 4. So I don't, is it Mr. Peterson we should be asking, or is it another witness that you might have?
Thank you for that question, Commissioner. The asset retirement plan was submitted with the Form 3. It does contain confidential business information, and so a redacted version was made publicly available with all the other information. Mr. Kaufman, the President and CEO, would perhaps be the best witness concerning that. I may be mistaken in that, but I'd like to confer with my general counsel, who also participated in the preparation of that. And I could maybe after the, if we're going to take a mid-afternoon break, get back to you on that and provide an unredacted. I would ask that if an unredacted version is provided, that it only be discussed in executive session to protect the confidentiality of the document and the information.
Thank you. For me, I'm sure if you've seen any of our other financial assurance discussions, that's an important component for me. And so I would like to understand how that fits into this whole package that we're going to be looking at and hopefully coming to a conclusion about.
Certainly.
Other questions of this witness? Mr. Sura, you have your hand raised.
Yes, thank you. Just one brief question. We did talk about this, but I didn't get an answer, and I still don't frankly understand it.
If I may interrupt, I apologize.
Yeah, Mr. Sura, I think it's out of turn at this point. We're at this point. I mean, I've tried to be allowance, but I think we're kind of getting past due here. So
I understand. I've only got one question, and we've previously allowed other attorneys to.
Well, throw your question out, and we'll see if we're going to allow it.
Okay. Well, you've got acreage costs, but you also, under stormwater BMPs and stormwater reclamation inspections, you have what amounts to $23,100 for per site. And I just haven't seen that applied to any of the sites either 3 months ago or, in this last round. And I'm just wondering if I'm missing it.
I'm going to object again to this as out of order. There's been no redirect and therefore should be no recross.
All right. Let's not have that question. I believe you can raise that in closing for sure, Mr. Sura. And let's move to redirect. We're running out of daylight, guys.
No redirect.
Oh, that's good. All right, let's take 10 minutes and return at 3:35 for the remaining rebuttal testimonies. All right, we're back. It is 3:36. And we are going to have all the lawyers visualize themselves All right, Mr. Thomas, are you with us?
Yes,
Can you provide updated time checks?
certainly. At this point, staff has 25 minutes and 54 seconds left. Frederick has 6 minutes and 28 seconds left. KPK and Dakota have both gone over their allotted time at this point, between 2 and 5 minutes.
Okay, I do want to hear rebuttal from Frederick and Dacono. Frederick is up first, but before we do that, Mr. Lewis Prescott, do you have a sense of time that you were looking at for rebuttal?
You know, given the amount of time that we've already taken up here, to forego rebuttal, I would like a little bit of time for closing, but I think we can streamline this that way.
Okay, thank you. I appreciate that. Mr. Sir, a similar question for you.
3 quick questions, shouldn't take more than 2 minutes.
Okay. All right. Well, with that, then let's recognize Mr. Sura and his clients for rebuttal.
Thank you. If we could elevate Ryan Johnson. There he is. Good afternoon, Ryan. Just to remind you that you're under oath. Just to have a quick, 3 quick questions. Of the 10 locations that were part of your virtual tour of Frederick, were any of those locations subject to current development proposals?
No, in fact, many of the locations were designated as open space and therefore couldn't be developed.
And even in areas that may be developed, can we assume that oil and gas locations will be eliminated by commercial or residential development?
No, I wish that were true. As you heard from 2 developers yesterday, very few are able to pay the exorbitant fees that are assessed or charged for KPK to plug its wells and therefore incorporate those sites into a development plan.
Thank you. And we've heard some testimony that development in Frederick came to an oil and gas site, but there were many wells permitted in Frederick near existing homes, weren't there?
Yes, there's homes in Frederick that are over 100 years old. And in 1994, the town enacted a local ordinance making it illegal to drill in Frederick without obtaining an oil and gas permit first. The ordinance required a $1,000 permit fee, a 350-foot setback to homes, and noise and visual mitigation measures. Fast forward to 1999, North American Resources Company challenged that local ordinance by drilling in Frederick without obtaining a permit first. 3 years later, the Colorado Court of Appeals actually upheld a lower court's decision to strike down Frederick's ordinance regarding the 350-foot setback and the noise and visual mitigation measures, finding them in operational conflict with the provisions of COGCC.
Great, thank you. And for the attorneys in the room, I think that is a Town of Frederick versus North American Resources, and that's a 2002 decision. And that's the only questions I have. Thank you.
All right, the witness is subject to cross. Any cross, Mr. Jacobs?
No cross from KPK. Thank you, Mr. Chairman.
Mr. Boudreau?
No, thank you, Mr. Chair.
Mr. Lewis Prescott?
Nope, thank you.
Commissioners? Without cross, I don't think there's a need for redirect.
No, there's not. Thank you.
Okay, and then Dacono has indicated that they're going to forego rebuttal. That brings us then to closing arguments. Irrespective of what time may or may not exist, I do want to have closing argument from each party. I believe folks should be able to sum up their thoughts in, say, 5 minutes. Does that sound about right?
Mine's clocking in around 7, if that's okay.
Okay.
Mine
Well,
is
why don't,
7 or 8 as well.
okay, why don't we? I'll say 10. You get bonus points if you keep it under 7 or 8. And my next question to the lawyers is, are you ready to proceed to closing arguments? Mr. Jacobs, you're first.
I can be ready in just a couple of minutes.
If I give everybody, say 5 to 10 minutes, would everybody be in a good spot?
That works for staff.
Okay. Let's return at 3:50. That's 8 minutes.
Thank you.
We are back and I'm now unmuted. We're going to move into closing arguments. Commissioner Cross, your hand is up.
Thank you, Mr. Chair. I just wanted to ask quickly if Mr. Jacobs, if your client was able to find the unredacted version of that asset retirement plan that could be passed along.
Happy to answer that. We have it. It's at my client's office on a desktop computer. It was submitted unredacted, though, and staff should have that. It was labeled confidential. Then staff asked that a redacted version be provided, which was complied with. So it is our understanding that staff does have access to the unredacted version, and you should be able to get that immediately from staff.
Mr. Berman, are you with us?
I am.
I'm not sure if this question is for you, but do you know if we have access to the unredacted version of the asset retirement plan?
I don't. I don't think it went through me. Would it have gone through me, Mr. Jacobs?
No, it was submitted with the Form 3 through e-filing on November 1st of last year.
Deputy Director Cuthbertson has just visualized himself.
Yes, Chair, I have access to that document. And I emailed it earlier to Assistant Attorney General Davenport, but I can also email it confidentially to the commissioners if you would like.
AG Davenport, are you with us?
Yeah, just one moment, Chair. I'm going through my emails. If you could give me 1 minute, please.
Yeah, sure.
Okay, thanks.
While we're doing that, we could probably get started with closing arguments. And then we can get an update on that in a bit. So with that, would look to, I think the town of Frederick was up first, followed by Dacono, and then KPK, and then staff.
Hey, can you see my screen?
Yeah, we sure can.
Okay. Hoping to get some bonus points. We'll get out of here before 6 minutes. This hearing has been long and difficult, but it matters. The differences between what KP Kaufman wants to pay for a known remediation and what ECMC staff believes is necessary is a difference of more than $20 million. Similarly, what KPK believes is necessary for reclamation, $7,834 a well, is far different than the $45,000 per acre reclamation supervisor Dr. Dennis Arthur believes is required as described by Greg Duranlo. Or the testimony of Dr. Alward, or the evidence presented by Dacono, who put the figure for the smaller locations within those municipalities at $55,000 to $60,000 a well. The difference between $7,834 a well and $55,000 testified to by Dacono and Frederick is a difference of $47,166. But when multiplied by the 108 wells within Frederick and 59 wells within Dacono alone, that difference is 7.8 million. That is why Frederick and Dacono are here. As you have heard from Frederick's witnesses, the town has been uniquely harmed by the legacy of previous state oil and gas commissions permitting hundreds of wells within the town and allowing inactive and low-producing wells to be transferred without adequate financial assurance. And now they struggle with an operator who is out of compliance with existing regulations. Frederick and Dacono want to know that there will be adequate resources if KPK defaults on its obligations to plug and reclaim wells. Your decision could greatly impact their futures. It is worth taking the time to get this correct. This is the first time this commission is considering demonstrated costs. It is also important to set correct expectations for operators, staff, and the public. Demonstrated cost does not equate paying what you want or what you think you can afford. The evidence by KPK was simply not credible. They did not consider the full size of the locations. They did not include removal of access roads or flow lines, and they did not consider whether they were in sandy soils or the cost of replacing topsoil. As this exemplar from KP Kaufman demonstrates. Again, they didn't consider the access road or the flow lines. $7,000 to reclaim a nearly 1 acre tank battery is just not credible and not even consistent with their new testimony that states it should be more like $20,000 an acre. They did not offer a third-party estimate, but used an estimate that was created by another operator, Helena Resources. Helena Resources does not even agree that KP Kaufman should use their cost figures. When asked to come up with receipts of actual reclamation costs, CEO Jeffrey Kaufman offered a cost estimate from plugging a single well, KP Kaufman Exhibit S. The total cost on this invoice for this one well in Frederick was $46,460, for which they claim they spent $5,520 on reclamation. KP Kaufman CEO Jeffrey Kaufman admitted that all work was done by KP Kaufman's subsidiary and the price charged was, quote, an internal transfer price. It was a number we decided, unquote. When asked, Mr. Kaufman affirmed that the reclamation was completed on the location. After he was presented with a recent satellite image that showed no reclamation occurred other than the removal of equipment, he continued to claim that there was some reclamation, although he agreed that there was no topsoil imported, no recontouring, and no reseeding. According to KPK, reclamation that does not include recontouring, reseeding, and topsoil replacement costed $5,420 on this location. The figure for reclamation and remediation that were provided by KP Kaufman just were not credible. Frederick was told it could not subpoena ECMC reclamation staff or orphan well program staff to testify. I believe that this hearing would have really benefited from some additional analysis from staff with a background in reclamation. Again, I query the question as to why there is a total of $23,100 per site that was never applied to any of the exemplar wells, either 3 months ago or today. Thank you for taking the time needed to get this right. Inadequate financial assurance will harm Frederick, Dacono, and Colorado. We ask that you either reimpose the $30,000 a well for plugging and $100,000 for each location, or as an alternative, $31,626 for plugging costs, and that KP Kaufman had mentioned, and $55,000 per well for the 167 wells in Dacono and Frederick, and the additional $24,344,402 for remediation that the staff has requested. Thank you.
Thank you. We appreciate the closing statement. Normally, commissioners, we don't really ask questions at closing. If anybody believes that that needs to happen, let me know, but otherwise we will move to Mr. Lewis Prescott.
Thank you, Mr. Chair. I'm going to abandon the slides. This will be short, but I apologize regardless. Simply get my face. Put it simply, KPK has not met its burden to demonstrate plugging and reclamation costs of its 1,086 wells subject to single well financial assurance. The evidence presented by KPK and its witnesses has been inconsistent, incomplete, and at many times arbitrary. For example, we looked at KPK's wells in Dacono and the flow lines connecting every single one throughout Dacono. We heard testimony that many of these flow lines are fiberglass or plastic, which, unlike steel lines used by other operators, cannot simply be pulled. They are brittle and often break. The average $10,000 reclamation cost for flow lines identified by Mr. Olborn is actually much higher for KPK's fiberglass flow lines, according to Mr. Olborn's unrefuted testimony. KPK presented no evidence related to the cost of removal or reclamation of its many miles of flow lines in Dacono or otherwise. On the other hand, Frederick and Dacono, two adjacent and similarly situated jurisdictions, presented consistent and reliable evidence, including expert testimony and opinion regarding plugging and reclamation. It vastly contradicts KPK's evidence and arguments. Even the ECMC staff, which originally supported KPK's figures related to reclamation, has now testified as much higher reclamation numbers than what KPK presented. With respect to remediation, KPK's evidence also failed to establish the true and accurate costs to remediate all of its open remediation sites. KPK undercounted the number of remediation sites. KPK's estimations on necessary work and costs associated with remediation work was diligently refuted and shown to be inaccurate. Staff, on the other hand, provided compelling evidence and testimony as to KPK's true open remediation costs, a number that should be accepted. With respect to KPK's wells in Frederick and Dacono, we believe the evidence shows the single well financial assurance for plugging and reclamation was demonstrated to be at least $100,000 per well, and maybe substantially more. Dacono requests that $100,000 be the minimum set for single well financial assurance, particularly with respect to the wells in Frederick and Dacono. If this commission determines that simply doesn't have sufficient evidence to determine what demonstrated costs can be applied for reclamation and plugging of KPK's wells, the commission has the fallback presumptive amounts of $30,000 per well and $100,000 per location, which seems to be the right path to take at this juncture. Lastly, Dacono supports ECMC staff's remediation amount and supports its inclusion in this single well financial assurance hearing. Thank you.
Thank you, Mr. Lewis Prescott. We now will hear from Mr. Jacobs.
Thank you, Mr. Chairman, Commissioners. It's now time to take stock of all the testimony and evidence presented in this hearing and come to a determination on single well financial assurance. We appreciate your attention to the testimony and evidence and trust your commitment to remaining neutral and open to the arguments and evidence presented, as you must when sitting in a quasi-judicial capacity. We also trust that you respect and understand the need for KPK to push back on staff on certain issues where the facts and circumstances warrant. An awful lot's transpired in the course of this hearing. Staff denied KPK's original Form 3 financial assurance plan submission. KPK substantially supplemented its original submission. Staff then recommended approval of the supplemental financial assurance plan using demonstrated costs. Then at hearing, the commission ruled that both staff and KPK had misinterpreted Rule 702B, pursuant to which this hearing is being conducted. Since that time, KPK has been the only operator under any of the 700 series options required to provide additional financial assurance in a 702B hearing, but other operators with open forms 27 and 19, including Industrial Gas Services, Brown Oil and Gas, Webkin, Fullerton, and others, have had their financial assurance approved without additional financial assurance for remediation expenses. That circuitous procedural background notwithstanding, KPK has endeavored to support its original and amended financial assurance plan submissions despite these unexpected changes in the scope and standards for determining the amount of single well financial assurance required by this commission's 700 series rules. And even more significantly, the change in staff's position from support to partial opposition mid-hearing. KPK began using its own demonstrated costs, and these were rejected by staff. It then substantially supplemented its financial assurance plan without any request for additional information from staff. using demonstrated third-party costs developed by another operator, Helena Resources, and this met with the director's recommended approval, as it did for Helena Resources. Let's start by eliminating what's not in serious contention. KPK's downhole P&A designs and associated costs are not in serious dispute. They exceed staff's default figures, and the RLG party's concerns about only using 18 exemplar wells to estimate P&A costs for almost 1,100 wells is not shared by staff in any event. Moreover, KPK has looked at an additional 16 wells in Frederick and Dacono specifically to address concerns raised by Frederick and Dacono in their pre-hearing filings and in their opening statements at the August hearing in this docket. Turning to reclamation costs, you've heard testimony from staff that 8 to 10,000 for similar sites in Weld County is consistent with the historical experience of the orphan well program. You've also heard testimony from KPK witnesses that based on a further examination of those 16 Frederick and Dacono wells, that approximately $22,000 per acre is appropriate, and this compares favorably to the $18,000 per acre figure approved by this commission for Wep King Fullerton just a week or so ago, as documented in staff exhibits 7 and 8. The RLG parties counter with significantly higher totals based on high side assumptions and unit rates and large volumes of topsoil that are not typically required for agricultural locations. And they assert this even while they discuss their planned surface development that would render the financial assurance unnecessary or the reclamation if performed a waste of resources. We urge you to accept the revised estimates prepared in KPK Exhibit VV, not just for Frederick and Dacono wells, as a reasonable estimate that is supported by substantial evidence. And we further advocate that you adopt that for all KPK wells and locations subject to single well financial assurance for purposes of your decision at the conclusion of the hearing. That isn't actually an overestimate for many locations, but we believe may strike the right balance among the competing party and staff positions. Regarding remediation costs, we urge you to accept KPK's estimate of $2.9 million rather than staff's overestimate of $23.4 million. Staff's estimate assumes major excavation remains at most sites because it does not give KPK credit for work performed to date, and at least earlier admitted that it hadn't reviewed the many Forms 27 it seems to continually reject. It also assumes openly that excavation is the way to address background metals in soil, as I believe Mr. Hines, and also smear zone detections of hydrocarbons outside the source zone, as explained by Mr. Peterson. This excavation only approach to remediation is not only wrong and out of step with best industry practices, it is actually more environmentally impactful to Colorado's environment and the citizens near these locations that your rules are intended to protect. It makes excavations larger and keeps them open longer. It drives costs and lengthens exposure to these conditions. And staff also uses unit rates not grounded in the work of Colorado operators or even orphan well program contractors, instead borrowing costs from service station tank removal contractors governed by OPS that don't try to dig up everything, another mismatch between costs and assumptions. These various shortcomings compound the difference in remediation estimates between KPK and staff due to the sensitivity of those estimates to smaller differences in key rates and assumptions, as also explained by Mr. Peterson. For all of these reasons, we believe KPK's estimate is more credible, better accounts for significant prior excavation work to remove source material, and is based on the best available site data that is in Forms 27 that have been rejected or denied in large measure for various reasons and with unfortunate frequency. We also ask you to accept from single well financial assurance the KPK locations remaining in dispute regarding KPK responsibility or other operator responsibility for a spill or release. These include the North Quebec location, the Boxer Tank Battery and Salt Kill area, the Guadagnoli consolidation line location identified earlier in this hearing, and also should include the Eugene Doversberger location that was also docketed for a responsible party determination prior to the commission's termination of the compliance plan agreement. Staff has proposed a total of $4,579,829 in financial assurance for those locations, while KPK has proposed $145,087 for those locations. We urge you to accept KPK's proposed P&A expense of $31,626 per well, a reclamation expense of $7,834 per well, based on our further evaluation of the additional Frederick and Dacono wells in KPK Exhibit VV, and our remediation expense estimate of $2.9 million less the $145,087 we've estimated for the excluded sites I just mentioned that are subject to future responsible party determinations, for a net remediation total of $2,754,913. This altogether totals $45,608,538 in single well financial assurance for KPK's wells, tanks, batteries, and off-location sites with known contamination. We urge your grant of this proposed determination as supported by a preponderance of the evidence and testimony presented. Thank you for your attention.
Thank you. We now will hear from staff's attorney, AG Boudreau.
Thank you, Mr. Chair. Thank you, commissioners. Over the course of these hearings, you've heard testimony and reviewed evidence supporting staff's position on KPK's financial assurance obligations. You've heard Mr. Cuthbertson testify that KPK's proposed P&A cost of $31,626 per well is $1,626 more than the default amount set by the definition of single well financial assurance. You heard Mr. Cuthbertson testify that KPK's proposed reclamation cost of $7,834 per well has a reasonable basis in what ECMC might expect to pay to reclaim small locations in the DJ Basin. You also heard Mr. Cuthbertson testify that if in the future, should the P&A reclamation or remediation amounts prove insufficient, the rules provide for adjustments, including annual reviews and discretionary reviews. However, these two processes, the annual review and the discretionary review, they're not possible until we get an approved initial order for KPK's financial assurance. While questioning Mr. Cuthbertson, you heard KPK's counsel opine that ECMC is inconsistent in its application of known remediation issues because other operators' demonstrated costs were approved without additional amounts. And though I could not cross-examine him on this, Mr. Cuthbertson explained that the handful of approved plans were evaluated with the result being that additional financial assurance was not warranted because the status of those remediations did not require it. You heard Environmental Manager Greg Duranlo testify that as to staff's extensive assessment of KPK's remediation costs, he explained that staff identified KPK's 146 known remediation issues. He also explained that all known remediation issues includes all remediation issues that staff knows of, regardless of whether KPK submitted an approvable Form 27. Form 27s do not define the state's potential liabilities. The facts on the ground define that. Mr. Duranlo testified that the state's estimate for all of KPK's known remediation issues is about $24.3 million. He also testified that $24.3 million is likely conservatively low, but within the realm of what ECMC might expect to pay for such remediations. Mr. Duranlo and his staff had to make some reasoned and well-founded assumptions, and you heard him describe those in great detail. As Mr. Duranlo testified, many of those assumptions were necessary because KPK's reporting is often incomplete, untimely, or sometimes non-existent. But Mr. Duranlo's calculations are as complete as can be reasonably expected. KPK's calculations are aspirational at best. For example, you heard Mr. Peterson testify that he assumed KPK could excavate 1,000 cubic yards of contaminated soil per day. But when pressed, Mr. Peterson acknowledged that number is really only theoretically possible if KPK has 1 million trucks available. Mr. Peterson also tried to distinguish between excavation rates and haul rates, but that's irrelevant. There is no purpose in excavating 1,000 cubic yards of contaminated soil if that soil is just going to sit on location until trucks are available. In KPK's own submissions in this matter, their GRIP calculations submitted in that matter, and their own Form 27s, KPK provides wildly different calculations depending on what suits their purposes at any given moment. The only consistency in their calculations is the inconsistency. You also heard KPK attempt to deflect responsibility for some of their known remediation issues. KPK's counsel stated that KPK thinks some other unnamed parties are responsible for some of their remediation sites, but he gave no specifics, and I could not cross-examine him on that. Mr. Peterson and Mr. Hines also suggested there might be some other responsible parties out there, but again, nothing specific. What we do know for sure is that KPK recently dismissed a host of responsible party actions. I asked you to take administrative notice of 5 of those. Ultimately, KPK provided no basis in the record for the commission to reassign responsibility for any of KPK's known remediations to some other unnamed party. I submit that the whole responsible party discussion is a red herring, and I respectfully request that the commission just ignore it. Ultimately, Mr. Duranlo provided the commission with a thorough and reasonable calculation for cleaning up KPK's known remediation issues. These are calculations that the commission can feel confident using, knowing that the state will not become financially responsible for KPK's spills and contaminations and reclamations and all their other obligations under the Act and the rules. What staff is asking you for today is simply what the rules require, that the commission enter an order that KPK post their required financial assurance amount in 90 days of that order, so that the commission can begin to build a financial assurance account for this operator. If you enter that order today, KPK will only be required to post 10% in the first 90 days. And going forward, staff will conduct annual reviews and may conduct discretionary reviews of the operator's financial assurance. But to do that, we need an approved financial assurance plan. Staff submits that plan should be $39,460 per well for P&A and on-location reclamation costs, plus an additional $24,344,402 for all of KPK's known remediation issues. For those numbers, you have a reasonable basis in the record. Thank you.
Thank you. All right, with the closing arguments done, we now will turn to deliberations. To start with that front, want to ask my fellow commissioners if folks are all comfortable turning to deliberations at this time. I mean, I'm going to ask that in reverse. Is anybody not ready to start talking? All right. I would like the attorneys to unvisualize themselves. Just leave it up to the commissioners to be on board. And I saw Commissioner McGowan raised her hand.
Thank you, Mr. Chair. I'm ready to deliberate, but I want to say that I think that we did not cover everything that should have been covered, but I have the information that I need to make a decision.
Okay. Who would like to initiate deliberations? Commissioner Cross.
Thank you, Mr. Chair. And I hope everyone sticks with me for a minute. I tried to write down as much of this as I could so I could put it in a well-versed and hopefully organized manner. I want to talk about this in several kind of different buckets here. The first of which is I want to talk about the inclusion of remediation. I'm aware that this is an issue that we previously decided, as we talked about at the beginning of the hearing on Tuesday, and the commission denied KPK's motion for partial summary judgment concerning this topic, but I do think it's prudent to expound on my reasoning for inclusion, given that Mr. Jacobs has continued to suggest this is contrary to our rules. The Oil and Gas Conservation Act requires every operator to provide assurance to fulfill all obligations, including covering costs to plug, reclaim, and remediate. ECMC rules allow for single well financial assurance to be done in one of 2 ways. 1, an operator's demonstrated costs, or 2, assumed reclamation and plugging and abandonment costs. For the assumed costs, the rules assume $30,000 to plug and abandon wells between 4,000 and 8,000 feet, and $100,000 to reclaim each location or facility. Although these default costs identify plugging and abandonment and reclamation, The statement of basis and purpose for the 700 series indicates that these presumptive costs are based on data demonstrating expenditures to plug, abandon, remediate, and reclaim oil and gas locations through its orphan well program. Conversely, where an operator chooses to rely on demonstrated costs, the commission intends for operators to include all relevant costs, quote, including but not limited to known remediation. The financial assurance for remediation is required in Rule 703 does not mean that remediation is not to be included in a financial assurance plan. Rather, in the financial assurance plan submitted pursuant to Rule 702, any additional remediation being provided in conjunction with a Form 27 pursuant to Rule 703 would be noted in the Form 3 application. That additional financial assurance can be required under a Form 27 in no way suggests that the financial assurance for known remediation cannot or should not be included in a financial assurance plan. When interpreting statutes and regulations, the language included must be given meaning. Here, the language provided in the statute, the regulation, and the statement of basis and purpose demonstrates that remediation is pertinent to financial assurance. Thus, it is clear that single well financial assurance is intended to include remediation costs. Under the assumed costs, remediation is included in the reclamation, while under demonstrated costs, remediation must be separately considered. This topic is also necessary to discuss because of KPK's briefing on the issue of a perceived biased application of this review, although it's unclear whether this argument is suggesting that a due process violation or simply an arbitrary and capricious application. Regardless of the form of the allegation, there's no evidence to suggest any wrongdoing has occurred. During the last hearing, we specifically addressed that many operators, including Helena Resources, upon whom KPK has based their demonstrated costs, explained that there were no known remediation issues. During the hearing the last couple days, Deputy Director Cuthbertson reiterated that demonstrated costs were not applicable to other operators where no known remediation issues applied. Furthermore, some operators with known remediation did not have additional financial assurance, not because of any bias or unique application as it pertains to KPK, but because, as Deputy Director Cuthbertson testified, the progress of those known remediation sites did not require additional financial assurance. Additionally, KPK's own briefing, consistent with staff's briefing, indicates that additional operators were have provided known remediation issues in their demonstrated costs. Indeed, the White King Fullerton Energy application that was just mentioned by Mr. Jacobs provided that known remediation and demonstrated costs subsequent to the previous hearing on KPK's financial assurance plan and the commission's instruction to staff that known remediation should be taken into account. Finally, there's no evidence as stated in staff's briefing that the commission intended to review of known remediation with respect to demonstrated costs only apply to option 4 plans. Rather than instruction to staff was to consider known remediation costs for all considerations of demonstrated costs. The reference to option 6 plans in the briefing by KPK is irrelevant, as that option is a blanket bond that only applies single well financial assurance and thus applicable demonstrated costs if low producing wells comprise more than 25% of that operator's wells. Thus, there is no evidence of any unique, biased, or arbitrary or capricious application of the commission's instruction to staff to review known remediation as part of demonstrated costs, and certainly no due process violation. The second issue I want to talk about is a couple procedural issues. The first of which is the demonstration of financial capability. I want to address this issue realizing that I may be alone in my views amongst commissioners on this issue. First, I recognize that Rule 701B permits an operator to request a hearing to approve the type of financial assurance to be provided, if not a cash or surety bond. And I understand that a future hearing on form of financial assurance, including the potential use of salvage value, is intended here. But the Oil and Gas Conservation Act specifically states that alternative financial assurance can include, amongst other things, and upon commission approval, a guarantee of performance where sufficient net worth is demonstrated, a letter of credit, or a lien or security interest in real or personal property. At the outset, it is unclear whether the salvage value discussed by KPK would be considered a lien, which is a potential form of financial assurance. Regardless, and without making any decision on whether salvage value is appropriate or accurate, I have serious concerns with the use of using the value of equipment given depreciation, devaluing from oversupply of equipment, broad-based estimates of equipment rather than looking at it piece by piece and knowing whether other liens or security are first in line. During the last hearing, Jeffrey Kaufman explained that their financial situation was not different than described in the June 2022 hearing report. In that report, it was noted that KPK was operating with a significant and growing working capital deficit and equity deficit. The report's author described the imposition of a penalty of $1.2 million as an economic hardship that would make the company insolvent and force it into bankruptcy. Similarly, in an appeal of the commission's prior decision on the CPA, KPK stated that it did not have the financial capability to fund a $600,000 collateral. Despite the ability to request a hearing to approve a non-preferred form of financial assurance, Rule 702 specifies that each financial assurance plan will demonstrate how the operator is financially capable of fulfilling its obligations under the Act and the Commission's rules. In this Commissioner's opinion, I believe the wording of this regulation specifically requires that the financial capability be proven during the financial assurance plan, what we're hearing now. Therefore, I have concerns about not including testimony and evidence on KPK's ability to meet its financial assurance obligations at the time of this hearing. Again, I don't want to make any conclusions on financial capability, nor can I, given the lack of evidence provided on this issue to date. But I do want to express my concern about approving amount of financial assurance rather than approving an actual financial assurance plan, of which establishing financial capability is an integral component. Next, I want to briefly bring up the asset retirement plan. Under Rule 702D4, our rules specifically set forth a list of information that must be submitted with an option 4 plan, including production data, well status and designation data, well plugging data, an inactive well list, and an asset retirement plan. Here, this issue was raised several times, and a lot of this information was provided, but we just saw the asset retirement plan. And I know Mr. Jacobs doesn't want us to go into confidential information, and so I'm not going to discuss the details of the asset retirement plan that was submitted to us. But it is worth noting that nothing in the asset retirement plan specifically talks about retiring assets. We considered this exact thing during the Evergreen financial assurance hearing that we previously had a few weeks ago, and I had the same concerns at that time. I understand the idea that wells can be worked over, that production can be increased, that there's still value, but that is not what an asset retirement plan is. There needs to be some kind of plan put forward by an operator to say, at some point in time, these wells will need to be plugged and abandoned. Whether that's once it hits a certain production amount, I don't know what the case is, and we've seen varying things talking about what can be a trigger to move it from a low producing into the plug-in and abandoned list, into an inactive list. We're just not seeing this here. And so I also have serious concerns procedurally with the fact that the asset retirement plan is not at all an asset retirement plan. Next, I want to go into the demonstrated costs, kind of the crux of what our hearing was actually about for the last few days. First, I want to talk about plugging costs. I'll spend limited time on the demonstrated cost to plug in abandoned wells. I do want to note that I have some concerns about the plugging estimates, given concerns about the age of wells, the different locations of the wells. But ultimately, given that the demonstrated cost proposed by KPK to plug and abandon the wells is actually higher than the presumptive costs that come within our rules and our regulations, I'm willing to accept the demonstrated costs, although I will note at this point in time, I'm not 100% sure again what those amounts are. Previously, I understood those amounts to be $31,000 and change, but then Exhibit VV from KPK now says it's $35,000 and change, and then Mr. Jacobs again said during his closing it was $31,000 and change again. So I'm not 100% sure on that, but regardless, the fact that the amounts are greater than the $30,000 assumed cost in our regulations, I'm willing to accept that higher amount. Going into reclamation, I'll start off noting that the burden in this hearing is on KPK to prove its demonstrated costs to support its proposed financial assurance plan, and I do not believe KPK has met this burden. My first concern is that KPK initially submitted estimates that, one, utilize KPK subsidiaries rather than third-party numbers with ECMC, with which ECMC would have to utilize in an orphan well situation. And two, they did not use historical information that was available. Notably, actual 2020 AFEs that KPK noted were simply too old to be reliable. In looking at KPK's Form 3 supplementation, I still do not believe KPK has met its burden to demonstrate reclamation costs for the following reasons. First, when presented with Exhibit C in August, I did not believe that the use of 18 exemplar wells adequately evaluated KPK's asset portfolio. Specifically, I did not believe that the handpicked wells adequately characterized all wells. I would note that none of the exemplar wells were near buildings, schools, roads, etc., which is notable considering the oft-discussed proximity to developments, parks, neighborhood schools that we've been getting in this hearing and others. By failing to look at these disparate sites, it is difficult to assess whether access to these sites that are located near these other schools and developments would be hindered, or other factors would affect the cost to reclaim or be material different. I would note that I still do not believe that the 18 wells adequately depicts KPK's portfolio, but the testimony today has also raised additional questions in that regard. Second, Dr. Allward raised concerns about the size of the exemplar sites and concerns about the access to topsoil, which would raise the cost of reclamation. Other concerns related to the issues such as stormwater protections. And I will say, Mr. Mailer rebutted some of the points made by Dr. Allward, explaining that some of the access roads and batteries are shared and development can be planned, it can be and is planned in certain areas. Similarly, Mr. Peterson expounded on the explanation that some sites are shared and have proposed development. While I can accept Mr. Mailer's and Mr. Peterson's explanation on some of the issues raised, it still remains that many of the concerns are not addressed. Specifically, even if KPK can point to some sites that are shared, it's not clear how many are shared on a portfolio basis. Similarly, Mr. Peterson's explanation that some reclamation costs should be included in demonstrated costs, such as the seeding, no seeding on 13 of the 16 new exemplary sites, as an assumption of what may happen, is inappropriate. Proposed development is not guaranteed development. Relying on a developer taking over and not adhering to ECMC regulations is not appropriate when demonstrating costs. Similarly, stating that most or many landowners will only want decompaction of soil and not full reclamation is again not appropriate. Again, this is contrary to rules, but even if assuming that this is an assumption, and as Mr. Peterson said, you have to take in some assumptions that are conservative, some that are more liberal, KPK was unable to explain how broadly this assumption would apply on a portfolio basis. Under the percentage of new examples, the 16 brought up in the last day, 882 wells would not require any seeding under KPK's proposal. The commission has no way of understanding if that 882 is a reasonable assumption or not, but an assumption that more than 80% of wells will not comply with ECMC regulations seems inappropriate at best. Finally, Mr. Peterson's testimony that shared roads and/or batteries that were previously abandoned by the other party did not result in a shared cost by that abandoning party does not mean that those costs should not be taken into account. It is not appropriate not to include some costs for those shared locations in demonstrated costs, because similar actions by other parties to do so would leave ground disturbed without any financial assurance being provided. Rather, operators would be rushing to get out first on their shared sites. In response to some of the testimony today, I want to be clear that I do not believe that all 1,086 wells subject to financial assurance in Colorado should have an individual estimate on plugging in abandonment and reclamation costs. We have relied on recent costs in other circumstances, and I believe it is appropriate here. However, here we face a conundrum that has actually been based on what's been presented. We cannot rely on KPK's initial Form 3, which relied on internal costs. While staff recommended approval of P&A and reclamation costs previously, I was uncertain about some of those reclamation costs being sufficiently demonstrative of the entire portfolio, and I was eager to hear testimony from the relevant local governments and rebuttal on that issue during the last few days. Unfortunately, my uncertainty only grew with this testimony. Perhaps most notably, KPK has now proposed demonstrative costs that differ from the prior demonstrative costs. Mr. Peterson rebutted that the costs were similar enough, but that is simply not the case. For example, one proposal included seeding, the other no seeding on more than 80% of sites. Revised numbers included stormwater assumptive costs, but failed to actually apply those costs. Different equipment was needed in each demonstration. The cost of the equipment was different in each demonstration. These vastly different evidence simply fails to provide any faith in the demonstrated cost or the underlying methodology provided by KPK And again, this is where I want to harken back to the plug-in and abandonment. Even the amounts of plug-in and abandonment between what was provided in the initial Exhibit C and previously deemed reasonable by staff is different than what was provided in the Exhibit VV discussed today by KPK. I will admit that I do not necessarily believe that the reclamation numbers provided by the relevant local governments are completely accurate. As noted above, KPK was able to explain some of the discrepancies identified by Frederick and Tacona. And additionally, witnesses and counsel for the relevant local governments admitted that they do not have all the information that is available to KPK. While I'm not sure that I have a clear understanding of what appropriate demonstrated cost for reclamation should be here, I can say that I do not believe KPK has met its burden to prove these costs. With respect to that, I'd definitely be interested to hear what other commissioners think, but perhaps it's best to use staff's estimate of approximately $45,000 per acre as a middle ground. But at the same time, I don't know if that's appropriate, and I think that that's should be deliberated upon. And finally, I want to go into remediation. At the outset, I want to note that known remediation should include the sites that are covered by Form 19s and not just Form 27s. The suggestion that the rules only require financial assurance where Form 27s has been approved is baseless. If you look at Rule 703B, it specifically states that if existing financial assurance is not adequate to address remediation, additional financial assurance may be required through the evaluation of the Form 27. In no way does this suggest that known remediation sites that do not currently have a Form 27 should not be considered as part of the Form 3 financial assurance approval process. So right away, we already have a problem with KPK's demonstrated cost that they're only looking at just over 100 sites. I believe it was 109 versus 146 sites being evaluated by staff. And I just want to go into a few broad-based things before going into some of the actual assumptions and some of what was presented on both sides. First of all, I had some serious concerns with just the $2.9 million number for 109 potential sites that KPK provided. To provide a little bit about that, they testified that spending around $400,000 per month was appropriate. There are 72 new spills since that time. These are numbers that don't really make sense based on just doing the sniff test. I think a good way to look at it is when you look at the CPA that we've previously addressed, the CPA covered 23 sites, not 109, not 146, but 23 sites. And in just over a year, between November 2021 and January 2023, when we had the hearing on the CPA, KPK in its briefing specified that they had spent $7.2 million on those 23 sites. And none of those sites were completely finished with remediation. So the idea that 109 or 146 sites can be covered by $2.9 million of remediation and known remediation costs just simply is baffling to me. And so I kind of want to talk more broad-based about some of the assumptions that were discussed back and forth. I'll be honest, I don't know that staff's number is 100% accurate, just as I don't know if the reclamation numbers are 100% accurate. I do think that there is some validity to some of the rebuttal testimony provided by KPK, that the amounts, especially with the amount of excavation, especially since that's by far the biggest amount, may be overly excessive. But at the same time, I think that the testimony provided by Mr. Duranlo is, to me, it was far more believable than the testimony provided by Mr. Peterson. It was not numbers pulled out of a hat. It was not numbers saying, oh, this is what we've seen in other work done. It was Mr. Duranlo saying, we're basing these numbers off of reasonable assumptions that are published, and it makes sense to me. There was challenges to the assumptions, and Mr. Duranlo was able to come back and say, you're looking at just the amount of the driver there, when we're actually taking into account the amount of renting the equipment, the driver, the work done, the gas that's going to be done on it, and everything else. And so I think when you take those into account, those numbers are much more believable, especially when on the other side you have $2.9 million, which, as I said before, doesn't at all pass the sniff test. Some of the other things that stuck out to me with respect to the remediation numbers was some of the descriptions of the in situ remediation to be done. One of the things that stuck out to me is, I believe Mr. Duranlo said that there was 9 different sites that KPK currently has in situ remediation proposed, yet in their demonstrated costs, they're only doing it on 2 of them. Now, to me, it's baffling that they're only saying 2 when they actually have forms filed and are requesting to do in situ remediation on more sites than that. And that kind of inconsistency makes it completely baseless to try and believe that KPK has met their burden to prove those costs. Just the final couple of points that I want to make on remediation, and especially when we looked at some of the rebuttal testimony today, 2 of the sites that really stuck out to me, one was the Greeley National Bank site that was discussed. And when you look at the Greeley National Bank, and I believe it was also the Grant Tank Battery, and both those sites, KPK's demonstrated costs say that all that is left to do is some testing, some soil samples, and some lab work. Yet they currently have forms that are submitted saying additional work needs to be done on these sites. In fact, as Mr. Duranlo testified, there are still hydrocarbons at the Greeley National Bank site. And similarly at the Grant Tank Battery, they had to do an emergency backfill. And then they still have and have had for the last year forms submitted saying that they want to do in situ remediation. But now we're getting testimony that says, we don't want to do in situ remediation. All you really have to worry about is the $16,000 of testing left to be done. Those numbers just don't make any sense to me. In no way, shape, or form do I think they've met their burden. And I'll definitely be interested to hear my fellow commissioners, their thoughts on kind of the way to move forward, because as I said, I'm fine accepting the over $30,000 in plug-in and abandonment costs. I'm kind of at a loss for the reclamation. I'm not sure that anybody has really demonstrated those costs. I know KPK has not. And to me, with remediation, I'm in agreement. Maybe it's not $29 million, but at the same time, I find that number a lot more believable than the $2.9 million that's been provided by KPK. Thank you.
Thank you, Commissioner Cross. Very extensive deliberative thoughts there. Commissioner Messner.
Thank you, Mr. Chair. Thank you, Commissioner Cross, for your thoughts there. I think a lot of the details that you brought up around specific testimony associated with this hearing, is also things that I had in my notes and that I was going to go over. And so I'll try to not repeat a lot of what you said, but acknowledge that, significant portions of your testimony, specifically around, or of your thoughts, at least, specifically around some of the testimony that was provided, I would also agree with. But I believe that, per Colorado Revised Statute and our rules regarding financial assurance, that this commission shall require every operator to provide assurance that it is financially capable of fulfilling every obligation imposed by the Act. I think we do this through the proper implementation of our financial assurance rules. And as per 702, this operator is an option 4 operator. Option 4 plans have a clear set of criteria set forth in the rules that an operator needs to submit as part of their financial assurance plan application. As is standard in the rules, option 4 operators will provide single well financial assurance for all of its wells to be paid over a 10-year period at 10% of the total amount of single well financial assurance annually. Operators have the ability to be reimbursed from that sinking fund for plugging and abandonment activities once the full financial assurance amount has been met. Operators also have the ability to request at hearing before the commission a timeline for payment that is different than the default timing in the rules, based on an operator demonstrating an anticipated life of the field. This operator did not request this. Operators also have the ability to provide information to the commission that shows demonstrated costs associated with plugging, abandonment, reclamation, and remediation of all the operators' wells. In utilizing this option, operators must include in their proposal all relevant costs and information in their single well financial assurance proposal, including but not limited to known remediation issues, areas of initial and total disturbance for the oil and gas location and any associated offsite facilities, number of wells at the oil and gas location, whether the oil and gas location is cut and fill slopes, and if so, the slope ratio of both the cut slope and the fill slope, whether the oil and gas location has sandy soils, whether any salt kills have occurred at the oil and gas location, whether the oil and gas location is in a high priority habitat, and whether topsoil has been salvaged at the oil and gas location. This is not optional, but it is explicit in its intent. In addition, the commission also expects operators will support their demonstrated costs with, for example, 3 years of invoices from past plugging, abandonment, or reclamation operations, where possible, or a third-party estimate of plugging, abandonment, and reclamation costs. It is clear both in the rules and in the statement of basis and purpose that the level of detail required in the support is substantial, not cursory, and requires an in-depth analysis and quantification in order to justify proposed demonstrated costs. It is also clear that these costs must assume not that the operator is able to do this, but rather what it would take for ECMC or a contractor of ECMC to complete the plugging, abandonment, reclamation, and remediation should the operator fail to do so at some point in the future. In lieu of providing the necessary information for determination of demonstrated costs, the commission will utilize its definition of single well financial assurance in determining the necessary financial assurance amounts per well and per location. The operator is required to provide the necessary information as required in the rules, the statement of basis and purpose, and the act to allow staff and this commission to make a determination of demonstrated cost. In this commissioner's opinion, the information provided by the operator and the review by staff of the plan failed to meet the necessary burden of proof to determine demonstrated costs associated with this financial assurance plan for a number of reasons. Number one, while in this commissioner's opinion, it may not be a requirement for the operator to necessarily provide a site-by-site analysis, though the rules could certainly be read to, in fact, require that, I found the number of wells and locations provided in the exemplary subset of wells to be grossly inadequate and not a statistically valid sample size of wells to determining all relevant costs and information necessary in their demonstrated costs for single well financial assurance proposal. It is my expectation that an analysis of a much broader array of sites is both reasonable and necessary for the applicant to be able to meet their burden in determining all relevant costs and information necessary in their single well financial assurance proposal. In fact, this operator chose to utilize demonstrated costs provided by another operator in lieu of actually doing the necessary in-depth analysis of costs on their own, which is both lazy and inappropriate. Staff also indicated that they believe it could be a reasonable number based on evidence from the Orphan Well program, but staff also did not provide any evidence to support this statement that the proposed demonstrated costs are reasonable. In fact, presentations to this commission by the Orphan Well program during the financial assurance rulemaking clearly indicate significantly higher anticipated costs associated with plugging, abandonment, and reclamation than what the operator has proposed in this plan, as did the numbers associated with remediation and reclamation analysis provided by the experts in the environmental unit as part of this proceeding. Number two, in utilizing demonstrated costs in their proposal, the operator must include relevant costs and information with known remediation issues. The applicant provided insufficient information on known remediation issues, which staff clearly documented, and costs associated with known remediation issues were much more realistically provided by staff's analysis than by the operators. This is especially egregious in the fact that there are well over 100 known remediation issues with clear possible documentation associated with them that has both been used in previous hearings on the record and testified by the applicant before not only this commission, but in a judicial review. And yet the applicant chose to not include this information or costs in their application as required. Costs associated with remediation have been testified by this operator in other proceedings before this commission, and in judicial review that conflict with the numbers that were presented by this operator in this proceeding. This information is important in determining demonstrated single well financial assurance costs, as well as determining whether the operator has the financial ability to meet all of its obligations under the Act. Staff's supplemental review of reclamation's costs was thorough and appears reasonable, but this is not what the operator is proposing. So I will make my determination on whether or not the operator has provided adequate documentation to determine the remediation portion of demonstrated costs. And I found that they have not met this burden of proof. Number 3, the applicant must also include relevant costs and information associated with reclamation of areas of initial and total disturbance for the oil and gas location and any associated offsite facilities. Associated offsite facilities necessarily include flow lines and access roads. By choosing to not include this information, or if included in a very limited fashion after staff had already made their determination on reclamation costs, even in the exemplary number of wells and locations, it is reasonable to assume that the number of acres that have been presented as disturbed is grossly underestimated and would be necessary to assume that any costs associated with reclamation in their proposal are inaccurate. Again, I find it problematic that staff did not require in its review this information before making a determination on demonstrated costs. In fact, staff has indicated in their remediation analysis an offsite reclamation amount of approximately $45,000 per acre, or average to $16,779 per site. The acceptance of just over $7,000 per site reclamation costs by staff is not supported by evidence in the record, nor has the operator provided adequate information in the record, nor any analysis short of 18 exemplary wells that do not go near far enough to develop a statistically valid sample size, and even then is missing vital information regarding associated facilities, flow lines, access roads, topsoil, cut and fill slopes, and sandy soils, just to name a few. Regarding information associated with cut and fill slopes and sandy soils, this information again must be provided, and in these instances require more than an exemplary set of wells to make this determination, but rather a more site-specific or region-specific analysis on any locations that have these characteristics. I think the concept of utilizing the NRCS database in order to help determine this is a great example of how this could have been done. While a last-minute submission by the operator dated October 3rd attempted to provide information associated with these topics, the data provided lacked any site-specific information nor the level of detail necessary to determine any increase in associated costs related to addressing reclamation of cut and fill slopes nor sandy soils. The broad generalizations regarding reclamation in sandy soils and cut and fill slopes provided by KPK witness Mr. Peterson versus site-specific information necessary to determine proposed reclamation costs is exemplary of the lack of detail provided by this operator. Mr. Allward, who is a witness for the town of Frederick, provided a clear example of the level of detail necessary to meet submittal requirements necessary to meet the obligation of the rules. It is not possible for this commissioner, let alone staff in their review, to determine what site-specific costs may be associated with reclamation of cut and slope or sandy soils based on the information provided. I also note that this attempt at providing information by the operator on these topics arrived after a determination from staff on whether or not to accept the operator's demonstrated costs, which in my opinion, again, renders staff determination on this issue null and void. Number 4, again, in utilizing demonstrated costs in their proposal, the operator must include relevant costs and information whether the topsoil has been salvaged at the oil and gas location. This requirement, again, requires more site-specific information than the exemplary subset of wells could provide. But even in the subset of exemplary wells, no specificity regarding whether or not topsoil had been salvaged and was available for reclamation. Topsoil is a significant expense, as indicated even by this operator, that must be calculated as part of anticipated reclamation expenses and not by including this information as part of not even the exemplary subset of wells. I think it is reasonable and necessary to determine that the reclamation figures provided by the operator are inaccurate. Testimony provided by KPK witness, Mr. Peterson, clearly shows that KPK did not think it is necessary to utilize topsoil in a number of instances, which does not pass the red face test nor industry standard operating procedures regarding reclamation by ECMC reclamation professionals as shown in, nor by ECMC reclamation professionals as shown in presentations to this commission by ECMC reclamation staff, as well as the Orphan Well program. I'm not sure how staff in its recommendation could make an accurate determination of whether or not this operator provided accurate demonstrated costs without this essential information provided, and I'm sure that I can't make that determination. Number 5, the commission also expects operators will support their demonstrated costs with, for example, 3 years of invoices from past plugging, abandonment, or reclamation operations where possible, or a third-party estimate of plugging, abandonment, and reclamation costs. While this operator has provided spreadsheets that indicate what the operator anticipate will be costs associated with these activities, I find extremely limited evidence provided from the previous invoices associated with the activities that this supports the numbers in the spreadsheet, nor a third-party estimate. In addition, without full consideration of the total amount of disturbance, including associated facilities, flow lines, and access roads, the numbers provided by the operator are most likely grossly underestimated. In addition to the inconsistent evidence and testimony provided by the operator, including providing rebuttal evidence with site-specific costs totaling over $23,000, in addition to a per acre cost that would typically range in the $10,000 to $20,000 range. That inconsistency, and misapplication of these numbers made me come to the conclusion that this just didn't meet the burden of proof. Without accurate or proven evidence that supports these claims, this commissioner has no reasonable way to determine the accuracy of the numbers provided for demonstrated costs, nor do I see how staff could have made this determination. I actually think staff did a better job of providing relative evidence in support of a higher reclamation cost when they were reviewing their remediation costs. Finally, 6, I find more relevant and reasonable the evidence provided by the town of Frederick in regards to the actual site-by-site analysis regarding plugging, abandonment, and reclamation that is in line with the expectations of the information required by the rules. That level of detail is specifically what the rules are asking for. In light of these findings, I do not believe staff nor the operator has met its burden of proof to show demonstrated costs for this financial assurance plan. Thus, I believe the commission is required by the Act and our rules to utilize the default per well and per location amounts reflected in the definition of single well financial assurance for an option 4 operator in determining the necessary financial assurance amounts. In future reviews of this operator's financial assurance plan, if it is determined that even after applying the default amounts associated with the definition of single well financial assurance, that additional remediation assurance must be submitted, the reclamation analysis that staff provided can be utilized then. As such, the default amounts in the single well financial assurance definition are as follows. For Rule 702, the amount is $133,036,400. For Rule 703, it's $30,000. For Rule 704, it's $100,000, for a total of $133,166,000. The submittal and review processes for financial assurance plans are clearly laid out in statute, the rules, and in the statement of basis and purpose. As was stated in testimony and statements during this hearing, how this commission applies the financial assurance rules it promulgated over months of rulemaking determines whether or not the rules are successful in ensuring that every operator in the state of Colorado has the financial ability to meet all of the obligations under the Act. In order for us to make a statement that we have some of the strongest financial assurance regulations in the country, it is our responsibility to apply the rules in the way that they were intended to be applied. While it is once again clear to me that this operator does not think that the rules apply to them, I believe based on the record, we are obligated to apply the default financial assurance amounts to this operator's financial assurance plan as clearly laid out in the rules, with a total amount of $133,166,000. And by doing this, we have met that responsibility that was laid out in the rules as reasonable and necessary to protect the citizens of the state of Colorado and ensure that we have the financial assurance that the operator is able to meet all of their obligations under the Act in order to operate in this state. Thank you for listening to my long-winded thoughts.
Thank you for those deliberative thoughts as well. Commissioner McGowan?
Thank you, Mr. Chair. I don't have much to add from my fellow commissioners. I'm not sure the operator submitted an application in the spirit in which we created the financial assurance rules and requirements for the plan. And important information was missing from the original application, which made it necessary for the commission to have to ask others to provide information that is missing from the operator, which means that we're all having to make assumptions about costs, about reclamation, about remediation, because of missing information or inadequate information that was in the operator's application. I feel that the application and even the supplemental information was lacking important components that we require as part of a financial assurance plan. In particular, the retirement asset plan doesn't meet the intent or spirit of what the commission was looking for option 3 and option 4 operators, in ensuring that there was adequate financial resources available to assure that when the wells get to the end of their life, there is a plan in place for them that does not leave the state holding the bag for those assets. I think the application ignores the various states of required maintenance for certain sites that they have. The fact that there's such a big difference between the operator and our staff regarding those sites and what would be required to get them to a final reclamation point, I think is the reason we have such a huge disparity in numbers and what we think is necessary for financial assurance. I'm not sure I'm in the same place as Commissioner Mesner about what amount is necessary, but given that I feel that we don't have the most accurate information or the best information we could from the operator, we're going to have to make some assumptions as a commission to ensure that we have adequate financial assurance in place for this operator. And I think we're going to have to make that decision as best that we can based on the many days of testimony from various experts, including those from KPK, as to what that appropriate amount is going to be.
Others with deliberative thoughts? Commissioner Ackerman?
Thank you, Mr. Chair. My comments with regard to the specifics of the documentation and testimony that have been provided are similar to others. So I'll just add a few thoughts from a bit of a broader perspective. And, you know, I've pondered throughout the course of this hearing, as I do most financial assurance hearings, on how important this concept is. It's such an important part of what we do. It truly is a key component of the state and really the nation's sustained environmental well-being with regard to mineral extraction. And in my opinion, we're getting it right now, regardless of what's been done in the past. And I'm grateful that we are. I think that our citizenry benefits greatly from proper financial assurance. And, This is especially true with the potential long-reaching consequences that are possible without proper remediation of environmental damage that's caused in the course of oil and gas extraction. Financial assurance protects the people by placing the cleanup responsibility, all of it, upon those who financially gain from extraction. And the nation's largest minerals holder, the Bureau of Land Management, is currently focusing on the importance of proper financial assurance for these exact reasons. I agree with Commissioner Cross's reading that known outstanding remediation issues can and should be included in a financial assurance plan to properly protect the citizens of the state, as was further articulated by Commissioner Messner. KPK's claimed staff's detailed remediation evaluation contains gross overestimates, although those estimates are based on Division of Oil and Public Safety's reasonable cost estimates. Staff and local government testified their belief that their detailed evaluation is also on the conservative side. The local government's cases in chief offered specific analysis and demonstrated exclusions of entire reclamation components and responsibilities pertaining to KPK's handpicked exemplar wells, calling KPK's totals grossly underestimated. So which is it, grossly overestimated or grossly underestimated? Human nature might lead us to believe that the answer lies somewhere in between. But in this case, due to the testimony given today, as well as the historic approach of this operator, I do not agree. The testimony of these hearings, as well as my experience in consulting on environmental issues, including remediation, makes it clear to me that $2.9 million is indeed a gross underestimate for remediation of KPK's known issues. A statement by staff that rang true to me was that staff's analysis does not seek to minimize the environmental significance of remediation issues, and that the rates staff used are consistent with ground truth data. What's being sought, at least in the application, in cost-specific justification for the financial assurance plan in question, in total is already significantly less than the standard costs set forth in regulation. I would agree that KPK's estimates were less thorough, which really in and of itself does not make them invalid. However, while KPK's testimony discussed disagreements over protocols, processes, and other critiques of staff's approach, really, to me, no significant evidence was presented that would lead me to conclude KPK's estimates are more accurate than the detailed analysis conducted by staff, as augmented by the testimony of relevant local governments. Conversely, the testimony has led me to believe that KPK's estimates were significantly motivated by cost savings. The preponderance of the evidence would indicate to me that staff's assessment represents the best plausible estimate of real-world conditions and requirements for remediation, at least over that given by KPK. Based on the evidence provided and the intrinsic facts that staff used, official reasonable cost estimates used ground truth data and does not have an incentive to minimize the significance of the issues. And I think Commissioner Cross put it well. KPK's argument simply doesn't pass the smell test. As testified, the remediation amount that KPK proposes would only cover 6 months of remediation work based on rates associated with KPK's previous testimony and reported remediation costs expended, which, as a reminder to us, so far has only resulted in one completed substantive remediation project. So taking into account the amount of 7.2 million KPK purports it spent on remediation as previously testified, and the argument that the remaining amount necessary to remediate is 2.9 million, just rough calculations would denote that 71% of KPK's currently obligated remediation has been completed. And that's just not true. We also heard that there have been 72 new spills. So based on the gross financial facts, to me, it stands to reason that the amount of 2.9 million proposed to remediate 142 sites is indeed a gross underestimate, as KPK's numbers simply don't hold up, making pretty specious the argument that staff is grossly overestimating costs. KPK argues significant remediation cost estimates have not been conducted by ECMC staff in financial assurance plans of other operators, as they have done in the course of these hearings. And as such, the implication is that KPK is being treated differently than other operators. It's indisputable that the magnitude and number of KPK's unaddressed or underaddressed remediation issues is significantly above the norm, so much so that the commission attempted, although ultimately unsuccessfully, to establish an unprecedented, detailed, operator-specific plan and agreement to assess and address their remediation issues, which again ultimately led to the final closing of exactly one substantive remediated site closure. As testified, staff has considered the need for remediation when considering other financial assurance plans. Nonetheless, it stands to reason that whether or not significant remediation costs were included in other financial assurance plans, it's clear to me that they should be included in this one. In my opinion, the operator's history has demonstrated significant and clear historic difficulty in maintaining sites and preventing and/or abating remediation costs, as well as a plethora of known issues and constant complaints from impacted parties, similar to the words we heard from the local governments who testified during these hearings. So to me, history matters here. KPK's historic inability to assess, reclaim, and remediate sites does not elicit strong confidence in their expertise in these matters. This history, in my opinion, necessitates a conservative rather than a permissive approach to financial assurance, including but not limited to clear justification for the significant work done by staff to understand KPK's outstanding remediation issue obligations, which was questioned by KPK during this hearing. In the end, I also believe that KPK has not met the burden specific to the remediation amount proposed by staff. After 3 days of hearings on this matter, there is simply no compelling reason to deviate anywhere below staff's recommendation. And certainly a cogent argument can be made that this operator is a high-risk operator with regard to remediation and should be held to the highest standards of remediation costs. So to me, the primary avenues that lie before us are KPK's proposed plan, staff's recommendation of acceptance of KPK's proposed figures, but with the addition of $24,344,402 for known remediation issues, the local government's figures, which included additional costs for well sites within the jurisdiction of Frederick and Dacono, or as articulated by Commissioner Messner, the standard amounts for an option 4 plan. I look forward to discussing these options and deliberating on the path forward, but I want to make clear in going in, if I haven't yet, that I think the plan proposed by KPK has grossly underestimated the potential costs and obligations of this operator. Thanks, Mr. Chair.
Thanks for those deliberative thoughts. I am in pretty much alignment with all of my commissioners in terms of where we ought to go with this. Let me make a couple of comments about the burden. So the application was filed by staff. So staff has the burden of proof. And depending upon the 5 of us and where we end up, staff may or may not have met the burden with regard to plugging and abandoning and the reclamation. I've heard from Commissioner Messner that you would go with default. I've heard from Commissioner Cross that you might go with either the 31 or the 35. I think we need to make a determination on that. So I'm trying to lay this out so that we can make proper determinations. So we need to make that determination. And then with regard to remediation, staff has proposed an amount and KPK has proposed an amount. I think I'm hearing that there's consensus that we would go with staff's amount. We need to make a determination around whether there's any outlet around the responsible party issue. I'm not inclined to go there. That's just me talking. And then I want the record to reflect that at least for this commissioner, these deliberative thoughts and the work we've done on this are solely focused on the financial assurance application and the hearing we've had, and are not influenced whatsoever with previous enforcement matters or other litigation that maybe exists between ECMC and this applicant. This is its own ball of wax and its own information. So I'm not nearly as articulate as all my fellow commissioners, but I think those are the decision points we need to work through. And I would look to Commissioner Messner, who looks like he would like to provide some perspective.
Thank you, Mr. Chair. I would agree with you that those are the points of determination. So in my reading of the rules, and I think the intent of the rules when we wrote them, that if the burden's not met for demonstrated costs, then we go to the default. I don't know, and I'd be curious thoughts or legal opinions on this. I don't know if there's room in the rules for us determining some alternative financial assurance amount. My reading of the rules is that the applicant has the ability to be able to submit a plan that includes evidence with demonstrated costs. I would agree to you that the applicant in this particular situation is staff. Staff has a burden of proof to be able to show evidence in support of their decision. The applicant ultimately still has some burden because they're providing the initial evidence associated with their plan. I'm saying that neither of them have met their burden of proof. And so my reading of the rules is we immediately then go to the default because they have not shown demonstrated costs. So that's one point. The other point in my reading of the rules is that if we go to demonstrated costs, then remediation amounts do not get applied until the first annual review.
So I think I'm in agreement with you, Commissioner Messner, that if there's consensus that the burden wasn't met, that we go to default and it's just 130 times the number of wells. Commissioner McGowan?
I just want to clarify, I think something that Commissioner Messner said, which is additional remediation costs don't get considered until the annual. There are already remediation costs baked into the default amount.
Right.
Okay.
That's my perspective and understanding, and I think that's what we were doing when we did the default. Commissioner Cross or Ackerman, any additional deliberative thoughts? Commissioner Ackerman?
I don't have additional deliberative thoughts because I completely agree with Commissioner Messner's assessment here. I think with the clarification that you provided and the burden of proof, I don't believe has been substantively met in this case. I think that I don't know that I'll state so far as to go that we're required, but I don't see a clear avenue for doing something other than going to the default.
Yeah, I'm in agreement. Commissioner Cross?
Thank you, Mr. Chair. And I think I'm probably leaning the same way. I was trying to go through our rules there as you were speaking and kind of looking at commission approval, commission denial, and it talks about the commission order, and it does say in 702 E and E2 F4. It said the financial assurance an operator must provide, which may differ from the amount specified in rules 702, 703, or 704. So I think there is an outlet for it to be different. But I'll be honest, and I think going back to what you were saying, I don't think that with respect to especially with respect to reclamation, that any kind of burden of proof has been met by staff as well. But certainly nothing proposed by KPK either. And so I would have a hard time trying to come up with an amount, even with the different costs identified by Frederick and Dacono. I still, I do find some validity into some of the responses provided. And so I think there are holes that can kind of be poked into everything. And so I don't think any of the parties necessarily showed us something that I would equate to adequately demonstrate the costs necessary for, especially with respect to reclamation. And so based on that, I tend to lean towards the default amount as well, without kind of applying an arbitrary amount. And because I don't know how else we would do it without doing that.
Who would like to propose a motion? Commissioner Messner?
AAG Davenport may as well just visualize himself now because I'm going to screw this up. But I will make a motion. Well, let me ask AAG Davenport. Am I making a motion to deny the application and therefore applying the default amounts?
AAG Davenport? You're muted.
Yeah, thank you. Thanks for the question. I'm going back to what I think is staff's original application, which I believe is what the commission is essentially approving. Staff's initial application in this matter requested an order requiring KPK to implement its plan as submitted in Form 3 financial assurance plan without demonstrated costs. And the motion then would be, I think, to approve staff's initial application to approve a plan, which is option 4, single well financial assurance for every well without demonstrated costs. In other words, applying the default costs set by the definition of single well financial assurance in our rules. And I don't believe you need to go into what that definition provides. It does provide for calculation of plugging and abandonment based on well depth, and then $100,000 per location. I don't think we need to do the math here today.
Okay, I can make that motion. And the math is actually, I pulled the numbers that I made in my deliberative statements from that initial application. I won't put them in the motion, but it's a little over $133 million. And so I will make a motion to, am I approving staff's initial?
I think you could say so moved.
Just to clarify, I mean, staff, as we all know, staff changed its position. So my shorthand was to approve staff's initial request, which was to approve the Form 3 submitted by KPK, but to do it based on the default costs, not demonstrated costs.
Okay. So I move to apply the demonstrated costs, to not apply the demonstrated costs, but rather apply the default costs associated with staff's initial application to KPK.
Second.
Okay, we have a motion and a second. I would provide just a bit of further discussion on the motion before we vote. I appreciate the point you made, Commissioner Ackerman, about the importance of getting this right. I do believe we have some of the most, if not the most robust financial assurance protocols in place, and we need to make sure that we're using them in the correct manner. And I believe that is appropriate for where we are with regard to this motion that's on the table today. The second point that I wanted to make was I appreciate the hard work of staff, and in particular, a couple of the quick turns that were necessitated by this commission's actions in August. And then the third point I wanted to make is I do appreciate the relevant local governments taking the time to hire counsel and be involved in this. I think it helps us get to the right answer, and that relevant local government perspective is important because they're the boots on the ground that are dealing with some of these things as well. And so those are my further discussion points. Is there anyone else with anything further before we take a vote? All those in favor of the motion signify by saying aye.
Aye.
Any opposed? Motion carries. Thank you, everyone. It's been a long 3 days, but I think it's been a good 3 days. I think we've done good work here. With that, I'd look for a motion to adjourn.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
We are adjourned. Thank you.